Tabling of documents, dépôt de documents, the Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, pursuant to Standing Order 36.8, I have the honour to table in both official languages the government's responses to 14 petitions.
Introduction of government bills. Déclaration des ministres.
Statements by ministers.
Two delegations. The Honourable Member for Elgin, Middlesex, London.
Mr. Speaker, pursuant to Standing Order 34.1, I have the honour to present to the House in both official languages the report of the Canadian delegation of the Commonwealth Parliamentary Association respecting its participation to the bilateral visit to Mumbai, Bangalore, Trivandrum, and Kochi, India on August 31st to September 8, 2012. Mr. Speaker, also pursuant to Standing Order 34.1, I have the honour to present in the House in both official languages the report of the Canadian delegation of the Commonwealth Parliamentary Association respecting its participation in the 59th Commonwealth Parliamentary Conference held in Johannesburg, South Africa from August 28 to September 6, 2013.
Presenting reports from committees. Introduction of private members' bills. Is he? Are you doing? Yeah? Okay.
give us notice. Bruce is going to pull them out.
Oh, okay.
Just a moment.
Mr. Donnelly, seconded by Mr. Garrison, moves for leave to introduce a bill entitled An Act to Amend the Navigable Waters Protection Act, SoMass River. This motion is deemed adopted. The honourable member for New Westminster Coquitlam.
Thank you, Mr. Speaker. I rise today to introduce legislation that would extend environmental protection to the SoMass River. This legislation would restore the river to the schedule of waterways protected under the Navigable Waters Protection Act. The government's recent overhaul of this act allows for the construction of dams and bridges on most Canadian waters without having to notify the government and without needing approval from the Minister of Transport. This means that waterways like the SoMass River are now unprotected against development, leaving residing fish and their dependent ecosystems vulnerable to habitat destruction. I encourage all members of this House to support this bill. Thank you, Mr. Speaker.
Monsieur Donnelly, approuvé par Mr. Garrison.
Mr. Donnelly, seconded by Mr. Donnelly, moves that the bill be now read a first time and printed. This motion is deemed adopted.
When shall the bill be read a second time? At the next sitting of the House. Mr. Donnelly, seconded by Mr. Julian, moves for leave to introduce a bill entitled An Act to Amend the Navigable Waters Protection Act, Fish, Lake, and Other Waterways. This motion is deemed adopted. The honourable member for New Westminster Coquitlam.
Thank you, Mr. Speaker. I rise again to introduce legislation that would extend environmental protection to Fish Lake, Little Fish Lake, Big Onion Lake, Wasp Lake, Taseko River, and Beast Creek. This legislation would restore these bodies of waters to the schedule of waterways protected under the Navigable Waters Protection Act. These bodies of water would have been severely impacted by the proposed Prosperity Mine, as documented not by one but two federal review panels conducted by the Canadian Environmental Assessment Agency. In fact, the proposed mine would have turned the pristine Fish Lake into a tailings pond. By gutting environmental regulations, the Navigable Waters Protection Act, the government has including the Navigable Waters Protection Act, the government has broken trust in its ability to balance natural resource development with building healthy, sustainable communities. This bill is a small step in the right direction of restoring a more responsible and balanced approach, and I encourage all members of this House to support this bill. Thank you, Mr. Speaker.
Mr. Donnelly, seconded by Mr. Julian, moves that the bill be now read a first time and be printed. This motion is deemed adopted. Will the bill be read a second time? At the next sitting of the House. First reading of Senate public bills. Mr. Sweet, seconded by Mr. McKenzie, moves that Bill S-213, an act respecting Lincoln Alexander, be now read a first time. This motion is deemed adopted. The honourable member for Ancaster, Dundas, Flamborough, Westdale.
Mr. Speaker, I'm honoured to rise today to introduce Bill C-213, an act respecting Lincoln Alexander Day, also passed by the Senate as S-213. This bill would establish today to pay tribute to a truly great Canadian. As a friend and the Member of Parliament for a good part of what was Link's constituency when he was a member of this House, it's a great privilege for me to introduce this bill.
This motion is deemed adopted. And when shall the bill be read a second time? For the next sitting of the House. Motions, motion. Presenting petitions, présentation des pétitions. The honourable member for Beaches, East York.
Thank you, Mr. Speaker. It's my honour to present two petitions today on behalf of Canadians in and around my riding of Beaches, East York. And the first notes, excuse me, Mr. Speaker, that Canada is the only OECD country that does not have a national public transit strategy, and calls upon the Government of Canada to enact such a strategy which would provide permanent investment to support public transit. That investment would be predictable, sustainable, for the purpose of increasing access to public transit. The second petition, Mr. Speaker, takes note of the fact that Canadians face record levels of household debt, $1.65 for every dollar they take home, and calls on the Government of Canada to take significant concrete steps to make life more affordable for cash-strapped Canadians. Thank you.
Presenting petitions, the honourable member for Langley.
Thank you, Mr. Speaker. I'm honored to present a petition that represents thousands of people in British Columbia. The petition highlights that 22-year-old Cassandra Collius was killed by a drunk driver. Families for Justice are calling for changes to our laws. They say that they're asking for mandatory minimum sentencing for people who have been convicted of impaired driving causing death.
The honourable member for Winnipeg North.
Thank you, Mr. Speaker. My petition today is dealing with issues of the corneas, hearts, kidneys, lungs, and livers. Mr. Speaker, it's from the Falun Gong practitioners who are asking Parliament to condemn the Chinese Communist Party's crime of systematically murdering Falun Gong practitioners for their organs. Thank you, Mr. Speaker.
The honourable member for Gaspésie-Madeleine.
Thank you, Mr. Speaker. I have a petition signed by several hundred residents in my riding and other ridings in northern New Brunswick. We're thrilled that the minister announced $10 million to save the railway in our area, but unfortunately, she forgot that Via Rail passenger service also had to receive funding. In northern New Brunswick, we only have 3 lines. People want an answer, and we certainly hope the minister will respond.
The honourable member for Elgin Middlesex London.
Thank you, Mr. Speaker. I have a petition signed by members of the City of London about GM alfalfa.
The honourable member for Charlottetown.
Thank you, Mr. Speaker. I rise to present a petition signed by several residents of the province of Quebec with respect to the situation in Venezuela, calling on the Canadian government to take action through the Organization of American States and including economic sanctions regarding the situation in Venezuela. Thank you, Mr. Speaker.
The honourable member for Windsor West.
Thank you, Mr. Speaker. We have a petition here signed by a number of individuals across Windsor, Essex County, and also London, Ontario, requesting the Government of Canada return the rights of any healthy Canadian to give the gift of blood, bone marrow, and organs to those in need, no matter the race, religion, or sexual preference of a person. The right to give blood or donate organs is universal to any healthy man or woman. Thank you, Mr. Speaker.
Honourable member for Sudbury.
Thank you, Mr. Speaker. I'm pleased to rise today to table a new set of petitions calling on the government to reverse the cuts to Canada Post. The hundreds of signatories believe that we should be instead looking for ways to generate additional revenue, for example, by established postal banking. The petitioners want this government to make it very clear that we should not be cutting essential services that Canadians rely on. Thank you, Mr. Speaker.
The honourable member for New Westminster Coquitlam.
Thank you, Mr. Speaker. I rise to present 2 petitions. The first from petitioners across the country that say discrimination against people in same-sex relationships is unconstitutional and goes against Canada's Charter of Rights and Freedoms. And they're calling on the Government of Canada to return rights of any healthy Canadian to give blood, bone marrow, organs to those in need, and no matter the race, religion, or sexual preference of a person. That's the right of to give blood or donate is universal to any healthy man or woman. And the second, Mr. Speaker, I rise to present a petition from Canadians who want the government to take measures to stop the global practice of shark finning and to ensure the responsible conservation and management of sharks, and a call on the government to immediately ban on importation of shark fins to Canada. Thank you, Mr. Speaker.
Presenting petitions. Présentation des pétitions. Questions on the order paper. The Honourable Parliamentary Secretary of the Government House Leader.
Thank you, Mr. Speaker. Mr. Speaker, I ask that all questions be allowed to stand.
Is that agreed? Agreed and so ordered. The Chair would like to take a moment to provide some information to the House regarding the management of private members' business. Comme les députés le savent, après le complément de l'ordre de priorité, la Présidence examine les nouvelles affaires afin de signaler à la Chambre les projets de loi qui semblent, à première vue, empiéter sur la prérogative financière de la...
The Chair reviews the new items so as to alert the House to bills which at first glance appear to impinge on the financial prerogative of the Crown. This allows members the opportunity to intervene in a timely fashion to present their views about the need for those bills to be accompanied by a royal recommendation.
Order of precedence with 15 new items. I wish to inform the House that there is a bill that gives the Chair some concerns as to the spending provisions it contemplates. It is Bill C-584, an act respecting the corporate social responsibility inherent in the activities of Canadian extractive corporations in developing countries, standing in the name of the member for La Pointe de l'Île. J'encourage les honorables députés qui souhaitent.
I would encourage honourable members who would like to make arguments regarding the need for a royal recommendation to accompany this bill or any of the other bills now on the order of precedence to do so at an early opportunity.
Their attention. Orders of the day, order du jour.
Projet de loi émanant du gouvernement commune. Debate at third reading of Bill C-23, fair election.
Mr. Polliver, seconded by Mr. Duncan, Vancouver Island North, moves that Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts, be now read a third time and do pass. Debate. The Honourable Minister of State for Democratic Reform.
Thank you very much, Mr. Speaker. And here we are, rising to debate at third reading the Fair Elections Act. This has been an excellent process in considering the democracy that we have been fortunate to inherit from our ancestors in this country, to build upon its foundations and to make it even better. Today, we have before the House the Fair Elections Act, a bill widely supported by the Canadian people, based on the principle of fairness and universal suffrage. It will make it easier to vote for law-abiding Canadians and harder to break the law. It'll make it easier for law-abiding Canadians to contribute more financially to democracy, while making it harder for special interest groups to break election finance laws. It will make it more difficult to vote illegally or fraudulently, while giving new opportunities for Canadian voters to cast their ballots conveniently throughout an election campaign. The bill has been subject to a great deal of debate, a variety of opinions, and some modest amendments which built upon the foundations of the original document. So let us review now the final product that the House will consider with its vote on the bill tonight. To start with, Canadians will be required to bring ID when they cast their ballot. In the last election, it was possible for people to arrive at their voting location without a single piece of ID and cast their ballot by having someone else vouch for their identity. Identity vouching is no more. Every single Canadian voter will be required to bring ID showing who they are before they vote. Beyond that, there is going to be a safety valve in the system to help those people whose address may not appear on their identification. So, for example, in communities throughout rural Alberta, Canadians often have driver's licenses that do not contain a home address, but rather a P.O. box. That creates complications at the voting booth. In such a circumstance, or ones like it, the voter will be allowed to co-sign an oath with another voter from the same polling division who does have ID and proof of residence in hand to confirm the residency of the voter. There will be a list of oath takers, and Elections Canada will be required by law to check that list for duplicates. Duplicates would, of course, be evidence of multiple voting. If that occurs, it will automatically be sent over to the Commissioner, whose job it is to investigate breaches of the Canada Elections Act. Signing a false oath or using oaths to vote more than once could subject a voter to a $50,000 fine or up to 5 years in prison. There will also be a mandatory external audit to examine whether or not Elections Canada followed all of these procedures. That is particularly important, considering the abysmal record of the agency in managing the vouching process during the last election. The agency had roughly 50,000 irregularities linked to vouching last time, and 165,000 irregularities throughout the organization in other areas of its management on Election Day. This mandatory external audit will hold the agency accountable for this kind of mismanagement and these sorts of irregularities. That is an enormous step forward. Those protections were not placed in place in the last election, and nor was a mandatory ID requirement. The presence of ID will ensure that we know who people are before they vote, so that if they, for example, misuse, abuse, or mislead in the taking of an oath, we will be able to track them down afterwards, having actually seen their identification. Under the status quo, someone who used vouching to commit voter fraud we might never be able to track them down because they never provided ID and their identity is therefore not even registered into the system. These new safeguards will prevent against abuse, and they will embed a very simple principle into our system that if you want to vote, you must present ID. Now, I realize that this position is contentious within this House. The NDP and the Liberals believe people should be allowed to vote with no ID whatsoever, that they should be able to walk in and have someone vouch for their identity. I disagree, and so do Canadians. Before I even announced that there would be some amendments to this bill, 87% of Canadians believe that identification should be required to vote, and we agree with that 87%. In addition to requiring ID, we are eliminating a form of identification that has proven unreliable and susceptible to abuse. In the last couple of elections, the agency has allowed voters to use their voter information card as a form of ID. This card is error-ridden, it has millions of mistakes, and some voters even get more than one of them, allowing for multiple voting to occur. In the last election, there were errors with 12%, or roughly 1 in 6, of these voter information cards. Even today, the Chief Electoral Officer says that there are roughly 6% error rate within the voter information cards. 6% might not sound like a lot until you consider that there are 25 million voters in Canada, Mr. Speaker, so 6% is almost 2 million. Off the top of my head, it's almost 2 million errors in those cards. That presents an unacceptably high level of risk, and as a result, the Fair Elections Act will end the use of the voter information card as a form of ID. Furthermore, the Fair Elections Act will close financial loopholes that have allowed some powerful interests to get around the donation limits. Now, this House of Commons some years ago passed into place, with a great deal of consensus, restrictions on the amount that people can give and the sources from which those funds can come. Corporate and union money is allowed no longer. Individual donors were restricted to $1,000 a year. With inflation, that's about $1,200 now. The problem is that some have found loopholes. Liberal leadership candidates, for example, took enormous loans from powerful interests and just never repaid them. In essence, those are identical in their effect to illegal donations. For some reason, Elections Canada did not pursue an investigation into this breach of the law, and these Liberals were allowed to get away with that practice. The NDP, on the other hand, was particularly creative. They invited people to leave enormous donations in excess of the donation limit in their testaments or their wills. And the NDP received hundreds of thousands of dollars in donations bequeathed to them because the limits did not apply to dead people. So though dead people cannot vote, they can contribute under the status quo. The Fair Elections Act puts a nail in that coffin and ends the practice of dead donors. From now on, wills and testaments will be subject to the same donation limits as are applied to living Canadians. all of this is designed to end the abuse and the loopholes that have permitted big money to creep back in to our electoral system. We understand that big money can drown out the voice of everyday Canadians. And then that is why our laws attempt to restrict the flow of that money, so that parties can never take enough money from one donor to require them to be indebted to that donor with their public policy decision-making. These rules, whether to prevent voter fraud or keep out unacceptably large donations, would be useless without enforcement. And that is why the Fair Elections Act will strengthen enforcement by making the chief investigator of elections law independent. We're giving him sharper teeth, a longer reach, and a freer hand. Sharper teeth means that he'll have tougher penalties for existing offenses. A longer reach means that he'll have many new offenses to crack down on big money, voter fraud, and other forms of abuse. And a freer hand means that he will be completely independent. Right now, the Commissioner is subject to the control of the CEO. The CEO picks his staff, directs his investigations, hires him, and can fire him at any time without cause, according to the law. This is not independence. The Fair Elections Act will give the Commissioner control of his own staff and his own investigation and guarantee that he cannot be fired without cause. That is the kind of independence that the Canadian people expect from a chief investigator. And I expect that that independence will vastly improve the quality and consistency of enforcement that Canadians enjoy in their electoral system. Now, one of the best ways to ensure that people don't break the rules is to make those rules known and consistently applied. For example, if the agency were to allow a practice for many years and then change its mind suddenly, as it has been known to do, then it is hard for political actors to know which set of rules they're supposed to follow. As a result, the Fair Elections Act will require the CEO issue legal interpretations and advance rulings on request from political parties. So if a party is unclear as to how the agency will enforce a certain rule, they can send a request for an advance ruling saying, Mr. CEO, we plan to do A, B, C, and D. Is this allowed? He will then be required to respond within a confined time period, and the party will then be able to use that advance ruling to carry out its actions in compliance. The ruling will be binding on Elections Canada. In other words, the agency will not be allowed to tell a party that something is allowed and then change its mind after the fact. Furthermore, it will set a precedent so that all parties can follow the same practice as one party has been allowed to do. In other words, one set of rules for everybody. This is a massive improvement, and it represents the use of an ounce of prevention instead of a pound of punishment. Mr. Speaker, the democracy we enjoy should never be taken for granted. All of us have been given this sacred opportunity to choose who shall govern our country. Unfortunately, many Canadians choose not to exercise that right. One of the biggest obstacles, according to Elections Canada, to voter participation is a lack of basic information about how to participate. Now, most of us understand, most Canadians understand, that they can vote on Election Day. That knowledge is widely understood. But half of young people are not aware that you can vote before Election Day. A poll by Elections Canada showed that three-quarters of Aboriginal youth were not aware that they could vote before Election Day, either through an advance ballot or a mail-in ballot or by going to the Elections Canada local office on any day throughout the campaign. that knowledge will be useful in helping people who are too busy, out of town, working, having family or health obstacles, to get out and vote. That is why the Fair Elections Act is going to focus Elections Canada's advertising on where, when, and how to vote. In fact, with the passage of the Fair Elections Act, the agency will only be allowed to advertise on the basics of voting. That is a change from the system right now, and it will ensure that the information that people of Canada receive from their election agency is relevant to their role. Finally, for the vote to matter, it has to be honored. Under the status quo, Elections Canada is able to attempt to remove a member of Parliament through suspension from the House of Commons if there is a financial dispute over election spending. Now, Mr. Speaker, I think all of us agree that if someone flagrantly and deliberately breaks election law in order to be elected, that they should be suspended. But we have to make sure that allegation is in fact true before reversing the decision of thousands of voters by edict of one agency head. So the Fair Elections Act will allow any member of Parliament whose financial claims are disputed by the agency to exhaust all levels of legal appeal in the courts before the CEO can come to Parliament and ask for that MP's suspension. And this is altogether fitting and proper. It is not right for an agency head to attempt to overturn the results of a democratic election and cancel out the votes of tens of thousands of voters unless and until a judge has agreed with the allegation that the CEO has presented. The Fair Elections Act will embed that required judicial proceeding in place rather than the current system, which is undemocratic and unfair to the voters. Mr. Speaker, we also believe in this party and in this government that voting should be as easy as possible. And that is why we're adding an additional day of voting during which Canadians can show up and cast their ballot in advance in case they are not able to do so on Election Day. This is a summary of the changes that we are putting forward before the Canadian people. Widely debated, thoroughly considered in both committees of House and Senate. And now we move forward to Decision Day. Having had all of this debate, considered some modest but fair changes, it is time for people to decide. This bill will allow Elections Canada to focus on its core mandate of running elections fairly and efficiently, while removing from its mandate aspects that really don't belong with the agency at all. It is a major step forward for democracy. It will protect the independence of our elections, and it will allow the Canadian people to have full confidence in the apparatus that is constructed to carry out their vote, to carry out the vote on Election Day. And so, Mr. Speaker, I invite members of all parties, having carefully considered it, to vote in favour of the Fair Elections Act tonight and to celebrate it as a step forward in the evolution of Canadian democracy, building upon our long-standing traditions and democratic heritage to move our country forward into the future of its democracy. Thank you very much.
Questions and comments? Question et commentaire. The honourable member for Toronto Danforth.
Thank you, Mr. Speaker, and I thank the Minister for outlining some of the benefits. I do appreciate that finally, indeed, I can list them. I'm also glad to see that finally the Minister has contrasted what is back in the Act with something that was eliminated. He said that vouching for identity is no longer available, which means that he now accepts that he has restored vouching for address, and that certainly was the biggest concern of all the witnesses. And I would count that not as a modest amendment that the minister started out by saying all the amendments were, but as a major amendment. So I thank the minister for that. The question I would like to ask is, however, did the minister listen to, and if he did, why did he not act on the testimony from the commissioners for Canada Elections about the effects of transferring the commissioner to the office of the DPP? The concern was that a compliance model permeates the Canada Elections Act, and that separating the commissioner from the CEO, the Chief Electoral Officer, is going to actually create serious effectiveness problems for the commissioner's job when it comes to assisting in compliance versus prosecutorial enforcement. Did the minister listen to that? Did the minister not see the reason in that criticism? And why did he not leave, therefore, the commissioner with the Chief Electoral Officer?
Honourable Minister of State for Democratic Reform.
Well, I thank the member. He addressed two issues. One is the issue of voting without ID. Under the status quo, people can vote without any ID whatsoever by having someone vouch for who they are. That's over. That's done. It's not coming back. And it is a major improvement to require every single voter present ID when they cast their ballot. I respect that he takes a different point of view. And though we're on opposite sides of that, I don't question his well-intentioned approach. On the issue of the independence of the commissioner, there are two different functions here. One is administration, and the other is enforcement. The job of Elections Canada is to administer elections. If you read the Neufeld report, you'll see that administration had serious problems in the last election. 165,000 serious irregularities that represented breaches of practice, and that cannot continue. That's why we're focusing Elections Canada on its core job, which is to administer properly elections. As for enforcement, there are two parts to enforcement. One is prosecution, the other is investigation. They have, in the past, those two functions have been housed not only in the same office, but in the same person. Prior to 2005, one person was both prosecutor and investigator. What we're proposing now is that they not be in the same person, but in the same office. The prosecutor will be responsible when charges are recommended for taking those charges before the courts, but the investigator will be completely independent from the Elections Canada, able to exercise a free hand in seeking out wrongdoing. And I think that all that we've seen over the last several years suggests that this independence is needed, and that it will be a major improvement when it is achieved.
Questions and comments? Question commentaire. The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. Because the minister himself is the minister, he was afforded the opportunity to name the bill. He named it the Fair Elections Act. Mr. Speaker, that is anything but the truth. This is a conservative election act, Mr. Speaker, and every action demonstrated from this government towards this bill clearly demonstrates that it is a conservative election piece of legislation, Mr. Speaker, through time allocation, through limitations, through the lack of consultation, the lack of respect, whether the Chief Electoral Officer, something in which this minister himself verbally assaulted the Chief Electoral Officer for expressing concerns that Canadians have with regards to this legislation. Mr. Speaker, my question to the minister deals specifically when he talks about the commissioner. It's only the Conservative Party that wanted to take the commissioner outside of the Elections Canada. Not only did the CEO want it to stay within Elections Canada, so did the commissioner himself. Can the minister give any indication clearly from any academic that made presentation that suggested that the commissioner, amongst other things, had to be taken out of Elections Canada? Was there anyone outside of the Conservative Party or the PMO's?
The Honourable Minister of State.
Yes, I think we did have Ian Lee, who's a respected professor in Ottawa. I think the Lortie Commission, which did a very thorough study on election law, suggested that there should be an independent commissioner, and that's what we've done. We've allowed, through the Fair Elections Act, the Commissioner will be independent from the elected government, the political parties, and from Elections Canada. Now, keep in mind, Mr. Speaker, there are about 36 offences in the Act which would relate to the conduct of Elections Canada officials. Now, how could he possibly investigate potential offences by officials within the organization for which he works? It is impossible. A basic precept of good governance is that enforcement is independent and separate, that people do not investigate themselves, and that the investigator should make his own decisions and have a free hand. And that is the decision that we've made in the Fair Elections Act.
Questions and comments? Question et commentaires. The honourable member for Charles Wood, St. James, Assiniboia.
Oh, thank you, Mr. Speaker. And I'd like to congratulate the Minister for an excellent bill. I played his or had his portfolio a few years ago, and I think it is a terrific bill. I think it is a bill that Canadians will respect. I have, when I've heard about this bill in my constituency, people think it's just common sense that people identify themselves. And I wonder if the member or if the minister could just, again, reassure us that people who can vote will have that vote opportunity, and those who cannot vote do not vote. And perhaps you could share with us some of the other identification methods that are available under this new bill.
The Honourable Minister of State.
Thank you to the member. He was a great minister in the Democratic Reform portfolio, and also presided over Crown Corporations. Has a very distinguished record, and I thank him for the question and the kind words. On the issue of voter identification, here's the fundamental difference between what the Fair Elections Act proposes today and what existed in the last election. In the last election, you could go in with no ID whatsoever and cast a ballot by having someone vouch for who you are. That form of identity vouching is gone. Every single person who votes will have to present a piece of identification showing who they are before they vote. Now, if that ID does not have an address on it, they can co-sign an oath with another elector as to their address. However, there's a big difference. From now on, the list of oath takers will be put before the eyes of Elections Canada right after the election to find out if there are duplicates, so that we can catch people who voted more than once. There will be a $50,000 fine for taking a false oath. Potentially jail time could come along with that. There will be an external auditor to make sure that Elections Canada actually follows these legal requirements. And because we will have required people to show ID proving who they are before they take that oath, unlike under the status quo, if they have lied or cheated, we will be able to track them down. Under the previous model of vouching, where people could go in without any ID whatsoever and have someone vouch for who they are, if the system showed that they had voted more than once or cheated in some way, you might not ever be able to track them down because their identity would not have been established. In other words, they could simply lie about who they are. There's no picture of them. There's no record of their existence. They literally vanish into thin air as though they never existed, but their vote gets counted. And that vote would have canceled out the legitimate vote of an honest voter. And that is another way of disenfranchising someone. So we are eliminating that practice and that possibility by requiring every single person show their ID, by checking the list of oath takers for duplicates to catch people who vote more than once, and having an external auditor oversee all of it so that we can ensure Elections Canada actually follows its own rules.
Resuming debate, reprise de débat, the honourable member for Toronto Danforth.
Thank you, Mr. Speaker, and if you could give me a fair warning of 1 minute, that would be extremely helpful. I'd like to orient my remarks in the following way. Just briefly situate why it is that there was so much concern when this bill was initially tabled in early February, and for the months leading up to major concessions by the minister, not the minor or modest amendments that he just referred to. Secondly, outline what those amendments were that do constitute a major victory for civil society and the opposition in making a bad bill less bad. And finally, to go through 10 points about what still remains in the bill that indeed makes it a bad bill unworthy of the support of this House. On the first point, it has to be said that from the beginning, our worry was that running into the dozens of new provisions and changes in this bill created a tapestry that, in the result, whether or not by intention, was going to favor one party in the next election and lock into place a series of principles that were not themselves fair, despite the name of the act, the Fair Elections Act. And no better sign that those well aware of what this government is capable of and of the bill itself was the fact that on April 10th, two very highly respected progressive conservatives joined in signing a statement about their concerns and about why this bill should actually be killed. Those two persons were David Crombie and Alan Gregg. And they said, quote, "This legislation is a blatant effort by the Harper government to stack the deck in favor of the Conservatives for the next election." End of quote. Two extremely knowledgeable members of Canadian society, one of which was the former mayor of Toronto and a former progressive conservative minister, the other of which is a deeply connected pollster and marketing person. Both of these men knew what this government was capable of. They read the bill, they understood, and they used very strong language. Stack the deck is something that clearly suggests an effort to create an unfair Elections Act, the opposite of the title of the bill, the Fair Elections Act. Now, with pressure from all sides, civil society, from a vigorous opposition effort, from academics speaking out, and I have no doubt from a certain number of conservative backbenchers who, either as a matter of principle or as a matter of feeling the pressure, weighed in. On the basis of all of those factors, a number of major concessions were announced by the minister and indeed delivered on in amendments at PROC, the Procedure and House Affairs Committee. I will list them, and by listing them, I hope I convey, Mr. Speaker, how major they are and how the government was forced off of some elements that were at the very heart of the effort to quote-unquote stack the deck. First of all, there was a fundraising exemption. Parties would be allowed to exempt from their campaign expenses all the costs of contacting previous donors from the last 5 years in order to raise more money from them. All the costs associated with that would not have to go into campaign costs. All kinds of reasons were given as to why this was a huge, unlimited exemption to the campaign caps at election time. That was removed. Secondly, the government added in to the bill, the original bill, C-23, the fact that central poll supervisors would henceforth be appointed, de facto appointed by the first place party as candidate or the first place party going into the next election. The central poll supervisor is in many ways the most important person in any given poll, and the fact that this would unbalance the existing system, which is already unfortunately politicized, where the deputy returning officer and the poll clerk are each appointed by the first and second place parties respectively, the fact that this would unbalance that system was something that produced major concern. There was absolutely no logic to why this should be the case, and that was removed in one of the so-called modest amendments of the minister, but an amendment that I nonetheless would prefer to characterize as a major concession. Also, we've just had an exchange where the minister acknowledges that vouching for identity in and of itself is no longer part of C-23 and remains no longer part, but vouching for address, which is the absolute key problem that had occurred when the vouching provisions of the Canada Elections Act were removed, vouching for address has been restored. That was not a modest amendment. That was a major victory for civil society and for the many witnesses who took the time and the trouble to explain to Conservative members of PROC, the media, and ultimately the minister why the elimination of the current vouching provisions in the Canada Elections Act were deeply unfair and disenfranchising. Fourth thing is there was a bordering on ludicrous limit on how long calling service providers and others had to keep data with respect to voter contact in the new voter contact registry. According to C-23, when it was initially introduced, it was to be only 1 year, which is barely enough time for information to come out in some context that there's a problem needing investigating. The minister caved, and with respect to the keeping of scripts and audio recordings, that was increased from 1 year to 3 years. Many other problems remain with this voter contact registry system, but nonetheless, this at least was, yes, I would call this a modest amendment, but nonetheless a significant one. Fifthly, the government heard early that the elimination of the public education and information programming role of Elections Canada, especially targeted towards disadvantaged groups and those more likely to experience difficulties in voting. The elimination of that power by C-23 was an abomination, frankly. And I knew early on that this was one area that a lot of government backbenchers, Conservative Party backbenchers, had great trouble with. And I could have predicted from the beginning what happened, which is that the public education role for Elections Canada was restored, albeit only for primary and secondary school students. All the other outreach activities that Elections Canada has engaged in over the year or could engage in the future have remained prohibited by the current version of C-23. Nonetheless, at least allowing student vote and analogous programs to continue to be supported and funded, co-organized and partnered by Elections Canada constitutes a major victory on the part of, I would say, civil society, which very much put this near the top of their concerns. A sixth concession was the fact that C-23 contained no provisions that are necessary in a bill for technical reasons to allow communications between Commissioner for Canada Elections and the Chief Electoral Officer after the Commissioner was moved from Elections Canada to the Director of Public Prosecutions. That was rectified by putting in communications authorizations that are minimal, did not go as far as we wanted, but nonetheless important. The seventh concession is that it was very clear in the way that the new Section 18 of the Canada Elections Act was written, it was written in a way that the Chief Electoral Officer was henceforth prohibited from communicating other than providing information with the public, communicating with the public, other than by providing information on a very narrow set of functional questions, where one can vote, how one can vote, with what identification one can vote with. It was the reason for this is Section 18 was worded in a way to say the Chief Electoral Officer shall only communicate about the following. And so there was great concern that whether intentionally or not, it had been written in a way that meant the Chief Electoral Officer could communicate on nothing else other than that in the future. Now, Early on, the minister said that wasn't the intention. And when he announced his other concessions, he said the chief electoral officer can communicate freely in his own capacity. And when the time came for the amendments in proc, it was never made express that the chief electoral officer could communicate freely henceforth. But the way in which Section 18 was rewritten makes me satisfied that the result is that he can now communicate freely. I only wish the government had agreed to an opposition amendment, an NDP amendment, to make that clear for the sake of certainty. But I will go on record here, as I did in proc, to say that, in fact, it's clear from the record that the chief electoral officer may now say whatever he wants in whatever context in Canada or outside of Canada. Finally, of the concessions made by the minister, there was a very puzzling provision of C-23 that basically said the Commissioner for Canada Elections could not begin an investigation until he or she had reasonable grounds to suspect an offence had been committed. Now, anybody involved in the criminal law or investigative sphere knows that that's the standard not for beginning an investigation, but for receiving things like orders for wiretaps, for other kinds of investigative measures. But in the common law and in every other investigative context, all that investigative officers need is a reasonable suspicion to start an investigation. That was changed in proc, and I'm willing to concede, I guess, that that was simply a mistake on the part of the drafters, although a puzzling one that I cannot understand for anybody who understands how criminal law investigation works. So the point, Mr. Speaker, is that a number of major concessions arose as a result of fierce opposition and engaged civil society and either persuaded or somewhat fearful backbenchers who obviously weighed in with the government. Mr. Speaker, I wonder about how much I have time. 7.5. I'd like to now move on to why, nonetheless, despite listing all of those concessions, there still remain so many problems with this bill that it does not deserve our support, quite apart from all of the process concerns about how it was generated, how even the amendments process was non-consensual. Not a single opposition amendment was accepted of any substance. Despite the concessions that I mentioned earlier, there are so many problems it deserves not to see the light of day. And I will briefly now indicate 10 points. The first, the current C-23, that on which we're about to vote today, continues to eliminate the power of the Chief Electoral Officer to implement public education and information programs designed to enhance knowledge of our electoral democracy and to encourage voting. It only brought back one context, and that is for primary and secondary school students. All other public outreach remains prohibited. Secondly, C-23 prohibits the Chief Electoral Officer from authorizing the use of voter information cards, or VICs, as a piece of voter identification to be used not on their own, but alongside a second piece of identification. And it does this despite the fact that such cards are a method of enfranchisement that were introduced because of concerns about limited forms of identity showing address, and despite the fact that smoother administration of voting on Election Day resulted from their use in various contexts in 2011. And also, it's being prohibited despite there being no basis, no evidence whatsoever for believing these cards are likely to be a source of fraud. This remains the case no matter how many times the minister gives an example of a hoax that was attempted by the television show Infoman that never actually reached fruition. Thirdly, Bill C-23 requires that the Chief Electoral Officer and the Commissioner for Canada Elections must now get the permission of government officials in order to remunerate experts and investigators who they find necessary to hire on a temporary basis. Previously, they could have direct access to the Consolidated Revenue Fund. Now, The CEO has to go through the Treasury Board, and the Commissioner has to go through the Director of Public Prosecutions. Fourthly, it refuses to legislate powers that are necessary for full compliance with and enforcement of the Canada Elections Act in light of the experience with fraud and breach of other electoral law rules in the elections of 2006, 2008, and 2011. Notably, the power of the CEO to require registered parties to provide receipts accounting for the election campaign expenses, and the power of the Commissioner to seek a judicial order to compel testimony during an investigation into electoral crime. Fifthly, it unnecessarily transfers the Commissioner to a government ministry, the Ministry of the Attorney General, and away from the current location within the Office of the Chief Electoral Officer, who is, I will remind you, Mr. Speaker, an officer of Parliament. This thereby creates corresponding negative consequences for the effectiveness of Commissioners' investigations and for the complementary roles that the Chief Electoral Officer and his or her staff and the Commissioner and his or her staff play in securing compliance with the Canada Elections Act well ahead of and well beyond the relatively limited number of contexts in which their focus is enforcement. Sixthly, the Commissioner is fettered in ways that other investigative agencies are not. In particular, he or she is required to inform suspects that they are under investigation, and he or she is prohibited from explaining to Parliament and Canadians why an investigation has not led to charges or prosecution. Seventh, it leaves serious loopholes in the voter contact registry system that is to be administered by the CRTC, which is a welcome addition to the Canada Elections Act, but which does not go far enough. The loopholes include the fact that the voter contact scripts for live calls and audio recordings of robocalls do not have to be conveyed to the CRTC. The fact that no person or group is under any obligation to retain phone numbers of persons called, let alone to convey those numbers to the CRTC. And the fact that no affirmative obligations are placed on the CRTC to proactively inform the Commissioner if and when a CRTC employee suspects wrongdoing. Obviously not wrongdoing on the part of the CRTC, but on the part of the actors who have to report to the CRTC. Eighth, Mr. Speaker, how much time do I have? 2 minutes. Right. Eighth of the 10 points. The Canada Elections Act, through C23's auspices, under C23's auspices, retains a politicized system of appointing deputy returning officers, poll clerks, and registration officers as election officials or officers for Election Day. As such, the Canada Elections Act does not grant Elections Canada the full authority to appoint all elections officers on the basis of merit, with corresponding detrimental effects for Elections Canada's capacity to minimize Election Day irregularities through more timely recruitment and training of elections officers. This is one of the major outcomes of the Neufeld report, saying that the ability of Elections Canada to appoint all elections officers would be the single most important way to enhance the capacities of elections workers in order to minimize the irregularities that the government from the beginning tried to leverage as evidence of fraud, which it was not. Ninth, Mr. Speaker, 1 minute to go, thank you. It adds problematic provisions relating to voter identification that create the danger of harassment and intimidation of voters because identity documents can now be inspected by party scrutineers. And it also dissuades people from actually vouching for address because of the fear that the requirement that the person must have known personally the person being vouched for is very, very unclear as to how long and how well the voucher must have known the elector. And finally, it increases the role of money in politics through unjustified increases in donation limits and also by creating an unworkable banking loan system that will actually, in ways that are too complex to explain, benefit well-resourced candidates and parties. And so, Mr. Speaker, I would like to move, seconded by the member for Sudbury, a reasoned amendment, that the motion be amended by deleting all the words after the word "that" and substituting the following: This House declined to give third reading to Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts because, amongst other things, it, A, was rushed through Parliament without adequately taking into account the concerns raised by over 70 expert witnesses and hundreds of civil society actors that speak to a wide array of provisions that remain problematic in this bill. B, prohibits the Chief Electoral Officer from authorizing the use of voter information cards as a piece of voter identification to be used alongside a second piece of identification. Despite such cards being a method of enfranchisement and promoting smoother administration of the election day vote, and despite there being no basis for believing these cards are or are likely to be a source of voter fraud. C, refuses to legislate the powers necessary for full compliance with and enforcement of the Canada Elections Act in light of experience with fraud and breach of other electoral law in the 2006, 2008, and 2011 general elections. Notably, the power of the Chief Electoral Officer to require registered parties to provide receipts accounting for their election campaign expenses, and the power of the Commissioner for Canada Elections to seek a judicial order to compel testimony during an investigation into electoral crimes such as fraud. D, eliminates the power of the Chief Electoral Officer to implement public education and information programs designed to enhance knowledge of our electoral democracy and encourage voting, other than for primary and secondary school students. And E, increases the influence of money in politics through unjustified increases in how much individuals may donate annually and how much candidates may now contribute to their own campaigns, thereby creating an undue advantage for well-resourced candidates and parties. Thank you, Mr. Speaker, and I have that amendment here and signed.
The amendment is in order and will be accepted. Questions and comments? The honourable member for Kitchener-Conestoga.
Thank you, Mr. Speaker. A number of months ago, I had the privilege of serving with my colleague who just finished his speech. I served with him on the Procedure and House Affairs Committee. And I know that my colleague does his homework and is very well informed on this bill. So I was rather surprised to hear him at many times throughout his speech use words like mistakes, concessions, and changes as if this was something unusual that would happen at committee level. Mr. Speaker, one of the things he referred to was the retention of the student vote program. And I can say with confidence, Mr. Speaker, that many of us approached the minister and said that in our ridings, this system is working well. That's the reason to have studies at committee, to allow input into that committee to do a more in-depth study than we can do here in the House with all 308 members. So I'm rather surprised to hear my colleague refer to these changes as somehow big concessions. The very point of having our committees is to study in depth the legislation that's proposed and then to make recommendations to this House after this in-depth study. So why is my colleague implying that the committee's work is somehow simply to rubber stamp a bill that was passed here at second reading? This is the job of our committees. Why is he implying otherwise?
Honourable member for Toronto Danforth.
Thank you, Mr. Speaker. And I'm actually implying no such thing. I just wish this were the norm. This was an extremely unusual outcome for a government-sponsored bill in this Parliament for the last 2 years. Amendments of this nature coming for government legislation is almost unheard of. Yep. And as such, these were major concessions. The minister had no intention of making these kinds of concessions at the beginning. It was as a result of not just good faith efforts in a committee. It was the overall pressure on civil society that realized what was going on in this bill. Thank you.
Order. I'm required to read the motion. which reads as follows. Therefore, I move, seconded by the member for Sudbury, this motion from the member for Toronto Danforth, that the motion be amended by deleting all the words after the word that and substituting the following. This House declined to give third reading to Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts because, amongst other things, it, A, was rushed through Parliament without adequately taking into account the concerns raised by over 70 expert witnesses and hundreds of civil society actors that speak to a wide array of provisions that remain problematic in this bill. B, prohibits the Chief Electoral Officer from authorizing the use of voter information cards as a piece of voter identification to be used alongside a second piece of identification, despite such cards being a method of enfranchisement and promoting smoother administration of the election day vote, and despite there being no basis for believing these cards are or are likely to be a source of voter fraud. C, refuses to legislate the powers necessary for full compliance with and enforcement of the Canada Elections Act in light of experience with fraud and breach of other electoral law in the 2006, 2008, and 2011 general elections, notably the power of the Chief Electoral Officer to require registered parties to provide receipts accounting for their election campaign expenses, and the power of the Commissioner for Canada Elections to seek a judicial order to compel testimony during an investigation into electoral crimes such as fraud. D, eliminates the power of the Chief Electoral Officer to implement public education and information programs designed to enhance knowledge of our electoral democracy and encourage voting other than for primary and secondary school students. And E, increases the influence of money in politics through unjustified increases in how much individuals may donate annually and how much candidates may now contribute to their own campaigns, thereby creating an undue advantage for well-resourced candidates and parties. Questions and comments? Questions et commentaires. Honorable député de...
The honourable member for Marc-Aurèle-Fortin. Thank you, Mr. Speaker. From the outset, this election reform legislation is something new because traditionally in Canada, electoral legislation was worked out around a consensus. That is, all political parties supported such legislation, and such legislation in the past was supported by most experts in civil society. Yet for the first time in its history, electoral legislation will be developed despite the opposition of the majority of stakeholders. In particular, my question for my colleague who has understood democratic principles and defended them well. What is the future of a law which from the outset will be attacked by First Nations because the Unfair Elections Act will make it harder for them to exercise their franchise? Second, for students at college and university who will not be encouraged anymore to vote, who will not be motivated to vote, which is the essence of democracy, they will also be able to legally challenge this legislation. And everyone else who feels that their power to vote has been minimized, the Quebec Bar Association, the bar associations of various provinces like Quebec and Ontario. So my question for my colleague is this: what is the future of a piece of legislation which will be supported by the majority, but which has been so contested from a legal point of view? What is the future of this bad piece of legislation? The honourable member.
Thank you, Mr. Speaker, and I thank my honourable colleague for the question that actually builds into it extremely strong set of arguments about why the legacy of Bill C-23 is going to be a lack of public trust and confidence in our electoral system. We've given extremely good reasons why a whole range of sectors of society have not been dealt with fairly by this bill. We've not simply raised it for opposition's sake. But the result is that this bill is being passed against major opposition and major, not just in the House, but in society. And as such, I think the Auditor General, former Auditor General for Canada, Sheila Fraser, was correct when she said that the ultimate impact of this is going to be diminishing public trust in both our parliamentary institutions and our electoral system. And so at some level, it's going to be very important that we revisit key elements of this bill in a future Parliament and start again more consensually to produce a final version of the Canada Elections Act that all parties and all key actors in civil society feel an ownership in.
Questions and comments? Questions et commentaires? L'honorable député de Hochelaga.
The honourable member. Thank you, Mr. Speaker. A little earlier, my colleague talked about the banking loan system. He said it was something that was very complicated, and I'd like to have a little more information. Perhaps he can give us a quick summary of what this is. The honourable member.
Question, and indeed, and what I think is actually began 2 years ago as a good faith effort on the part of the former Minister for Democratic Reform. A system of political loans has been inserted into the Canada Elections Act, whereby essentially banks are now the central actor in providing candidates with loans in order to start up campaigns before they may have raised money. The problem is, through a whole series of limitations on how those loans can be guaranteed, the banks appeared before the Procedure and House Affairs Committee almost 2 years ago in a previous incarnation of this in another bill to say there would not be the right kinds of incentives for a bank to be chasing down all the guarantors in order to actually give out these loans. And then the Chief Electoral Officer said it would be unworkable because those who can guarantee and give loans within their individual donation limits would be impossible to track because of a whole series of fluctuations over the course of a year. Unworkable according to the Chief Electoral Officer and unworkable according to the banks. The result is that those who actually need some loans because they have not, especially non-incumbents, have not yet raised money, are going to be disadvantaged versus those who have had a chance to raise a lot of money, mostly incumbents, or can receive direct transfers or loans from a well-resourced national party and therefore have no need whatsoever to turn to the banks to help start up their campaign. And that's why that I think it's in the result. I don't think this is intentional on the part of the government, although they heard the concerns before. In the result, this bank loan system is actually going to advantage parties and candidates who are well-resourced because its access to it will only be needed by those who don't have resources, and it will also be a system that when they try to resource it, they may access it, they may find that the bank's doors are closed.
Questions and comments? Questions et commentaires. The honourable member for Yukon.
Thank you, Mr. Speaker. And I'd like to touch on a point that my honourable colleague is making about parties being well-resourced. Mr. Speaker, parties that are well-resourced are indicative of parties that have support of the Canadian public. The resources are provided by people who take out memberships in the party, believe in party philosophies, and are willing to donate money. Then it would only stand to reason that parties that aren't well-resourced aren't well-supported. So I'm not sure I understand the member's logic that parties that aren't supported by a membership, that parties that aren't supported by membership donations, and that don't have the broad Canadian support should somehow be given financial resources through some other means. And his argument about resourcing being indicative of incumbents' positions is not actually the case. I wasn't an incumbent in the last election, but was resourced. And Mr. Speaker, I can tell you that resources don't equate to election success because the incumbent in the last election in the Yukon spent $20,000 more than he had in the election before and lost 1,500 votes. So that resourcing didn't equate to election success, and I don't think that's broadly the case across this country. Maybe the member would wish to comment on some of those remarks.
My member for Toronto Danforth, we're almost out of time.
Well, if fundraising and resourcing doesn't affect elections, then I think we should all talk about lowering campaign expense limits entirely, and making sure that every candidate has a much lower limit, because it doesn't have the impact that my honourable member, has indicated. At the same time, unfortunately, I think in the norm, that's not the case. That the ability, especially at the spending limits per constituency election that we currently have, it can make a major difference, especially major gaps in what candidates can spend. Beyond that, the fact of a party having a lot of money is a sign of which sectors of society may be supporting that party and may be in a position to donate to that party. It has nothing to do with the levels of support from the society as a whole. And so I think equating the fact that a party has been able to raise a lot more money from a stronger donor base with on average wealthier donors says nothing about its political support.
Resuming debate, reprise de débat, l'honorable député d'Ottawa-Vanier.
The honourable member for Ottawa-Vanier. Thank you, Mr. Speaker. I rise today to speak to a bill that is highly problematic and that might well take us into a very delicate situation in this country, Mr. Speaker. Now, I'd like to start by trying to understand the origin of the bill, or try to explain, based on my perception, the origin of this bill. Now, we all remember, following the last election, that there were investigations undertaken by Elections Canada on certain practices that occurred during the election. One such practice was the mechanism created by a party to exceed limits authorized for a national campaign by lending money to riding associations or to local campaigns, which subsequently returned the money back to the central party for advertising. And that was called the famous In and Out scandal. It led to prosecution, and the party was found guilty of having violated the act. They had to pay a fine, Mr. Speaker. And I think that left a mark on the party in question, which is now the party in power. The other incident, which stemmed from the last election, which had begun prior to that, was the new approach during elections campaigns to get the vote out, or to, in fact, reduce or suppress the vote, in an attempt to have certain candidates elected because maybe one side had a better team, and to get the vote out on their side, to discourage others to vote, and that would increase the likelihood of their candidate being elected. And that was the robocalls scandal, Mr. Speaker. And it's not the right label for it, Mr. Speaker, because there are some people in the riding that I represent who received calls from real people, not automated calls, people who gave them incorrect information. I had a few cases of that, a couple, in fact, Mr. Speaker, and the people who contacted me, I asked them to swear it in an affidavit, and I have all of the affidavits, Mr. Speaker. I sent them to Elections Canada and to the RCMP. But I'll give you an example. There was a woman of a certain age who's lived in a building for, 60 years? And in that building, when the elections take place, be it municipal, provincial, or federal, the polling officers are always in the building. And she received a call that very day telling her that her polling station had been moved. Now, she laughed at them, the people who made the call, because, in fact, she said, "You're complete idiots. They're in my building, and what you're telling me to do is absolutely wrong." And she is one of the women who signed an affidavit, sworn affidavit, before a lawyer. And that situation was, that letter was sent to Elections Canada. But that left a very bad taste in the mouths of Canadians, and it left a mark on the governing party. Now, perhaps that's what led to their desire to amend the Act, except that Canadians and parliamentarians demanded amendments. The chief electoral officer called for amendments, and the government committed to making some amendments. Moreover, the previous minister said to the House that the bill would be coming in a few days, and what we learned, in fact, was that he went to consult his caucus, and oops, instead of tabling it the next day as he was supposed to, the bill was taken back to the drawing board, and then following the last cabinet shuffle, where the current minister was appointed to hit the position as Minister for for Democratic Reform, he took action, because we know that also that the minister who is in charge today is different. He's more acerbic, more partisan than his predecessor, and that led to the bill that we have, that they call the Fair Elections Act, Mr. Speaker. And that's where the public outcry occurred. The outcry began in the House as well. And I think that it's important to point out and to remind viewers of some of the reactions that occurred across the country. In the Cape Breton Post, for example, and I'll read this in English.
Act anything but fair. Ça, c'était au mois de février, Monsieur le Président.
So that was back in February, Mr. Speaker. In the HoC newspaper in Edmonton, Alberta, they said elections tension is up. The over 400-page bill is being rammed through despite the impact that it will have on the democratic process. The proposal put forth at the start of the month will change rules in depth. In the Gazette.
Elections Canada ads failed, Minister says. Dans le National Post.
In the National Post now.
Mr. Slav's reform bill at meetings vows not to resign. Draws applause. An article écrit par Glenn McGregor.
So that was written by Glenn McGregor, Mr. Speaker. In the Gazette.
Unconstitutional, critics. Fair Elections Act measure could affect the young seniors and Aboriginals. Dans la Gazette encore.
In the Gazette again.
Problems the Tories want to solve. Dans le Winnipeg Free Press, election bill helps Tories exclusively. Dans le Chronicle Herald.
In the Chronicle Herald.
Times electoral reform bill. Dans the Chronicle Herald encore, some good, some bad election changes. Well, il y a quand même des nuances.
There are some nuances added there.
Encore une fois,
and once again in the same newspaper.
Exactly as advertised. Dans the National Post.
In the National Post.
Based on mistrust, new bill removes chief electoral officer's power.
And so on and so on and so on. In the Devoir, a poison pill. In La Presse, the government wants to remove from the chief electoral officer the responsibility for investigations. So, Mr. Speaker, that summarizes, in fact, the reaction we saw across the country from well-known, respected people who also made some very surprising comments, including Preston Manning, who said in the Globe and Mail, and I think that was on March 1st, and I quote,
"are increasingly not viewed as the party that most champions democratic values." Monsieur Manning, it's ça, Monsieur le Président.
Mr. Manning said that. So this led us to a situation where we had some questions. Changes needed to be made because the bill was unacceptable, Mr. Speaker. Now, I did attend the presentation made by the Chief Electoral Officer when he appeared before the committee in mid-March 6th, in fact, and I shared his remarks with the members of the riding that I represent, and he went through the entire bill, Mr. Speaker. We also remember that during a week we've dealt with something we'd never seen here. One of the largest newspapers in the country, the Globe and Mail, had 5 editorials, one each day, seriously criticizing the bill, with one following up the following Monday that said, "Kill the bill." So, Mr. Speaker, we can see that what we were dealing with was a widespread phenomenon. People were not satisfied with what the government was proposing. There was a public outcry by civil society, a number of organizations that launched petitions, the opposition parties as well, Mr. Speaker. And it put us into a situation where the government finally realized that there was a problem. And when the minister, who always rose in the House in response to questions to quote the Neufeld report, now he used a report to confirm the opposite of what the report actually said, well, it became clear that he was hindering his own party, adversely affecting it. As the member for Toronto Danforth said earlier in sharing his view, pressure was on the rise, undoubtedly within the Conservative caucus too. Certain members also spoke out anonymously, and as a result, the minister made some changes and presented amendments. I think there were 45 that were tabled in committee at the Procedure and House Affairs Committee. All of those amendments were accepted by the government majority, but there were also 150 amendments put forth by the opposition parties, who are members of that committee. I think the only one who got one through, because it was a small technical error to identify a technical problem in the bill, in the drafting of the bill, that was accepted, but all of the other ones were rejected. Everything that came from the opposition parties, be it to the NDP, the Liberals, the Bloc, the Green or the Independents, those groups had consulted the people they represent. They made an attempt to change the bill, to put forth an amendment, and it's unacceptable for none of them to have been made part of our bill. Now, some amendments were made. I do agree with that. There have been some improvements, but it's simply not enough, Mr. Speaker. And now today, well, in fact, yesterday, we spent over 2 hours watching the government majority reject all of the other amendments systematically, when in fact there were many that made perfect sense, would have strengthened the Elections Act, democracy, and would have defended Canadians. But they were not accepted, Mr. Speaker. There were also some amendments that came along. There were some troubling comments made when Sheila Fraser, the former Auditor General of Canada, made a very strong statement, and I'll quote what she said.
An attack on our democracy.
Well, the reaction to that on the government benches was a furious one. They accused Ms. Fraser of being a mouthpiece for Elections Canada, of being paid for saying what she did, whereas that woman, Mr. Speaker, deserved unwarranted respect by all Canadians when she was the Auditor General for 10 years. She did a remarkable job. It's something that affected us when we were in government. The work that she had a mandate to do as the Auditor General, she had a great reputation, and the government, some of the critics, quickly attempted to destroy her reputation, to assassinate her. So when faced with a situation like that, there is clearly a problem. Now, where the government realized perhaps, or realized in fact, that the resistance was on the rise was when they went to the Senate. They sent it there for pre-study to see how the Senate would react. And they heard some very strong words from their own senators that certain amendments needed to be made, and that is what has led us to the situation we're in today. I'd also like to underscore that it was at that time the government quickly imposed time allocation to shut down debate, and then it was at that point that we had hoped to see some openness to make the bill acceptable in the eyes of Canadians and to parliamentarians. But no, the government said no. 1 day of debate at report stage, vote, that was yesterday. 1 day of vote today, third reading. It'll be voted on this evening, it'll be done, and I will support the motion of standing in the name of the member for Toronto Danforth, which was seconded by the member for Sudbury, to not proceed with this bill and adopt it, because adopting it would be a step backwards, not a step forwards, as the minister claims. Well, now we had a list of amendments that were good improvements to the bill and some other deficiencies. Now, with respect to the voter ID card, it's not allowed as an ID, piece of ID. It's still not the case that it can be used, but the role of Elections Canada is also very seriously limited. The separation of the Chief Electoral Officer and the Commissioner, and the sending of the Commissioner's duties to a government agency, where an agent or an officer of Parliament is lost. Mr. Speaker, this is completely unacceptable. And also the increase on limits, contribution limits to a political party or for candidates to $5,000, Mr. Speaker, helps the richest people in this country. That isn't a direction that we should be moving in, Mr. Speaker. I think, on the contrary, we should look at the situation and, in fact, reduce the amounts. Now, of course, things are difficult for the political parties. However, that would force the parties to open up, to encourage people to get involved in their movements, to contribute. And that is what strengthens a democracy, Mr. Speaker. It also creates a sense where people see that and feel that their voice is heard and has an impact. Now, I'm not talking about increasing the limits here. I'm talking about the opposite, but that's what we'll see.
That I think is really bothersome, Mr. I've got a couple of minutes, I think. 3 minutes. Elections Canada has, over the years, developed a fabulous international reputation. I've had occasion to travel in a number of countries, in Africa in particular, where you see these electoral commissions, commissions électorales provisoires ou permanentes, qui sont plutôt boiteuses.
The temporary commissions that are not functioning right, they're controlled by their governments.
Are problematic, and the people rely quite a bit when they have elections on external bodies, and I have seen Elections Canada's fabulous reputation in terms of going there to help, que ce soit au niveau
be it through Mr. Kingsley in the past, Mr. Hamel. Over the past decades, we established a strong reputation, but with the bill before us today, if it's adopted, Mr. Speaker, by this House and by the Senate, and it obtains royal assent, it will be a step in the wrong direction, a step backwards. We will be weakening Canada and weakening the ability of this autonomous and independent organization, which reports to the House, not to the government, to ensure that the elections process is strong, solid, transparent, and able to ensure that the law is abided by. And if not, then we can launch investigations, to have the authority, the power to investigate, which still isn't the case, to ensure that the reputation that we had is preserved. Now, if we adopt this bill, Mr. Speaker, we will be moving in the opposite direction. It will be a step backwards. It will weaken Elections Canada. We will be weakening Canada's, Election Canada's international and national reputation, and I am astonished. Now, I had those responsibilities in the past as Minister, Mr. Speaker, and we made an amendment, a minor amendment, to the way in which criteria would be used for readjustments. And in doing so, I consulted officers of Parliament, the opposition parties, and that's how we made an amendment to the Elections Act at the time, Mr. Speaker. Not the way we're seeing them acted today in a very cavalier method or way, using a report to make it say the opposite of what it in fact does say, to put forth amendments because they were required or forced to do so, but by rejecting all other amendments. Mr. Speaker, I hope that some members opposite will vote against this bill and that it will not become law, Mr. Speaker.
Questions et commentaires.
Questions and comments.
Comments. L'honorable député de Châteauguay.
The honourable member for Châteauguay-Saint-Constant. Thank you very much, Mr. Speaker. I'd also like to thank my colleague for his remarks. In his remarks, he raised a number of aspects that are absolutely scandalous in this bill, because we must remind Canadians that this is the first time in the history of Canada that the majority party will ram a bill down the throats of all people, a bill that no one wants. The opposition parties don't want it, nor does civil society. It is scandalous to see the way this government, Mr. Speaker, is acting on this Unfair Elections Act. It's a scandal. And I say scandalous, Mr. Speaker, because what it's going to do is suppress the vote for people who aren't in favor of the party opposite. We're talking about students, seniors, Aboriginal people. This is an attempt to prevent them from voting by not accepting the voter's identification card, and that's ridiculous.
The government says it wants to encourage voters, encourage people to participate in democracy, but in fact, these are undemocratic, scandalous practices. We know about the robocalls, where voters were misled, and I would like the Conservatives to explain to us how this legislation meets the requirements of what we actually need. The Commissioner of Elections will not be able to investigate how, in a way he should be able to, but in fact, what this government wants is for the Chief Electoral Officer not to be able to do its work. The Honourable Member for Ottawa-Vanier. Thank you, Mr. Speaker. The powers are very, very strong, but there is a limit to what one can do to keep power. We've seen tactics to suppress voter participation, reduce the number of people who go out to the polls. We saw in the United States the start of this trend with the Republicans, and it seems to have been imported here. The government wants to see if they can make this work here. It, in fact, seems to work because the practices put in place discourage people from coming out to vote. They confuse people. We have Elections Canada, which is an independent, arm's-length body, and it had certain powers and wanted more powers to be able to constrain witnesses and so on. But if Elections Canada doesn't have the powers it needs and loses that independence, then we won't have fair elections.
The
Honourable Member for Joliette. I would like to thank my colleague for his speech. There is something that I want to bring up, and I've been voting for decades, I just want to say that, and I have never had a problem. The current legislation means that the chief electoral officer will not be able to promote voting by activities out in the public, and this is something that really bothers me. What is the government doing? If we don't change this, then we won't be able to really criticize the government properly. I think that this change is dangerous because people will not be able to get the information that they need to be able to go out and vote. The honourable member for Ottawa-Vanier. If I understood the question, or rather if I understood the legislation properly, all Elections Canada will be able to do is to tell people when the election is, where they can go out to vote. What Elections Canada is losing in terms of its freedoms is to be able to encourage people to go out and vote. And that's what Elections Canada has done in the past. It has activities that target young people, and not just in schools, I would add. Elections Canada tries to encourage young people to go out and vote, and it has had a positive impact. Now, if I understand correctly, Elections Canada will be able to encourage students in elementary and secondary school to learn about voting, but not university students and other young people. As I said earlier, this is a step back, a step in the wrong direction. We need to encourage Canadians to exercise their fundamental right to vote. Why can't Elections Canada do that from now on? I have not had any answer to that question. It is important for Elections Canada to continue to play that role.
I have a question.
Questions and comments.
The honourable member for Beaches, East York.
Thank you, Mr. Speaker, and I thank my friend for his speech today. One of the amendments that NDP members of the committee studying this bill put forward at committee was to insert a provision into the Fair Elections Act to allow for the study of proportional representation system to ensure that every vote of every Canadian counts in an election. Unfortunately, the Liberal member of that committee voted down that proposed amendment, and I was wondering if our friend could explain why the Liberals voted against an amendment to study proportional representation. Thank you.
The honourable member for Ottawa-Vanier.
I'll have to talk to that member, Mr. Speaker, to see why he did. I don't know. I'll find out. However, for the information of my colleague, he should know that the position of a party is indeed, when we form a government, this is one of the things we will look at very seriously in terms of looking at proportional representation. I, for one, have always supported an element of proportionality in our electoral system, not a full proportionality, but an element of proportionality. I've said that publicly before, Mr. Speaker, and I had great discussions with Mr. Broadbent on this, and I'd love to have that same discussion with that member, should he so desire.
Questions and comments? Question et commentaire, l'honorable député.
The honourable member for Saint-Hubert, Saint-Bruno. Thank you, Mr. Speaker. I listened carefully to my colleague's speech, and my question is very simple. In Quebec, we are fighting for more transparency with the Charbonneau Commission. We want political parties to be more transparent. We see that the Conservatives, in this case, have changed the financing rules in their favor. So I would like to know what my colleague has to say about the influence of money in politics. The honourable member. Well, Mr. Speaker, I have always been in favor of limiting the influence of money in politics. Money from big corporations or big unions. It was Mr. Chrétien's government that put in place the public funding model and this was done by Mr. Lévesque in Quebec. I supported it at that time. I support it still today. But this has been eliminated by the Conservative government. Right now, the Conservatives are increasing the limits under this legislation. Why did they make this change? The Liberals and the New Democrats are starting to catch up with them in their fundraising. Our fundraising has increased a great deal, and we now have more donors. We have more donors than the Conservatives do. Are they going to increase the limits? We'll see. But in response to my colleagues' questions, I think we need to limit the influence of money in politics, certainly. Resuming debate.
The Honourable Parliamentary Secretary to the Minister of Agriculture.
Thank you very much, Mr. Speaker. I will be splitting my time with the member from Lanark, Frontenac, Lennox and Addington. It is a privilege for me to rise in the House to speak on the importance of the Fair Elections Act, also known as Bill C-23. Today I'll be focusing on the important measures taken by our government to protect democracy, to ensure the integrity of the voting process, as well as our commitment to combating big money and to minimize the possibility of fraudulent voting. We are very fortunate as Canadians to be able to exercise our right to vote through our democratic system. Sadly, in many countries, the voices of its citizens are frequently stifled by dictatorship and/or communism, and we often hear news of fixed or rigged election results in these countries, which results in civil unrest, division, and violence. This is why our government fully commits itself to protecting the core Canadian values of democracy, fairness, accountability, and transparency through the Fair Elections Act.
Our Conservative government is focused on the value of Canadian democracy and will continue to be so. I believe that this bill is important for strengthening the integrity of our voting system. We will continue to deliver, and under the leadership of our government, we have acted and taken good measures to protect and simplify our democratic system. Complex rules lead to unintended violations and discourage ordinary people from taking part in democracy. This is why the Fair Elections Act will make the election rules more clear, more predictable, and easier to follow. In order to be able to follow the rules, the parties will have to know about the rules, and the Fair Elections Act will help them in this regard by requiring the Chief Electoral Officer to take the appropriate steps. Further, to make sure that our legislation reflects the realities of the whole election process, the Political Parties Advisory Committee will be created through legislation. It will be composed of the Chief Electoral Officer and 2 representatives of each registered political party. The committee will ensure that the views of the parties represented are taken into account in administering election legislation. Its mandate would be to give advice and useful information on any administrative or legislative issue under the Act or in connection with Elections Canada's activities. The bill states that the advice and recommendations from the committee are not binding on the Chief Electoral Officer. Elections Canada does have the ultimate interpretation, but the committee will help protect the independence of election administration. The committee will look at the interpretations made by the Chief Electoral Officer and suggest improvements if needed. We need to bear in mind that there is no perfect election system. Even though Canada has a particularly strong democracy, we can always improve it. We believe that the measures that I have just mentioned will do that.
Government continues to take action when it comes to improving our voting system. In light of accountability and transparency, the Fair Elections Act helps combat big money to to encourage small donations and eliminate taxpayer-funded handouts. This would also keep special interest groups such as unions or individuals with deep pockets from drowning out the voices of everyday citizens. We believe that political parties should interact and engage with the public to advocate their cause, to be meaningful to Canadians, and to seek their financial support. This means that political parties and candidates need to be engaged, committed, and most importantly, relevant to Canadians so that they will make contributions from their own hard-earned money. Political parties need to do their own fundraising and utilize resources at their disposal to encourage individuals to come out to vote. That seems like a win-win for me, Mr. Speaker. Also, as MPs who hold public office, we have a responsibility to keep ourselves and those around us accountable. All of us here must lead by example come election time as well. The spending limit, although increased by our government from $1,200 to $1,500, would help political candidates do just that. Along with ensuring accountability, this spending limit would allow Canadians to make meaningful contribution to the parties that they support. Although I do appreciate and listen to the views and concerns of the members opposite on the matter of vouching, it is my opinion that they do not understand that the majority of Canadians agree with our position that a person must show identification in order to vote. I can assure you, Mr. Speaker, that we are committed to strengthening our voting process and procedures. We will take the necessary action to reduce high levels of irregularity that have been noted in studies resulting from a process known as vouching. It is indeed very reasonable to ask someone to produce identification prior to them casting a vote. When Canadians pick up a parcel at a post office, they are asked to produce a valid piece of ID. When Canadians embark on a plane, they are asked to produce a valid piece of ID. When a Canadian sets up a new bank account at their bank, they are asked to produce a valid piece of ID. My point here is that if one should require a piece of ID for many day-to-day dealings and activities, it is entirely reasonable that one would produce a piece of ID to prove their identity in order to vote. And what the opposition clearly does not understand is that Canadians agree with this, that this is indeed entirely reasonable. Our government has made the process simple, accessible, and clear for Canadians. There are currently 39 forms of authorized ID to choose from to prove identity and residence. And I will not go through the list for the sake of time, but I can assure you that it is extensive. That there are 39 forms of approved identification facilitates the ability of Canadians to show who they are. And, Mr. Speaker, what the members of the NDP and Liberal parties need to do is to lay aside their ideological opposition to the Fair Elections Act on a matter such as this and instead recognize that the measures are fair and reasonable and are considered to be so by Canadians. En dernier lieu,
lastly, Mr. Speaker, I would like to express my ongoing support for this bill. It is a remarkable initiative, especially in view of the fact that no other government, except for ours, could have achieved this. We have worked as well with the opposition members, and we have thus implemented a number of amendments to make a good bill even better. Through this legislation, our electoral system will be simplified and will be shielded from abusive campaign donations such as big money or fraudulent calls. Our government is committed to protecting Canadian values through this legislation. Unfortunately, the NDP and the Liberals have consistently voted against these important initiatives. As a Member of Parliament, I often think about the importance of democracy in Canada, and I certainly believe that this bill is based on the vision and of accountability, transparency, and impartiality of our democratic system. I once again invite the members of the opposition to join with us and support this bill, whose purpose is to defend our democracy and improve our electoral system.
Accountability, transparency, and fairness. And this is what we are delivering through the Fair Elections Act. Thank you very much, Mr. Speaker.
Questions and comments? Question et commentaires. L'honorable député.
The Honourable Member for Hochelaga. Thank you, Mr. Speaker. I attended an event in my riding last week. It was the opening of an organization that helps homeless people, people who are drug addicts and are on the street for other reasons. And one of the services they provide is to help homeless people obtain identification. So I asked them whether it was difficult, whether it was easy. They said to get ID, you need ID. It takes months. You have to go through a whole bunch of hoops, and it means that for a whole segment of society, a growing segment, I would add, that is people who are homeless, you have people who are already very much marginalized, low income, and they are at a disadvantage because they won't be able to vote since they don't have identification. And people who help them, like this organization I mentioned, will not be able to vote for them. Unfortunately, the people who are helping them do not live near them and won't be able to vote for them.
I'm going to plug in on your side because I can't hear on this side.
Reasonable to ask Canadians to prove their identity before they vote. And Canadians actually support this initiative. And, Mr. Speaker, for those who are homeless, many homeless people still receive support from levels of government. It might be from the federal level of government, it might be from the provincial level of government, or perhaps the municipal level of government. If they receive a check with their name on it, Mr. Speaker, that government-issued check actually would count as ID. And, Mr. Speaker, there is an amendment in place that allows, with respect to vouching for address, allowing that process to occur. So in other words, the obligation now is simply that someone produces a piece of valid ID with their name on it. And I think it is entirely possible, Mr. Speaker, for people, for Canadians, to have access to this type of ID. If they need to vouch for their address, this Fair Elections Act accommodates that. Thank you.
Questions and comments? The Honourable Member for Yukon.
Thank you, Mr. Speaker, and I'd like to thank the Parliamentary Secretary for his presentation. And we have had a discussion about identification. And, Mr. Speaker, just last week, a couple weeks ago now, I went back to my riding in the Yukon and got a fishing license. And that fishing license required an address on it. And, Mr. Speaker, one of the 39 pieces of identification that's acceptable to vote in the next general election is a fishing license. So, and Mr. Speaker, I want to touch on one other thing quickly with that. In terms of the 39 pieces of identification, that is reasonable, fair, and supported by 89% of Canadians that were asked whether or not ID should be required. Contrast that, because the comment has come up around elections in other countries like Kenya, for example. And, Mr. Speaker, in Kenya, in certain electoral districts, you need to produce a piece of identification, and you also have to have a thumbprint given. So your fingerprints are scanned to ensure the security and the integrity of that electoral system. Clearly, we're not going that far, Mr. Speaker, but of all the 39 pieces of identification, right down to a provincially issued fishing license, I think all Canadians agree that those are reasonable pieces of identification to provide when you go to the polls to cast your ballot to influence the outcome of a federal election. And I just wonder if the Parliamentary Secretary would agree with that and maybe add some additional comments from his experiences. Thank you, Mr. Speaker.
Honourable Parliamentary Secretary, you have less than a minute.
Thank you very much, Mr. Speaker. I absolutely do agree with my colleague. 39 different pieces of ID. Mr. Speaker, a lot of Canadians don't realize, but this list of 39 pieces of ID is published on the Elections Canada website, and it would include such things as a bus pass, a library card, any bill that is received, a cell phone bill, a telephone bill, a cable bill, a hydro bill, a heating bill, an oil bill, any type of a bill that is received at home. It could be a hospital card. It could be a hospital bracelet if someone had been hospitalized. It could be a letter from a senior's resident home simply attesting that they are residents in that home. Mr. Speaker, the list is extensive, 39 pieces of ID, and I think Canadians in general are shocked that the NDP feel that anybody should be able to show up at a poll with absolutely no identification whatsoever and cast a ballot in a Canadian election. That is clearly unacceptable, Mr. Speaker.
Resuming debate, reprise de débat, the honourable member for Lanark, Frontenac, Lennox and Addington.
Thank you, Mr. Speaker. Mr. Speaker, I too am rising today to address the Bill C-23, the Fair Elections Act, and some of the very significant and beneficial reforms that it is making to the Canada Elections Act and to the conduct of elections in this country. I want to run through a couple of things here, and if I have time at the end of my remarks, I have only 10 minutes, I'll go through some of the amendments that were made in committee, amendments that I think show a genuine commitment on the part of the government and on the part of the responsible minister to take into account a wide range of inputs and to alter the bill in order to make it better in reflection of those inputs. But let me start with what I think are the 4 key themes of this legislation. As someone who sat through all of the many hours of committee hearings on this bill and who's been involved in one form or other in every stage of the process of its adoption and amendment, it seems to me that these 4 themes come out very clearly. Number 1, an attempt to limit the influence of big money. This is a continuation of a theme that began when Jean Chrétien was Prime Minister and donations were limited to $5,000 per person. Before that, there were no limits on how much you could donate, and anybody who has an interest in these things can look at the records of Elections Canada to see the enormous donations to the tune of $250,000 from major institutions. That was changed. It was tightened by this government in its first term, reducing the amount of donations to $1,000 and eliminating all forms of corporate and union donations. The bump upwards in this piece of legislation, in the Fair Elections Act to $1,500, is merely a reflection of inflation over that period of time. And I should add that we have done a few things that entirely non-controversially, but I think very beneficially, this bill eliminates the possibility of the one kind of giant donation that still exists out there. This is the donation in the form of a bequest. A few years ago, the New Democrats received a donation in a bequest, in a will, of over $300,000 from a single individual. Clearly, the existence of this kind of continued very large donation, which could, in theory, allow for donations through bequests and wills of up to the millions, would destabilize a political system in which every other input of cash has been reduced. So I think that's a very significant step that this bill has done. Secondly, we have greater certainty in the administration of elections and of the rules. Elections Canada now is required to prepare rulings in advance. It's required to make public I should make it clear when I say in advance, they cannot make retroactive rulings. The rules are this now, but we also say that in the past they have changed from what we said they were in the past, or what a reasonable person might have thought they were in the past. They are bound by their own rulings. They are no longer in a position to sign compliance agreements with the party, as they did with the New Democratic Party following their convention and following the large corporate donations that were given in the form of sponsored advertising at that convention for consideration, for very large consideration. Well, the compliance agreement is a secret. The CEO knows what it says, and the New Democrats know what it says, and none of them want to reveal to the general public. That can't happen anymore. That's vital for the rule of law. Greater integrity and protection against vote fraud. Much has been spoken on that subject. I will only say that I think the measures taken here are reasonable, balanced, and especially once the amendments have occurred, do everything they can to ensure that there is fairness and that the restrictions that are placed on the ability of people to vote without identification are applied with as light a touch as is realistically possible. I applaud the Minister for having made those amendments. Finally, the fourth item, greater knowledge by Canadians of what their rights are under the law. You know, Canadians have the right to vote not only on Election Day, but also at advance polls. They have the right to vote at the returning office throughout the election period, or most of it. They can vote by mail. They can, if they are visually disabled, they have the right to go in and vote with a secret ballot through the use of an ingenious template that lets them know that my candidate is the candidate who has whose name is listed third. So I can count down 1, 2, 3, and tick off that ballot. It remains my secret ballot. That's a very clever solution for a minority of the population. But I know, and you can check the Hansards of the committee hearings, that the representative from the Canadian National Institute of the Blind did not know that right existed. My point is, Elections Canada has done a very poor job, a really poor job, of informing people of all the different ways in which they can exercise their franchise. An examination of Elections Canada's own reports on the subject indicate that youth in Canada, who are the group that has the lowest vote participation, indicated that one of the primary reasons they don't vote is because they don't know where to vote. They don't know and are not given that voter information card because they moved recently. And the voter information card, which is Elections Canada's way of attempting to assist you to how to find out where you vote, was cited its absence as one of the key reasons they didn't vote. If there's information, here's how you get yourself onto the voters list. Here's how you can vote in advance. And all the other rights that we have were publicized properly by Elections Canada. I make the modest suggestion that we would see youth voting rates go up substantially and the voting by disabled people and others go up substantially. The CEO is now mandated to engage in a series of these kinds of acts of publicity, which in the past, as I say, he had not done to nearly the adequate level. Mr. Speaker, this bill has been the subject of a great deal of debate, including a motion that was put forward by the New Democrats under the name of the member from Toronto Danforth, I guess it's about a month ago now, in which they expressed particular concern with regard to the ability of certain groups in society to vote if there was requirements that they prove their identity and their place of address. And they cited in particular 3 groups. I want to talk a little bit about how the amendments to this bill have dealt with these 3 groups. The 3 groups they mentioned were seniors living in residence, long-term care in other words, Aboriginal people, and I think by this they meant Aboriginal people living on reserve, although that may not be exactly how the motion was worded. And finally, students living in residence on campus, and how these groups were being, as they felt, potentially deprived of their franchise. You can read the rhetoric of the NDP, which was a little overwrought at the time as to what this meant. Well, even in its original form, I think the bill was pretty good at dealing with people in these categories, but the amendments to the bill did a significant amount to ensure that these individuals will be able to cast their vote. And I would add to these people another group that wasn't mentioned in the NDP motion, and that is the homeless. All of these groups have one thing in common, and that thing that they have in common is that they have moved their residence recently or else are residing in a place where having the normal forms of identification, such as a driver's license, or bills they'd be paying are not readily available, and therefore they find themselves unable to prove their place of residence. Now, in some of these cases, it's obvious that the person is in residence where they say they are. The best example of this is a senior living in long-term care. These are often closed facilities. People cannot come into them because of the fear of spreading pathogens. And so the notion that someone could show up claiming to be John Smith, who lives down the hall, is preposterous. And yet, under the existing legislation, there is a problem that there's no one available who can vouch for them. The administrators are unable to do so. There is a provision for attestations to be given, but for reasons of their own, these residences have on occasion been reluctant to issue such attestations. Homeless shelters, the impression I got from listening to testimony, are in general better at this, and there appears to be a problem where full use of the attestation provisions in the current law is not exercised as much as it should be on some Aboriginal reserves. That would vary from one reserve to the other. But the point here is that dealing with the issue of identity, this bill, through its amendments, specifically through amendments that were made to Section 143 of the bill, this will allow the use of attestations as a proof of residence on a more widespread basis. Some people have called it a kind of vouching for a residence. I'm not sure that's exactly the right way of putting it, but what happens now is that voters can vote with 2 pieces of ID that prove their identity and a written oath as to their residence, providing that another elector from the same polling division who has proved his or her identity and residence by proving documentary proof takes a written oath as to the elector's place of residence. So you still have to prove you are who you say you are, but you don't have to prove by the way that would have otherwise been required. your place of residence. That has now been adjusted and taken care of through this amendment to the bill. That, I think, is very, very significant, and it deals with the fundamental issue, which is not that people would be unable to prove who they are, but rather that they couldn't prove where they live. There were a number of very empathetic examples. Given, Mr. Speaker, in my last 5 seconds, I just want to give one example. A witness before our committee offered the example of a woman who has had to flee her home and is now living with a relative because of an abusive relationship with her spouse. She would be unable to prove her place of residence, her new place of residence. That person, it was suggested, would have been able to vote. That was a legitimate concern, and it has now, Mr. Speaker, been dealt with through this amendment to the law. So I think we have done as much as can reasonably be done to ensure that every Canadian will be able to vote while still ensuring proper security against improper voting by those who are either not eligible to vote or who are voting in the wrong constituency. Thank you, Mr. Speaker.
Questions et commentaires? Questions and comments? Reprise de débat. L'honorable.
Resuming debate. The honourable member for Laurier-Sainte-Marie. Thank you very much, Mr. Speaker. I would like to point out from the outset that I will share my speaking time with my honourable colleague, the member for Victoria, and I would like to take advantage of this opportunity to say that it's an honour and a pleasure for me to share my time with such an active and articulate and involved colleague. Mr. Speaker, unfortunately, I have to say this often. My democracy is hurting. The Unfair Elections Act, which we are debating today, this bill concocted by the Conservatives, is another dark moment and a work which will destroy our democratic institutions. This work is being carried out by the Conservative government. I think we need to better understand the bill, we have to put it in its proper context. Since they have won a majority of seats in Parliament, and I insist on this, a majority of seats in Parliament, which they received under our parliamentary system without receiving a majority of the popular vote, the Conservatives have attacked the very institution of Parliament with a record number of time allocations or closures, and it is quite ironic that we are debating a bill dealing with the integrity of our electoral system under time allocation, despite the fact that this is such an important piece of legislation which, under the British tradition, should be developed by consensus involving all the parties. But even when it comes to this matter, the Conservatives dare and have gone ahead with time allocation. It's quite incredible. In the past, there have been abusive prorogations. We know that the Conservatives refuse to work with the opposition parties, who, nevertheless, we must remember, represent the majority of Canadians. We also know that the government attacked officers of Parliament. It has attacked recently the Supreme Court itself. And nothing is sacred anymore. It has muzzled scientists, officers of Parliament, and people, members of civil society. In fact, they have launched an all-out attack against anyone who does not agree with them. Incidentally, included amongst this group, we have to include Elections Canada. This morning, again, the innuendos made by the Minister for the Secretary of State for Undemocratic Reform. Mr. Speaker, this bill is another attack against, ultimately, Canadians and against their right to vote. It is an attack which, in my view, is the logical extension of the robocalls affair, which the purpose of which was to prevent people from voting. And we know that these calls were made from the Conservative voter database. Luckily, and this must be pointed out, these very Conservatives backed down on some aspects of the bill which were particularly problematic, following the pressure exerted by the NDP and by the exceptional work of my colleagues from Toronto Danforth, Louis Saint-Laurent, and Hamilton Centre. Thanks also, and it's very important to mention this, Mr. Speaker, it was also thanks and especially to all the Canadians, every Canadian who got up, wrote, signed petitions to object to this Conservative maneuvering in the riding of Laurier-Sainte-Marie. There were many people who stood up, and I would like to thank them, to recognize their commitment and determination. As always, I must say it is a huge privilege for me to be their voice here in this chamber. So together, all of us, we have managed to get the Conservatives to back down on certain aspects of their bill. Included in these aspects is the issue of vouching, the use of vouching to vote, the issue of returning officers at polling stations, because under the original bill, the Conservatives wanted to politicize even more the appointment of these returning officers. And to whose benefit would this have been? Well, in fact, the entire bill was designed to the advantage of the Conservative Party.
For example, with the fundraising campaign, where they were allowing more and more contributions to be off the radar screen and not taken into account, if I can put it that way, which would have increased the influence of money in the election as well. Now, we won on that front. We, together, succeeded. We, the Canadian citizens and the members of the opposition in the NDP, won on that front. And we also made some gains with respect to public awareness and education to encourage people to go out to vote. Now, that is an extremely important issue in Canada, as it is in other countries. Having said that, those are the gains that we made. However, there are unfortunately many major problems with the bill. Now, I could talk about a host of problems with this bill, but what I'm most concerned with are the powers for the Chief Electoral Officer. Now, I said that we made some gains with respect to public education and awareness, but it's very limited in the bill that we have before us today, and compared to with what the Chief Electoral Officer could do in the past is very different. Essentially, he will be able to promote the vote in elementary and secondary schools, high schools. I have nothing against that. That's good. But why not have the power to speak to college and university level students who are concerned by this, who will vote in elections? It's completely, in fact, something that we can't understand. Why can't the Chief Electoral Officer encourage young people of a voting age to get out and vote? That's incredible, but at any rate, the Chief Electoral Officer won't be able to or authorized to join forces with other groups, such as Apathy is Boring, which is an extraordinary group. I am familiar with them. I've met with people who initiated or launched the movement. They're doing exceptional work with the people under the age of 25, but the Chief Electoral Office and Elections Canada won't be able to work with them anymore. And here's something else that's ironic, because there are new provisions that will require Elections Canada to cancel Democracy Week in Canada, which they organized, were accustomed to organizing, and that is beyond words. Canceling Democracy Week in Canada because the Conservatives don't like it? Come on. The Chief Electoral Officer will also have to obtain approval by Treasury Board before hiring technical experts. Now, that's something. I like that, Mr. Speaker. We imagine a party that's in power, now charged with electoral fraud, and I'm not alluding to anyone here, but the Chief Electoral Officer will have to go and get a technical or obtain a technical information to investigate, but the Minister of Treasury Board, who's part of the party in power, says no. That is ludicrous. And now I know that I don't have much time, but I'd also like to point out that the powers for the Chief Electoral Officer are being limited. He's not being given any new powers to do his job, such as to compel parties to provide evidence, or to compel witnesses. In short, Mr. Speaker, we prevented some of the damage from being done, but the work has not been completed, and I cannot vote in favor of this bill. Thank you, Mr. Speaker. Questions and comments?
The honourable member for Winnipeg North.
Yes, thank you, Mr. Chairperson. And I wanted to highlight the Commissioner and the Chief Electoral Officer. I found in listening to them make presentation on C-23 that what we saw was the Chief Electoral Officer saying that the Commissioner should remain within Elections Canada. And we all know that the CEO for Elections Canada is in fact a man of great stature, truly independent, and so forth. Then you had the Commissioner come before the committee and had indicated that he was quite comfortable in the current situation being over at Elections Canada and felt that he was truly independent and was favorable to stay there. My question that I have for the member is, why do you think the government took it upon itself and went against the Commissioner of Elections and the Chief Electoral Officer and pulled that office outside of the Elections Canada?
The Honourable Member for Laurier-Sainte-Marie. Well, thank you very much, Mr. Speaker. Yes, it is very troublesome. Everyone says that, well, in fact, both of those say they're comfortable with the situation, but the Minister of Unfair Elections says that if the Commissioner isn't with Elections Canada, it won't be as partisan, as if Elections Canada were partisan to begin with. And they acknowledge the same tradition. Elections Canada has investigated the Conservatives, blamed them, but they did their job looking into the party in power, and the party in power perceives that as being partisan and an attack on them and responds with accusations towards Elections Canada. So that makes no sense, because the Commissioner is being placed under the aegis of the Director of Public Prosecutions, so less sheltered from interference by the government or the party in power. Now, that, too, is a very strange measure.
Commentaire.
Questions and comments?
L'honorable député de Joliette.
The Honourable Member for Joliette. Thank you, Mr. Speaker, and I'd like to thank my colleague for her remarks and for all of the work that she does in this House and in her riding. In this bill, we've seen several areas where key aspects are lacking, where no one agrees with the provisions. In Joliette, people protested a great deal about this approach to reforming or attempting to reform the Elections Act. Now, Elections Canada asked for the authority to compel witnesses to appear before it, but the new bill doesn't do that. The Commissioner will now be working for the Director of Public Prosecutions and doesn't have that authority either. I'd like to know what my colleague thinks about that. The Honourable Member for Laurier-Sainte-Marie. Well, thank you very much, Mr. Speaker, and I'd like to thank my colleague for her question. It's a very pertinent one. We asked the question. We asked it on several occasions. We asked for the Commissioner to be in a position to compel witnesses. There's nothing complex or revolutionary about it. Several provinces do it, countries do it. It's a tool, an additional tool that they could use in order to ensure the integrity of elections in Canada. But I don't think that that is the priority for the government, the Conservative government. Thank you, Mr. Speaker.
8, the honourable member for Victoria.
Thank you, Mr. Speaker. I would like to first of all congratulate my colleague from Laurier-Sainte-Marie for her spirited, indeed passionate presentation on the Unfair Elections Act. I believe we're actually debating the amendment by the member for Toronto Danforth in which he proposed that we decline to give third reading to this bill. And I wish to say at the outset that I'm in hearty agreement with my colleague. Perhaps by way of introduction, I'd like to comment on the process and comment on the implications of this bill in my riding, Victoria. I want to say just at the outset how deeply proud I am of my fellow citizens in Victoria. We had a petition, we had a sign on the window of our office on the main street of Victoria asking people to come in and register their concern with this legislation. And I can say without fear of contradiction that the number of people came in was extraordinary, and they came from all political walks of life. We had members of all political parties come in and express their disdain for this repression, the suppression law that this bill clearly has become. Of course, progressive conservatives such as David Crombie and Mr. Alan Gregg have expressed their concern earlier with this bill as a blatant attempt to suppress votes. And of course, that was loud and clear in one of the cross-Canada meetings that was held in my riding, where we had business people, we had people who were wealthy, we had people who were poor, we had people from all political parties come in and express their deep concern for this law. And I was just so proud of Victoria for speaking up against this atrocious legislation. And as I say, from all political parties and from all walks of life. I think it was the elephant in the room when, in question period, the Minister for Democratic Reform could not bring himself to utter the words Sheila Fraser, who, of course, attacked this, said that this bill was an attack on our democracy. And I think that was telling, that refusal to even acknowledge her, someone who Canadians hold in such great esteem, was an indication of just what they thought of her commentary, and then to trivialize her as somehow because she was being paid or something that was to take away from the serious concerns that this great Canadian had expressed. When our leading newspaper, the Globe and Mail, wrote 5 editorials in a row, and ending in which killed the bill, when newspapers across this country and editorials on the radio said the same thing in different ways, but speaking to their part of the country and the like, it became clear to Canadians that it wasn't just an official opposition that was doing everything it could to stop this bill, from filibustering, and I'm so proud of my colleague from Hamilton Centre, to the enormous work that was done by the member for Toronto Danforth and the member for Louis Saint-Lambert. It was astounding, this upheaval in Canada, this civil society rising up and saying, academics, people in the street, people in all walks of life, this travesty must stop. So I was pleased that the government accepted some of the proposed amendments that were made by the official opposition. We made 100 of them. Of course, the Conservatives let their ideology undermine this once again, and they shut us down in the committee when only half of our amendments were debated, something that should cause Canadians to be deeply, deeply concerned. But perhaps it's not surprising because of the track record of the Conservatives in breaking elections law, overspending by Conservative members, the in-and-out scheme designed to suppress opposition votes, and so forth. And to take and say that the chief electoral officer, an officer of Parliament who is only appointed after consultation with other parties in this House, who enjoys the same kind of independence virtually that judges do, to say that that person was, in the Prime Minister's words, wearing a jersey, close quote, was shocking to a lot of Canadians. Shocking because he was only doing his job, and people understood that. He was trying to prosecute Conservatives for their rule-breaking. That was his job. But perhaps he did it too well, and that is why that attack was levied against an officer of Parliament, something that I think a lot of us found very, very concerning. The minister this morning said the act is widely supported by Canadian people. I don't think he's been to my riding of Victoria to take that position. If he had seen the people on the streets demonstrating against it, if he had come to a meeting which I organized, which had hundreds of people in attendance from all walks of life, he wouldn't have said that. And so the changes that were made, some of them I'd like to comment on, are in some cases very good. And I say that I agree entirely with the minister's suggestion in the bill that now is incorporating these suggestions that there be advance rulings and that there be legal interpretations that other parties could use as precedents. I salute that as an effective amendment and something that we should support. But I still don't understand their perspective reflected in this bill on voter participation. We have a crisis in our democracy of young people not voting. It's a shocking statistic to see that 2/3 of people under the age of 30 don't even bother to show up and vote. And yet the effectiveness of this bill in trying to promote voting was limited to high schools and elementary schools. What about the universities sector? What about the outreach that the Chief Electoral Officer was trying to achieve? That seems to have been shut down in the face of what is our biggest problem, not voter fraud, but voter participation. That, I think, is something that, since the agency can only advertise the basics of the election, needs to be addressed. And I'm so distressed that that continues to be a problem in this legislation. The Chief Electoral Officer can suggest that MPs be suspended for disputes over election spending irregularities, but apparently now they can only do so if the entire appeal process has been exhausted. So therefore, even those cases where there are glaring and obvious errors, overspending problems, we have to wait, and presumably until it gets to the Supreme Court of Canada, which in some cases might have meant the person would be elected for their entire term, given the way our appeal structure, of course, works. That seems to me to be, in some circumstances at least, inappropriate indeed. My colleague from Toronto Danforth, in his presentation, characterized this as a bad bill that is less bad now. I would say it is a terrible bill that is simply now a bad bill in light of the amendments. As Mr. Crombie and Alan Gregg were said to say, two prominent progressive Conservatives, this is a blatant effort to stack the deck for the Conservatives. I think Canadians understand that. For example, the fundraising limits have been raised in this legislation. The fundraising limits now suggest that individual contributions can go from $1,200 max to $1,500 max. Clearly that favors the party that receives the biggest contributions. That would be the Conservative Party. It allows candidates to contribute up to $5,000 to their own campaign. I wonder who that favors. That would be the Conservatives. Every NDP amendment to remove these provisions was of course refused categorically by the government. Those concerns are still with us. Many speakers have talked about the unnecessary separation between the Commissioner of Elections, Elections Canada, and the Chief Electoral Office, and wondered, as the Minister said, there's administration and there's enforcement. But since the Commissioner agreed with that, wanted that, it's hard for us to understand why that change was necessary. In the old adage, if it ain't broke, don't fix it. And in addition, the powers that Commissioner has were also sought in order to, like Section 11 of the Competition Act, compel witnesses, as is done in other provinces and other countries routinely. And that was also sought by the Commissioner, and the government, of course, would have none of it, and moved it outside of the Elections Canada apparatus, and now has to, at the last moment, change it to have information sharing agreements to deal with the problem they created in the first place through an absolutely unnecessary and uncalled for amendment. So in conclusion, Mr. Speaker, I would support the amendments of the member for Toronto Danforth that we decline to give third reading to this bill. I wish we were not in this state. I wish the government hadn't moved closer to limit debate on one of the most fundamental bills in our democracy, but here we are, and I sadly rise in utter opposition to this voter suppression legislation. Thank you.
Questions and comments? The honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. And if I can pick up on the member's concluding comments where he's talking about, just how sad it is, the whole manner in which this bill has gone through a terrible process, given the very fact that it's an election law that we're talking about, and you have the Conservative majority government using its majority, not doing the consultation that's important to do, and just not working with the different stakeholders on the issue. In fact, Mr. Speaker, I think it bears repeating that we had numerous amendments that were brought to the committee, and a good percentage of those amendments were never debated when the motion was called. A good number of those amendments, Mr. Speaker, were quickly tossed to the side. Why? Because at the end of the day, the government moved in a motion to put a May 1 deadline, 5 o'clock. It didn't matter where the committee was in terms of its stage, and it speaks volumes in terms of even second reading, time allocation. Third reading, what we're in today, time allocation. This government has taken upon itself to ram through this Conservative election bill. And I'm wondering if the member might just want to provide some additional comment in terms of just the management of what is one of those fundamental pillars of our society, and that is our democracy and the importance of election laws.
The honourable member for Victoria.
Thank my colleague from Winnipeg North for his very thoughtful commentary and question. The process that has accompanied this organic law, this one of our fundamentals of our Canadian democracy, is nothing short of appalling. And, of course, hundreds of academics from Canada and around the world called attention to that. And I think the record speaks for itself, Mr. Speaker. We had closure, or time allocation as it's called, imposed very early on in the process. The NDP provided 256 questions, along with our cross-country hearings, which, of course, the government chose not to support, indeed to attempt to squelch. And in addition to all of that, Mr. Speaker, the filibustering that was necessary, the fact that half of the questions on amendments that were they weren't even allowed to be debated in the committee, speaks volumes as to the disdain for which the government addressed our amendments, opposition amendments to improve this bill in good faith. If it wasn't their idea, it couldn't be a good one, so none of the amendments in committee were accepted except those that dealt with grammar and the like. It's shocking.
Honourable member for Pierrefonds-Dollard. Thank you, Mr. Speaker. I would like to also thank my colleague for his speech. He talked about how the bill was dealt with in committee, in particular the fact that amendments were raised. I would like his opinion on how the witness presentations were received. We had some 70 witnesses that appeared on this bill, but despite the fact that there was almost unanimity against the measures in the bill, it seems that those objections weren't taken into account by the Conservatives when it came to a number of amendments. For example, having the Chief Electoral Officer be able to investigate possible wrongdoing. There were amendments and changes that were proposed, but none of that is reflected in this bill at third reading. Was the point just to invite people, let them have their say, and go ahead with what the Conservatives want? Or isn't the idea usually to be able to take into consideration the expert advice given?
The honourable member for Victoria.
Thank my colleague for her question, and the way in which this bill was addressed in committee was shocking. We're always told in this place that we should wait and do the hard slogging, the clause-by-clause analysis, and hear from expert witnesses at committee, because that's where we can improve the bill. That's the way in which it's supposed to work. But in my short experience in this place, amendments proposed by the opposition are virtually never accepted, because if it wasn't the government idea, it couldn't be a good one. And I think that's reflected in spades in what happened in the Procedure and House Affairs Committee during the process of this debate. We invited people, experts from across the country from different perspectives to make their presentations. They spoke as one on the need to change key elements of this bill, and all of their efforts were in vain. Nothing was accepted. Half the amendments never even got debated.
Resuming debate, the honourable member for Don Valley West.
Well, thank you, Mr. Speaker. It's my great pleasure to rise today to speak in support of Bill C-23, the Fair Elections Act. If I may, I'd like to take this opportunity to outline how this bill will be of great benefit to our democracy. Mr. Speaker, our government understands that the integrity of Canada's voting system is paramount to our democracy. It is vital that we protect the integrity of the system so that everyday Canadians remain in charge of our democracy. That's why, Mr. Speaker, the Act has been met with support by Canadians from coast to coast to coast. My honourable colleagues have spoken at length about the many facets of this landmark legislation. The Fair Elections Act will ensure that our elections are fair and democratic. As members of all parties, we are entrusted by Canadians to act in the interest of protecting the integrity of our electoral process. The Fair Elections Act, Mr. Speaker, provides all members an opportunity to uphold that obligation. I'd like to add that the government undertook extensive consultations in drafting this legislation. The bill brings to light concerns raised by Canadians, various groups and think tanks, Elections Canada, and parliamentarians themselves. The Fair Elections Act addresses those concerns and would improve the system by introducing a new standard of consistency. We promise to examine the bill with openness to ideas that would strengthen this common sense bill. That's why, Mr. Speaker, on April 25th, the government announced it would support the amendment to support amendments to the Fair Elections Act. The committee has had a long and extensive study of Bill C-23. There have been 15 meetings, amounting to roughly 31 hours of study. In addition, there have been 72 witnesses that appeared at committee to offer insight into how we could further strengthen this bill. I'd like to begin by discussing the issue of vouching. First, I want to emphasize an important element of the Fair Elections Act, which is the changes that it will make to the identification process. As it stands, the current system has been unable to preserve the integrity of the electoral process. In fact, Mr. Speaker, serious errors of a type the courts consider, quote, irregularities that can contribute to an election being overturned were found to occur in 42% of cases involving identity vouching. Overall, the Neufeld report estimates that irregularities occurred for 1.3% of all cases on election day voting during the 2011 federal election. More than 12 million Canadian citizens cast ballots, and the audit indicates that the applications of specific legal safeguards in place to ensure each elector is actually eligible to vote were seriously deficient in more than 165,000 cases due to systematic errors made by elections officials. Averaged across 308 ridings, elections officers made over 500 serious administrative errors per electoral district on election day. These levels, Mr. Speaker, are just too high. We must recognize that a fraudulent or illegitimate vote has the same mathematical effect as denying honest Canadians their constitutional right and privilege to cast a ballot. The Neufeld report cites cases of fraudulence and irregularities that are far too high. We cannot let the electoral system continue in its current flawed trajectory. That's why the Fair Elections Act will finally end the use of vouching as a means of identification. Our government believes that it is important to let every eligible voter cast a ballot. By the same token, we believe that fraudulent voters should be ineligible to cast a ballot. The safeguards that current laws establish to halt fraudulent voters were violated in 50,735 cases, 42% of the time, in the 2011 election, according to Election Canada's own compliance report. We cannot continue to abide by the current vouching procedures and expect different results in future elections. It is evident that changing times have brought about changing threats to the integrity of the electoral process. That's why, Mr. Speaker, I'm pleased with the direct manner in which the Fair Elections Act proactively keeps up with changing conditions. Mr. Speaker, the Fair Elections Act represents a giant leap forward in ensuring that the integrity of the electoral process is upheld. The bill will require voters to choose from some 39 pieces of acceptable identification to prove their identity and residence. Photo ID will not be required. Again, photo ID is not required, but simply having someone vouch for a voter's identity with so much as a utility bill to back it up will no longer suffice. While the Fair Elections Act will require people to show ID excuse me, proving who they are before they vote, we support an amendment to help people whose address is not on their ID. If someone's identification does not have an address on it, they will need to sign a written oath of residence. Another voter with fully proven ID will be required to co-sign the oath attesting to the voter's address. This will only be required for people whose identification does not have an address. Mr. Speaker, this is one of the reasons why Canadians overwhelmingly support this bill. In fact, 87% of Canadians believe it is reasonable to require someone to prove their identity and address before they can vote. Mr. Speaker, as a resident of Ontario, I recently had the opportunity to apply for a new OHIP card in my riding of Don Valley West. In applying for Ontario health insurance, you must provide proof of citizenship, proof of residency, and supportive identity. That's 3 pieces of identification. With that level of scrutiny required for an OHIP card, it is only right to support a bill that requires a similar level of identification to provide for voters in our federal elections. What our government will not support is the opposition suggesting that people shouldn't require any ID to vote. Mr. Speaker, this is another reason why Canadians are on board with this bill. According to an April 24, 2014 Ipsos poll, 70% of Canadians believe it is acceptable to eliminate vouching and require voters to personally prove their identity and address before voting. Our government believes that in a democratic country, all eligible citizens have the right to participate in making the decisions that affect them. The Fair Elections Act will ensure that an honest vote is not denied by fraudulent votes. The fact is, Mr. Speaker, the Fair Elections Act represents a giant leap forward in ensuring that the integrity of the electoral process is in fact upheld. Another important element of this bill, Mr. Speaker, is that it will separate the Commissioner and the Chief Electoral Officer. Quite simply, Mr. Speaker, the Commissioner of Elections Canada should not serve at the pleasure of another official. He should have control over his staff and his budget, and no one should have the power to dictate what he investigates. It just makes sense that the Commissioner should not work for one of the entities he might investigate. This is in keeping with basic fiduciary accountability and standards that government departments and institutions use to ensure their functions are carried out properly and ethically. Our government understands that separating administration from enforcement is vital to upholding the integrity of our electoral process. That is precisely why the Fair Elections Act will house the Commissioner with the Director of Public Prosecutions. Their elections law enforcement will be held under the auspices of a strong Commissioner. We have made him completely independent by giving him authority to investigate offences. The Commissioner will also be afforded full independence with regards to being in charge of his own staff and his own investigations, as well as a fixed term of 7 years whereby he can't be dismissed without cause. We gave him new offences to help him in his investigations, such as obstructing an investigation and providing false information. Our government also supports an amendment giving the Commissioner the unrestricted ability to begin investigations by removing the bill's proposed evidence threshold before the Commissioner may begin an investigation. Working in different entities, our government understands that a line of communication between the Commissioner and the Chief Electoral Officer will be required to perform their duties effectively. As a result, our government supports an amendment allowing the Chief Electoral Officer and the Commissioner of Elections Canada to exchange information and documents. Meanwhile, the CEO currently has the power to adapt provisions of the Elections Act during emergencies. It is highly unusual to give an unelected agency head the power to rewrite any section of an Act of Parliament. Our government believes that the purpose of this power should be limited to protecting the right to vote, which is in line with basic democratic principles. In addition, members of all parties have complained that the rules are unclear and complicated. Complicated rules cause unintentional breaches and intimidate Canadians from taking part in democracy. That is why the Fair Elections Act will make the rules for the Chief Electoral Officer clear, predictable, and easy to follow. The Fair Elections Act will continue to equip the CEO with key responsibilities, especially as they relate to educating voters. That is why our government supports an amendment with regards to the education mandate of the Chief Electoral Officer. The Chief Electoral Officer may communicate with the public, where he advertises to inform electors about the exercise of their democratic rights. He can only do so on how to be a candidate, when, where, and how to vote, and what tools are available to assist disabled electors. Further, the CEO may support civic education programs for primary and secondary schools, something that I know in my writing, Mr. Speaker, is a very important element. Mr. Speaker, I am pleased with the direct manner in which the Fair Elections Act and its amendments will establish ethical and fiduciary investigative independence that is in line with good governance. Another essential element of this bill, Mr. Speaker, is that it will redirect Elections Canada back to its core mandate. As recent elections have shown, Canadians are participating less and less in the voting process. In my constituency of Don Valley West, 67% of eligible voters cast a ballot in the last federal election. Federal voter turnout, however, was even lower at 61%. Since Elections Canada began promoting voter participation campaigns, turnout has actually plummeted from 75% in 1988 to a low of 61% in 2001, where it has stayed. The facts show, Mr. Speaker, that Elections Canada's campaigns are not working. As a result, the bill will amend Section 18 of the Canada Elections Act to focus all of Elections Canada promotional campaigns on two purposes: informing people of the basics of voting, again, where, when, and what ID to bring, and informing disabled people of the extra tools available to them to help them vote and participate in their democracy. Let me be clear. Elections Canada will continue to be the organization responsible for the administration of our elections. However, the job of generating interest will be left to aspiring candidates and parties. Government bureaucracy should continue to focus on administrative functions and leave the duties of generating interest to the parties and the candidates. That is why the Fair Elections Act will allow parties to better fund democratic outreach with a small increase in spending limits, while imposing tougher audits and penalties to enforce those limits. Aspiring candidates and parties, not a government agency, have a duty to reach out to voters, to inspire them and give them something worth voting for. It is time for the agency to get back to the basics while political parties get down to the work they are prescribed to do. Finally, Mr. Speaker, the Fair Elections Act will introduce additional measures to crack down on lawbreakers and fraudsters. This would strengthen the penalties for election lawbreakers. This includes introducing prison time for serious offenders and tougher fines for rule breakers. For example, anyone caught bribing or obstructing an election official could receive upward of 5 years in prison, and anyone who makes a false statement could be fined up to $50,000. Investigators would also be afforded more extensive capacities to fulfill their mandates, such as the introduction of a number of new rules that will close loopholes, crack down on influence of big money, and help stop the election fraud that jeopardizes the system. This includes enhanced protection for voters against robocalls, cracking down on voter fraud by prohibiting vouching, and banning the use of loans used to evade donation rules. In addition, Mr. Speaker, the Fair Elections Act will introduce guidelines for clear and transparent tracking and records retention of telemarketing, which will help prevent rogue calls and voter deception. It will also introduce new measures to track mass calls to protect voters and prevent fraud by creating a mandatory public registry for voter contact services by telephone. The Fair Elections Act will make it an offense to impersonate an election official and increase penalties for deceiving people out of their votes. That is why, Mr. Speaker, the Fair Elections Act is a major improvement of the status quo. It is clear that Bill C-23 is not only constructive, but it also is very reasonable, and we are moving forward. In closing, Mr. Speaker, this bill will make it harder to break the law and easier to vote, not to mention closing loopholes to big money. Election laws will be tough, predictable, but easy to follow. Life will be harder for election lawbreakers and easier for honest citizens who merely wish to take part in their democracy. Our government continues to be a leader when it comes to enforcing greater accountability in politics. When we first took office, we passed the most comprehensive anti-corruption legislation in Canadian history, the Federal Accountability Act. This important legislation increased oversight, cracked down on lobbying, and expanded transparency in government spending. Now, through the Fair Elections Act, we are building on that strong record and helping ensure Canada's democracy remains strong and its integrity upheld. The Fair Elections Act is an important step forward towards greater transparency and accountability in our elections. These meaningful changes would help strengthen Canada's electoral system and help ensure that our democracy remains in the hands of everyday Canadians. That is why I vote in favour of the Fair Elections Act, Mr. Speaker, and I hope my colleagues on both sides of this House will join me in doing the same. Thank you, Mr. Speaker.
Questions and comments. The Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker, and thank you to my colleague for his speech. A little earlier, he talked about powers which would allow investigators to do their work in case of suspected fraud. However, it seems we're not interpreting these provisions the same way, because we don't feel that there are enough powers to allow for the effective conduct of investigations of alleged electoral fraud. I think we all here in the House recognize that fraud was committed in 2011 and that we need to give the proper tools to people who investigate. Until now, we still have not been able to identify those who are responsible for the fraud in 2011. So by going over some of the testimony, the Federal Elections Commissioner in his 2012-2013 report said that it was important to be able to compel testimony. The Chief Electoral Officer of Canada also talked about more powers, that is, the powers to ask for receipts for campaign expenses. These two things are not contained in the bill. Does my colleague feel that these people, the Chief Electoral Officer and the Electoral Commissioner, don't know what they're talking about? Is a political party less partisan than these independent experts asking for these things?
Well, thank you, Mr. Speaker, and I thank my colleague for her question. Respectfully, I disagree with the premise on which the question was launched. The Commissioner and the CEO, Mr. Speaker, are being separated according to the bill. Under good governance, fiduciary responsibility that's now entrenched in so many parts of our society, it's important that premise be maintained and underpinned in everything we talk about today. We do that from the perspective of separating the Commissioner in managing the process, the CEO in managing the process, and the Commissioner in managing investigations, etc. The Commissioner will have the same powers as he does today and the same powers as the RCMP. We agree that the Commissioner must be free to do his job without impediment, and that's why the separation of the two, falling with the Commissioner now working under the Director of Public Prosecutions, and that way I feel very, very reasonably being able to operate in an unfettered environment and according to the fiduciary standards, again, that are inherent in our society today. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Lac Saint-Louis.
One aspect of the member's speech when he talked about what is required to obtain an OHIP card. I'm just wondering if we're not comparing apples and oranges here. When it comes to OHIP cards, you know, we know that unfortunately people over the years have tried to defraud OHIP, but it's a very different case from trying to vote illegally, because in the case of defrauding OHIP, there's an actual financial benefit to the person who would defraud the system. But when it comes to committing election fraud, when we're talking about one person who is voting who would not have the right to vote, you know, it's not benefiting that. First of all, it's not a financial benefit, and secondly, it's not benefiting that person directly. It's benefiting maybe that person's candidate or party or what have you. So I don't think it's a fair comparison. I'd like the honourable member's comment on that.
The honourable member for Don Valley West.
Well, thank you, Mr. Speaker, and thank you to my colleague. Let me be clear. I didn't want to use the comparison to necessarily say that one equals the other. Clearly, there are differences between OHIP and the right of a voter. In fact, I believe the privilege and the right to vote is more important than any other democratic standard we have available to Canadians in this country today. I merely pointed out to the degree that from an identification process, the Ontario Health Insurance Program has rigid rules and processes in place where you simply can't get a health card without three very well-defined pieces of identification, including photo identification. I believe very consciously that our right to vote is the greatest privilege we as Canadians have today. And so to that end, I believe that we must take very, very seriously the identification processes, the issue of eliminating vouching to the degree that we have for identity, as a mandate to ensure that we uphold the very highest level of electoral standard that we possibly can. And clearly, I believe that I've outlined that in my presentation today. So thank you to the member opposite.
Questions and comments? Honourable Minister of State for Sport.
Well, thank you, Mr. Speaker, and I want to thank my colleague for an excellent speech, an excellent interpretation of Fair Elections Act, and it's greatly appreciated by Canadians all across, traveling around talking to them. identification he talked about. One thing I would like to ask my colleagues is, when he went back to his riding, consultant with the people who elected him, what were their views on this Fair Elections Act? Thank you.
The Honourable Member for Don Valley West.
Well, thank you, Mr. Speaker, and thank you to my honourable colleague. And a very good question, because I was involved actively at the grassroots level talking to my constituents. And clearly there's been opinions on both sides, but far exceedingly, anytime I talk to my constituents in Don Valley West about vouching, they mirrored or exceeded the 87% of Canadians that were polled in the Ipsos poll of April 24th that said that it is a reasonable expectation that identification should be proven by the voter. And so when I talk to Canadians within my riding across the City of Toronto, in fact across Canada as I've had opportunity, including, I should add, leading in my riding, I led a roundtable discussion on this very issue at the Canadian National Institute for the Blind to address issues of disability voting or voting for the disabled, in this case the sight impaired and the blind. And clearly our position on this is well entrenched in the minds of the people that I talk to, and they're very, very supportive. So thank you to that question.
Questions and comments? The Honourable Member for Marc-Aurèle-Fortin. I appreciated the speech given by my distinguished colleague, with whom it's always a pleasure to work. My problem, however, is that this bill, it has been presented without the prior consent of this Parliament, and it's the first time in the history of this country that one political party introduces a piece of legislation which, and pardon the expression, is very favorable to its own re-election. Generally, to be credible in the eyes of all Canadians, electoral legislation must not only be independent, but it must also have the appearance of being independent. And in that regard, this bill, C-23, admirably misses the target. All of the stakeholders, editorialists, witnesses, representatives from the legal community, experts in electoral affairs, everyone has said that this is a bad bill. Certain amendments were introduced, and thank God, because we've gone from an unacceptable and undemocratic bill to a bad one. Nevertheless, it is still bad for the simple reason that no one else but the Conservatives approve of it. Does my colleague find it normal that such an important piece of legislation be introduced without consensus?
Well, thank you, Mr. Speaker, and thank you to my colleague opposite. Mr. Speaker, in my presentation, in my speech, I talked about the extent to which the committee opened the doors and heard the views of Canadians, and many eminent and very well-respected Canadians who took the time and energy to come to Ottawa and to present their testimony as witnesses at committee. In my numbers, just to reflect briefly, the committee had a long and extensive study with 15 meetings, accounting for roughly 31 hours of study. This was no trivial exercise. This was an extensive study in the House, and there have been 72 witnesses that appeared at committee. And I should also mention, Mr. Speaker, that to my honourable colleague's comment, we allowed every single witness that the opposition brought forward to committee to testify. I think that's an incredible statement. Now, they ran hearings across the country, and they brought a series of witnesses that that the government, the committee itself, opened the doors to and clearly heard from. I believe, Mr. Speaker, that democratic process has been well entrenched in this bill, and that the hearings of Canadians, hearing their opinions, has more than adequately been met. Thank you, Mr. Speaker.
Resuming debate. The Honourable Member for Saint-Bruno-Saint-Hubert. Thank you, Mr. Speaker. Once again, the Conservatives have shown their disdain for our democracy by shortening debate on a bill as important as electoral reform. Bill C-23 would seriously change the quality of our democratic institutions without prior in-depth public consultations, even with essential experts, including the Commissioner of Elections and the Director of Public Prosecutions, or even the Chief Electoral Officer. In fact, this is purely and simply a partisan maneuver on the part of the government, which sees in this bill a way to stay in power. The bill is an attack against the democratic right of vulnerable populations. Today, if a voter wants to exercise his or her franchise, they can vote with the help of someone who will vouch for their identity. The Minister for Democratic Reform wants to eliminate vouching on the pretext that 1 out of 6 voters might receive a voter information card with mistakes, and some voters might therefore vote in a riding other than theirs, or even vote several times. But instead of fixing the problem, the government has decided to eliminate vouching, and this will have serious consequences on certain groups. In the course of the last election, Elections Canada made a special effort to use voter information cards in various contexts to increase the number of people eligible to vote amongst groups who usually don't vote as often as others, such as Aboriginals on reservations, young people on campus, and seniors in residences. This method, the voter information card, along with one piece of ID, this method, which will be abolished, was used successfully during the last election and received an unbelievable amount of positive feedback. The minister likes to repeat that 39 different pieces of ID will be authorized to voters to prove their identity, but what he forgets is that some of these ID pieces only contain the address of a voter. For instance, a person's health insurance card does not have a person's address, or a passport, student card, and many other pieces of ID. Therefore, many people will have to present 2 documents if they want to vote. And these documents, these pieces of ID, will have to be on the list. As we all know, the rate of participation at elections is in free fall in Canada. Why does the government therefore want to make it harder for senior students and Aboriginals living on reserve to vote by prohibiting the use of voter information cards as a proof of address? There's another thing which worries me about this bill. This bill would impede progress in the area of electronic voting. Elections Canada will have to ask for the authorization of Parliament to set up pilot projects for electronic voting. Elections Canada has the mandate to improve our electoral system, and electronic voting would make it easier for seniors and people with disabilities to vote. But again, the government has turned a deaf ear and is putting obstacles in the way of Elections Canada. However, the government will amend the bill with regard to election financing rules. This is a barely veiled maneuver on the part of the Conservatives because they are only serving their own interests. By increasing the maximum donation limit from $1,200 to $1,500, the Conservatives are going against what they are claiming they want, which is to reduce the influence of money in elections. Further, the fact that a candidate will be able to invest $5,000 in his or her own campaign will mean that wealthier candidates will have an advantage. Is this what democracy is all about, Mr. Speaker? The NDP has proposed about 100 amendments to improve this bad bill, but no substantive NDP amendment was retained by the Conservative Party, which of course had a majority on the committee. One of these amendments was to eliminate this financial provision. But as with the majority of the NDP amendments, this one was rejected, unfortunately. In a sign of disdain for Canadian democracy, the Conservatives have closed down the work of the committee which was studying the Unfair Elections Act, even though half of the amendments proposed by the NDP had not even been debated. Mr. Speaker, this government, since it was elected, has done nothing but infringe on the rights of our citizens. It has abused its majority position to impose bills which do not serve the interests of Canadian men and women. This debate is a charade. Once again, Mr. Speaker, the Conservatives have imposed time allocation. This will prevent us once again from studying in depth the electoral bill. It is shameful to see how the government is acting and preventing us from fulfilling our parliamentary duty. We are being muzzled, Mr. Speaker. The government has to know that when it wants to amend the Elections Act, it must obtain a consensus first. It must not engage in the tyranny of the majority to impose changes which meet its own needs. I'm sorry, Mr. Speaker, but I would like to let you know that I will be sharing my time with my colleague for Châteauguay-Saint-Constant. Mr. Speaker, the Conservative government wants to make it harder for Canadians to exercise their franchise, especially the most vulnerable Canadians, and especially those who do not agree with their conservative ideology. This is a form of discrimination which harks back to certain American practices carried out under the reign of U.S. President Bush. How can we encourage our constituents to vote, to participate in the democratic life of their country when their institutions are being violated? Of course, I object to this bill, and I would invite all of my colleagues to do so as well in the name of democracy. Thank you very much.
Questions and comments? Question et commentaire, l'honorable député.
The Honourable Member for Drummond. Thank you very much, Mr. Speaker. I'd like to thank my colleague for her excellent speech. She did a remarkable job to explain the non-democratic nature of this bill. Now, this change to our democratic institutions doesn't take into account consensus. There was no consultation of the opposition or the political parties, etc. As you know, in Quebec, the province I represent, changes were recently made so that funding for institutions were dropped to $100 per person. $100 per person instead of increasing those amounts. Why did they do so? Well, in fact, to avoid the influence of big corporations, big money, who can subsequently ask for benefits because they would think they are owed that because of their contributions. Mr. Speaker, the act was adopted unanimously in Quebec. There were consultations before they went ahead with that, but unfortunately the Conservatives didn't do their homework. They didn't seek out a consensus so that they could have good legislation, a good democratic reform that would have been in the best interest of Canadians. Unfortunately, the Conservatives, with this bill, are not representing Canadians. They're only representing themselves, and that is deplorable. When a party forms a government, they need to represent all Canadians and not just Conservatives. This is a comment that I wanted to add to the excellent remarks made by my colleague. I'd like her to perhaps comment on this position, the need for a consensus when undertaking a reform to elections and to our democracy, so as to, and the importance, in fact, of reducing donations by citizens instead of increasing them. The Honourable Member for Saint-Bruno-Saint-Hubert. Well, thank you, Mr. Speaker, and I'd like to thank my colleague for his very pertinent comments. his very explicit comments. As he said in Quebec, we are currently working on transparency and on reducing the influence of money in politics. Unfortunately, since we came to this House, what I have the impression is that this Conservative government is disconnected from reality, or it has blinders on. With tunnel vision, it focuses exclusively on its objective for Conservatives, and they're not taking action in the best interest of Canadians. Again, today we are debating, and it's a masquerade. Things need to change. We need to have discussions. This is the Parliament. And in French, Parliament contains the word parler, which means dialogue or to speak together. And that is not something this government is doing.
Comments, the honourable member for Winnipeg North.
Yes, Mr. Speaker, I'm wondering if the member could provide comment on the fact that when we make changes to the Elections Act or to the Parliament of Canada Act, that they are fundamental to our democracy and should be achieved. In fact, they must be achieved by a broad consensus. And ultimately backed by solid evidence. This is something in which we, within the Liberal Party, would advocate for in the strongest of ways. And my question to the member is just, given the manner in which this legislation was brought into the House of Commons, to the point where we are today, once again, through closure, the government is forcing the vote a little bit later on today. And I'm wondering if she might want to provide comment on just how important it is when you pass these type of pieces of legislation that it should have been done on a broader sense of consensus, and as opposed to the manner in which this majority Conservative has used its majority in order to push through this Conservative Election Act without any consultation from organizations such as Elections Canada and many other stakeholders, including political parties that are in opposition to the government.
L'honourable deputy.
The honourable member for Saint-Bruno-Saint-Hubert. I thank my colleague for his very pertinent question. As I mentioned earlier, under this government, there is no transparency. Everything is being done in secret and in the interest of Conservatives. Of course, we can no longer have confidence in the Conservatives, nor in the Minister of Democratic Reform, when it comes to improving the rights in an election. We know that the committee was interrupted before all amendments were dealt with, and it's unfortunate, as has been mentioned several times, the government is using its majority to impose a tyranny, if you will, on the Parliament in this. Resuming debate. The honourable member for Châteauguay-Saint-Constant. Well, thank you very much, Mr. Speaker. Today is a very dark day, it being the last day of debate on Bill C-23, which we call the Unfair Election Act. It was tabled not with a view to strengthening our democracy and our election system in this country, but to make changes to benefit the Conservatives in the next election, including a strategy to suppress the vote and to continue to skirt around election laws without being concerned. It is simply scandalous to see what the government is doing here today, Mr. Speaker, by using a steamroller approach to deal with the opposition parties. This is the first time in Canadian history that the government's using its majority to impose undemocratic changes without reaching an agreement with anyone, without any of the opposition parties' agreement, nor the agreement of society. We are unanimous. All voices are unanimous. Everyone opposes the bill. Rarely have we seen all segments of civil society join forces to so vocally oppose legislation from the government. This bill is undemocratic, and the way that it was tabled and introduced and debated, etc., in this House, Mr. Speaker, is as well. Because, as the Conservatives continue to do. They sidestepped the democratic process. Canadians are being deprived of their due process, and the Conservatives have taken this action. They impose time allocation and have limited debate. And this is my first opportunity to speak on the bill, not because I didn't want to speak to it, because they have limited debate on legislation, Mr. Speaker. In addition, other colleagues would have been interested in speaking out against this bill as well. They also put an end to the committee proceedings when it was being examined there, this Unfair Election Act, even though more than half of the amendments being put forth by the NDP weren't debated. At the committee stage, Mr. Speaker, the first version of the bill was scandalous in nature. This one isn't as bad. It's still scandalous, but it shows, in fact, that the government has no respect for democratic institutions, because changes were proposed. We had proposed them at committee as elected officials. We wanted to make changes to democracy in this country in fact, they put the bill to the Senate first. So they presented their potential amendments to the Senate side, where the senators are unelected, and this would affect the elected members of this place. That defies logic, and it shows what kind of respect that government has for democratic institutions. Now, the Conservative government rejected amendments that would give voters the tools that they need in order to deal with election fraud, to preserve Elections Canada, and to give the Chief Electoral Officer the right to encourage Canadians to go out and vote. The Minister of Democratic Reform didn't even consult the Chief Electoral Officer on this bill and misled the House during question period by saying that he had consulted, when that was completely false. Following that, the minister attacked Elections Canada, and more recently he took umbrage with the Chief Electoral Officer and attacked him, as he has attacked other officers of Parliament, and this is completely scandalous on the part of the government, Mr. Speaker. Unacceptable. For years they've criticized Elections Canada, saying that it's biased and partisan in the way that it denounces the lack of respect for elections law by the Conservatives, because, as you will recall, they were caught with the in-and-out scandal. And basically, to explain it to Canadians, we have a contribution limit for each election. They sidestepped that by sending money into the riding associations, because they have a ceiling of $90,000, and then they had their advertising bills paid off by the riding associations. It was supposed to be paid off by the National Party, but they sidestepped those rules. They got caught. They pleaded guilty, and with this bill, they're going to continue to sidestep elections legislation and the law without worries of being investigated by the Chief Electoral Officer or the Commissioner of Elections, who doesn't have the adequate authority to investigate. So they're going to continue to commit fraud without being concerned. Now, bear in mind as well that the Conservative database was what was used in order to send voters to the wrong polling stations. So instead of respecting the Elections Act, the Conservatives decided to attack Elections Canada by limiting its investigative powers, despite the fact that they had voted in favor of one of our motions in 2012, which called upon the government to increase powers for the Chief Electoral Officer with respect to investigative powers. Now, despite the fact that the Conservatives voted in favor of that, the powers were taken away from the Chief Electoral Officer, and they are simply skirting around these aspects. Now, this bill doesn't have the support of any opposition party in this House, nor does it have the support of civil society. Canadians from across the country have joined forces to speak out against this bill, and in light of the backlash, the Conservatives had no choice but to back down on some of the fundamental aspects of their initial proposal. With those concessions, the NDP showed that it was a strong opposition and worthy of being the government in waiting, and that's what we are, Mr. Speaker. We won't be a government in waiting in 2015. We will form the government. We called for these changes, in fact, to enhance the powers of the Chief Electoral Officer in the wake of all the scandals we saw, not to do what the government is doing, and the NDP is taking a stand to protect democracy in this country. And when the government attacks our democracy, the NDP is there to hold it to account, to hold the government to account to Canadians. Now, one of the aspects of the bill that the government partially backed down on was with respect to the participation of the Chief Electoral Officer in awareness campaigns to increase the voter turnout, because the rates are in free fall, Mr. Speaker. The turnout is low. The government, with its measures, wanted to ensure that it would be even lower with the measures it put forth. The CEO will not be allowed to make all Canadians aware of the importance of voting. The CEO will only be able to go to speak to certain aspects of the voting process, where and when to vote, for example, and the authorization is limited to that. So the CEO won't be able to work with certain groups in order to encourage people to participate in the vote. And we consider these awareness campaigns and educational components so important. They're a fundamental part of the Chief Electoral Officer's duties. But the Conservatives are doing opposite. This will result in a lower participation among young people, Aboriginal people, seniors, etc., because these are groups that won't go out to vote as much because their votes won't be recognized or acknowledged in certain ways. Now, there's also Democracy Week in Canada, which is organized by Elections Canada. It will no longer be possible for Elections Canada to organize Democracy Week, this important awareness of democracy event that takes place. Another aspect of the bill requires the Chief Electoral Officer to seek the approval of Treasury Board to hire experts for conducting an investigation or to write reports on robocalls, for example. So this means that Treasury Board will interfere in the independence of this elections responsibility and will have an impact. Elections Canada won't be completely independent, and that is unacceptable, Mr. Speaker. Now, as I mentioned in the past, one of the objectives of the bill was to suppress the vote. It would ban the use of the voter's identification card as proof of address, and this provision will create serious problems for people who are having trouble establishing their address the day that they have to go and vote. Students, for example, will be seriously affected by that, seniors as well as Aboriginal communities. Since I have very little time left, Mr. Speaker, I would like to point out that since the start of this procedure, we have been opposed to the bill, and we will continue to oppose it to the end, right through. Till the end, we will attack this unfair practice by the government, which is in place to ensure that they are re-elected in the next election.
Member for Winnipeg North.
Yes, thank you, Mr. Speaker. And I think, as we've pointed out in the past, one of the greatest deficiencies within this legislation is the government's failing to recognize the importance of compelling a witness. And what we saw in the last federal elections was literally thousands of Canadians from all across our country that expressed concerns in regards to public confidence, if I can put it that way, Mr. Speaker, in the last federal election. One of the ideas that came out of that, Mr. Speaker, was that the Elections Canada needed to have the ability to compel a witness. Many groups, independent associations, I see my former colleague, the former MLA from Burroughs in the gallery. You'll recall that Elections Manitoba has the authority to be able to compel a witness, as an example. There are other jurisdictions that have that authority to be able to compel. When we had the Chief Electoral Officer
come before the committee along with the commissioners of elections, they both felt that it was important in order to strengthen our election laws that they have the ability to be able to compel a witness. The government has decided not to enable them to have that ability to compel. Thereby, I would argue, and we would argue within the Liberal Party, that it is a fundamental flaw within the legislation. And we've challenged the government to allow for
The Honourable Member for Châteauguay-Saint-Constant. Well, thank you very much, Mr. Speaker, and I'd like to thank my colleague for his comments and his question because, in fact, that is one of the major problems with this bill. It's a tactic, indeed, that the Conservatives used in the last election, a tactic that was borrowed from not the Democrats, but the Republicans in the United States. In 2001, the Bush government used the tactic to suppress the vote. They knew that if they called the voters to tell them that the polling station had changed locations, and as a result, 1 out of every 3 wouldn't go and vote because they thought that their polling station had moved, it was too far away. So Elections Canada, with the scandal, showed that they didn't have the power to investigate and to compel witnesses to appear, and they didn't get the cooperation that they needed, well, in fact, that with respect to the use of the Conservative database for that misleading tactic. Questions and comments? The Honourable Member for Saint-Bruno-Saint-Hubert. Well, thank you very much, Mr. Speaker, and I'd like to thank my colleague for his passionate remarks on this issue, which is so crucial for our democracy. Now, the Conservatives rejected the NDP amendment, which was designed to ensure that the Chief Electoral Officer wouldn't need to go to Treasury Board for authorization in order to hire experts to conduct studies or write reports, etc., as it did on the robocall scandal. My question for my colleague is this. What does he think, in fact, the Conservatives are afraid of?
The Honourable Member for Châteauguay-Saint-Constant. I would like to thank my colleague for her excellent question. I think what we're afraid of, or what they are afraid of, rather, is that they might lose the next election. So they're trying to put in place measures that will allow them to keep going around the act, and they won't have to have witnesses constrained. They won't have a elections office that has strong powers. The Chief Electoral Officer will have to get an outside expert firm to figure out what's going on. And so to do this, to interfere in this way in the powers of an officer of Parliament is unheard of. This is what the government is afraid of. They're afraid of losing the next election.
The Honourable Member for Nipissing-Temiskaming.
Thank you, Mr. Speaker, and it's a pleasure for me to rise in this House to speak about Bill C-23. Mr. Speaker, over the past few months, the opposition parties have been tirelessly trying to portray the Fair Election Act as undemocratic and sinister. Before the bill was introduced, even before they had a chance to read it, they have been against it. They have consistently tried to misinform Canadians about why the government was implementing C-23. They have tried to build a narrative of government ramming legislation without proper consultation or investigation. Quite frankly, Mr. Speaker, nothing could be farther from the truth. It seems to me that the opposition parties have forgotten how our legislative process works. So I would like to use my time today to highlight 2 issues. First, how the progress of C-23 thus far exemplifies the integrity, utility, and efficacy of our legislative system. And secondly, what Canadians have really been saying about C-23 and not the fabricated stories the opposition parties have been desperately trying to sell. The 2011 elections saw several irregularities. While courts recently determined that nothing illegal had been done, Canadians, Elections Canada, and our government were concerned about the integrity of our electoral system and the process by which any irregularity would be investigated and prosecuted. Mr. Speaker, this is the true motivation behind the Fair Elections Act. Although the opposition parties like to throw around alarming phrases like voter suppression tactics and other wild descriptions, this bill started out like any other. A problem was identified that needed a government legislative fix. There is nothing controversial or new about this, Mr. Speaker. This is how our democracy has functioned for nearly 150 years. Before C-23 was introduced, the government spent a great deal of time examining the various issues raised by Elections Canada, as well as court cases related to the robocall scandals and other irregularities. I myself was inadvertently and, quite frankly, unnecessarily dragged into the robocalls case by the Council of Canadians. The court found, after close investigation, as we had stated all along, that nothing illegal had been done by any of the MPs involved. If Elections Canada had sharper teeth, this entire investigation could have been completed quicker and saved thousands of taxpayer dollars. If Elections Canada only had the proper investigative tools from the get-go, it would have been given straightforward to discover the evidence of any, if any existed. Only charges with substantive evidence would have progressed, and countless hours of the court's time and taxpayer resources would have been saved. Since C-23 was introduced, the opposition parties have been trying to misinform Canadians by stating that the government had not consulted with Canadians or experts. They have continuously tried to convince Canadians that this bill was being rammed through Parliament without any debate or proper investigation. Let me provide the House with some facts about what has actually transpired with C-23, Mr. Speaker. In committee, the bill has had a long and exhaustive analysis. There have been over 15 meetings amounting to roughly 31 hours of study with testimony from over 72 witnesses. In addition, Canadians have continued to voice their concerns to their MPs, who have duly consolidated these concerns and informed the Minister and his department accordingly. In my riding of Nipissing-Temiskaming, I've received input from 45 constituents. As people wrote in, Mr. Speaker, the overwhelming majority of concerns were focused on one particular part of the bill, and that was the elimination of vouching. So as their MP, I communicated this to the Minister. The Minister of Democratic Reform was always open to the feedback I shared on behalf of my constituents. In addition, the Senate also conducted their own study of the bill and conveyed to the Minister their thoughts and concerns. And what was the result, Mr. Speaker? On April 25th, the government announced that it would support amendments to the Fair Elections Act in anticipation of the House Committee on Procedure and House Affairs clause-by-clause review of the bill. These amendments included voter identification and vouching, the mandate of the Chief Electoral Officer to include engaging the public on voting, the appointment of central poll supervisors, fundraising exceptions to what constitute an election expense, and several others, I might say, Mr. Speaker. While the opposition continues to pine and misinform Canadians, our government has methodically been combing through the bill, listening to Canadians, and experts and making modifications that would better reflect expert insight and essentially what Canadians want. That is not controversial or sinister, Mr. Speaker. That is, quite frankly, democracy in action. In fact, I am currently in the process of sending correspondence to every single one of the constituents who expressed concern about the bill and inform them about the details of the amendments so that they know their letters, calls, and emails played a direct role in the legislative process of fine-tuning the bill before it becomes law. Here are some of the details. Voter identification. Allowing electors to vote with two pieces of identification that prove their identity and a written oath as to their residence, provided that another elector from the same polling division who proves his or her identity and residence by providing documentary proof also takes a written oath as to the elector's residence. This new measure will allow those who do not have identification proving their residence to register and vote on polling day. Secondly, public information and education mandate of the Chief Electoral Officer, specifying that the Chief Electoral Officer may communicate with the public, but where he advertises to inform electors about the exercise of their democratic rights, he can only do so on how to be a candidate, when, where, and how to vote, and what tools are available to assist disabled electors. Further, the Chief Electoral Officer may support civic education programs for primary and secondary schools. Appointment of central poll supervisors. Retaining the current appointment process for central poll supervisors. Fourthly, fundraising exception to what constitutes an election expense. Eliminating the proposed exception as to what constitutes an election expense in the case of expenses incurred to solicit monetary contributions from past supporters. Overall, Mr. Speaker, thanks to input from experts, Canadians, and legislators, 14 substantive and 45 technical amendments have been introduced by the Minister of Democratic Reform to further improve the quality of the Fair Elections Act. Now that we have an appreciation of how C-23 has carefully gone through analysis, consultation, and revision, I can briefly discuss what Canadians outside of the Ottawa bubble have actually been saying about it. A recent Ipsos poll conducted on behalf of CTV demonstrated that the overwhelming majority of Canadians believe that it is entirely reasonable for voting to have identification requirements. Mr. Speaker, we require Canadians to have ID to drive, to travel, to purchase alcohol, and to do countless other tasks. Canadians recognize the good common sense in requiring identification for one of the most fundamental acts citizens can do, and that is elect their government. This makes abundant common sense. This poll demonstrated that 70% of Canadians believe it is acceptable to eliminate vouching. This reflects the desire of Canadians to ensure the integrity of their electoral system. Canada is a very tolerant and diverse society. If a resident non-Canadian wants to vote, they are always more than welcome to apply for citizenship. However, the responsibility of choosing our federal government belongs to citizens and citizens alone, and we must protect that important privilege from those who would seek to abuse it. The opposition parties protest that ID requirements will disenfranchise some Canadians. For example, they argue ID requirements make it more difficult for students to vote. This is a perfect example of the kind of fear-mongering and misinformation the opposition has been propagating. All Canadian universities and colleges issue their students ID cards. These same cards can be used to vote. But the issue of ID raises a more important question, Mr. Speaker. If the right to vote is reserved for Canadian citizens, how does one prove they are a citizen? ID requirements are just good common sense. However, if though it is highly unlikely a citizen would not have access to any of the 39 pieces of acceptable ID, including basic and easily obtainable documents such as bank statements, hydro bills, or library cards, we have retained vouching as an assurance because we recognize that improbable does not mean impossible, and that we want to make sure that every citizen who takes the effort to come out and cast their ballot will have a reasonable way of proving their status as a citizen. This ensures no Canadian citizen will be deprived of the right to vote. Citizens who cannot obtain the necessary ID can request another voter from the same poll to vouch for them. But this person will have to first prove their identity and will only be able to vouch once. This change to how vouching is in line with the March 6th recommendations of the Chief Electoral Officer, when he said vouching procedures should and can be simplified, and the need to rely on vouching should also be reduced. We agree with that. This amendment is a perfect example of how this bill has been fine-tuned through the legislative process after extensive review and consultation. In fact, Mr. Speaker, for all the sound and fury the opposition has been making about C-23 and how allegedly outraged the majority of Canadians are, the same poll indicates that some 23%, right, 1 out of every 4 Canadians, are closely following the issue. Clearly, this reflects the fact that most Canadians have come to the conclusion that the Fair Elections Act is nothing but common sense, a common sense response to some very serious issues. The opposition parties have tried to mislead Canadians by calling C-23 a scheme intended to disenfranchise voters. This is simply not true. Mr. Speaker, and Canadians know it's not true. 61%, 6 out of every 10 Canadians, disagree that C-23 is a scheme, and only 15%, less than 2 in 10 people, strongly agree. Finally, when asked if requiring voters to personally prove who they are and where they live is essential to eliminating potential fraud in our electoral system, 86%, nearly 9 out of every 10 Canadians agreed. Only 1 in 10 Canadians disagrees with that statement. There is evidence, Mr. Speaker, the opposition parties are desperately trying to distract Canadians from the fact that they have no policy or plans of their own, except for possibly a $21 billion job-killing carbon tax. They have tried to mislead Canadians into thinking that this was something that was a scheme and that the majority from coast to coast are upset about. As I said throughout my speech, Mr. Speaker, over the past few months, only 45 constituents in my riding of 96,000 have raised concerns about C-23. The majority of these concerns dealt with vouching, and now that issue has been put to bed. Once again, the opposition pines and fusses instead of making meaningful and critical positive contributions to our legislative process. In closing, Mr. Speaker, I would certainly like to commend our Democratic Reform Minister for his principled commitment and leadership of guiding C-23 through the legislative process. While the NDP and the Liberals have tried to misinform Canadians about the contents of the bill, how it was drafted, how it continues to be fine-tuned, our government was attentively listening to Canadians, experts, and legislators to improve the Fair Elections Act. Thank you, Mr. Speaker. Merci beaucoup.
We have time for one question in government orders. Question and commentaire, l'honorable.
The honourable member for Oren-Fortin.
Thank you, Mr. Speaker. My question is really quite simple. The point of an Elections Act is to let people vote freely in an election. And does my colleague really think with this legislation, First Nations will vote in larger numbers? Will students go out in larger numbers? Will there be people actually put in prison for election fraud? Everyone has said that this bill will not increase voter participation.
For Nipissing to Miskaming.
Well, there they go again, Mr. Speaker. As I said, fear-mongering, negativity. I'm convinced that, I'm more than convinced that this reform, C-23, will provide the environment so that students, Native people, in fact, all Canadians will come out to vote in the next federal election. Thank you very much.
The time for government orders has expired. The honourable member for Nipissing to Miskaming will have 9 minutes remaining for questions and comments when this matter returns following question period. Déclaration de député, statements by members. The honourable member for Edmonton St. Albert.
Thank you, Mr. Speaker. Mr. Speaker, I would like to congratulate the Edmonton Oil Kings on winning the championship of the Western Hockey League last night, and in so doing in very dramatic fashion. For the second time in 3 years, the Oil Kings have captured the H&L Cup as WHL champions. After posting a 50-19-3 regular season record capturing the Eastern Division of the WHL, the Oil Kings swept the Prince Albert Raiders 4-0 in the first round, then bested the Brandon Wheat Kings 4-1. In the Eastern Conference Final, the Oil Kings beat the Medicine Hat Tigers 4-1, setting the stage for an exciting 7-game championship against the defending champions, the Portland Winterhawks. Each of the 7 games was riveting, and after losing Game 6, 6-5 in overtime, the Oil Kings prevailed last night in Game 7 in Portland with a 4-2 victory, taking the championship 4-3. The Oil Kings will now travel to London, Ontario. They'll be hosted by the Minister of State for Science, where they will compete for the Memorial Cup. I would like to congratulate the head coach, Derek Lockstall, and the entire Oil Kings organization and wish them well in their quest to capture the Memorial Cup. Go, Oil Kings, go!
The honourable member for Miramichi.
Mr. Speaker, I rise in the House today to acknowledge and salute Miss Brianne Tozer of Miramichi, who will be representing New Brunswick in the Miss Universe Canada pageant this month. Brianne is a bright and talented young lady who holds degrees from the University of New Brunswick and from St. Thomas University. She received several scholarships, including the prestigious National Millennium Excellence Award. Brianne now has a career in the Canadian construction and mining services industry. Brianne has a big heart and is a volunteer in her community. Through this Miss Universe Canada pageant, Brianne will be helping to raise awareness and support for 2 of these wonderful organizations, Operation Smile and SOS Children's Villages. On behalf of all Miramichiers, I wish Brianne good luck in Toronto. We are very fortunate to have such a capable and caring young woman representing all of New Brunswick on the national stage. I also encourage you to visit MissUniverseCanada.ca and vote for Brianne.
The honourable member for Sudbury.
Mr. Speaker, today is my first opportunity in this House to pay tribute to Fabio Belli, a dedicated family man and city councillor from my riding of Sudbury, who passed away suddenly a month ago yesterday. Mr. Speaker, Fabio was only 37 years old, and he was known as an award-winning business leader, and he channeled that spirit into getting elected as councillor. He worked hard for his constituents, as well as on major projects, especially a new arena for his beloved Sudbury Wolves. But more than anything, Fabio was a committed family man. To his wife, Sue, his 2 young daughters, Emma and Brianna, his parents, and extended family, thank you for sharing Fabio with us. As political colleagues, we would meet, but as friends, we would talk about our families, our community, and about how Italy was always the favorite to win the World Cup. My city lost a good man, a great husband and father, and I lost a friend. But, Mr. Speaker, I truly hope that this tribute will be looked upon by his daughters in the years to come, and it will remind them of how great of man their father truly was. Thank you, Mr. Speaker.
The honourable member for Northumberland, Quinte West.
Mr. Speaker, it's been my experience and the experience of many others that when someone says it's not about the money, it's always about the money. Recent media reports about the expansion at CFB Trenton indicate that career protesters, the ones I mentioned in my previous statement in this chamber, can now be described as paid professional protesters. Despite the efforts of the member from Ottawa Centre and a Liberal senator from BC, this issue is all about the money. These media reports show that these career protesters are being paid to protest. How sad. We will continue forward with our government's original intent to create long-term, secure jobs and countless opportunities for the Quinte region. Our government is committed to the base expansion and the transfer of JTF2 to CFB Trenton. Thank you.
The honourable member for Cardigan.
Mr. Speaker, I rise today to honour Elizabeth Harvey, who passed away recently. Ms. Harvey, from Isle of Mart on Newfoundland's southwest coast, spent many years fighting on behalf of fishermen treated unfairly through the Atlantic Groundfish Licence Retirement Program. She led a campaign for justice and equality, and in 2011 the result of her fight led to a victory in the federal courts for over 750 fishermen who finally received tax payments that were owed to them. Her determination and hard work led to a fair tax treatment for many former fishers throughout Newfoundland and Labrador and across the east coast of Canada. I know Ms. Harvey will be sorely missed, and her tireless and determined efforts will be remembered for many years to come. On behalf of all members, we offer our condolences to the Elizabeth family, her friends, her community, and the many people throughout the Atlantic region who worked with her to see that justice was done. Thank you, Mr. Speaker.
Honourable member for Vegreville, Wainwright.
I'm proud to rise today to recognize Sam Herman for a lifetime of service to the people of Lloydminster and area and to our country, Canada, which he loves so much. I first met Sam through politics in 1988. He was the driving force in building the Reform Party of Canada through immense contributions of hard work, money, and most importantly, well-considered policy ideas. He led the way in building the Constituency Association for the Vegreville and Lloydminster areas and helped me get elected as a candidate and then as the first Reform Member of Parliament for Vegreville. As campaign manager, Sam took the best part of a year to get me elected. I found out later that he never really thought he could accomplish that task. When I asked him why he contributed so much time and effort, he said, because it was the right thing to do. And that was my good friend Sam. He deservedly was named Reformer of the Year in Ottawa in 1994. Sam's contributions to his community didn't stop at politics. He was involved in Rotary, the Young Rotary Entrepreneur Program, and his church, and so much more, Mr. Speaker. But to Sam, his wife Artis, and his children, and his God were his greatest loves and the source of so much pride.
Honourable member for Portneuf-Jacques-Cartier. Mr. Speaker, today I'm pleased to welcome to Parliament Hill a group of young people from youth centres in Saint-Augustin-de-Desmaures and Saint-Catherine-la-Jacques-Cartier. Already very engaged in school and in their community, these people from my riding of Portneuf-Jacques-Cartier are here to discover how our parliamentary system works and what federal members of Parliament do here in Ottawa. These young people from my riding are a shining example of the vitality and incredible potential of Canadian youth, and I am pleased to welcome them. Their presence in Ottawa shows that they are already involved as citizens and that their voice must be heard by this government so that it can offer them all the support that they need. Whether through the development of initiatives fostering the active participative young people on the labour market or by funding programs that directly target young people, such as youth service cooperatives, it's time to act. As elected officials, it is our duty to include young people in our debates and in the policies we adopt, because they are too often neglected by this government. Thank you.
The honourable member for Calgary East.
Mr. Speaker, my current riding of Calgary East is fortunate to have a strong, vibrant community associations, namely Riverbend, Marlborough, Dover, Marlborough Park, Milliken Ogden, Southview, Linview, Crossroads, Mayland Heights, Forest Heights, Albert Park, Radisson Heights, Fenbrook Meadows, Forest Lawn, Erin Woods, Applewood, Highwood, Douglas Glen, and Abbeydale. I would like to take this opportunity to thank the volunteers of all the community associations in Calgary East for their hard work and commitment to keeping the Calgary spirit of community bright. With new boundaries taking effect during the next election in 2015, I warmly welcome the new communities of Vista Heights, Rundle, Pine Ridge, Monterey Park, and Coral Springs. I look forward to working with these communities in the coming years. Mr. Speaker, I also would like to thank to those whom I have had the honour to represent since 1997. Thank you, Mr. Speaker.
The honourable member for Etobicoke Lakeshore.
Mr. Speaker, Etobicoke Lakeshore is home to a growing number of Tibetan Canadians, many of whom fled religious persecution and made Canada their adopted land. Within a short time, they established the Tibetan Canadian Cultural Centre in Etobicoke. Draped in prayer flags, the centre actively promotes the distinct Tibetan culture of non-violence and tolerance. His Holiness, the Dalai Lama, an honorary Canadian citizen since 2006, visited Etobicoke Lakeshore and inaugurated the centre in 2010. May 17 is International Tibet Solidarity Day. On this day, let us recall how Tibetans face difficulties in practicing their religion. We renew our calls for the release of imprisoned religious leaders, including the 11th Panchen Lama, who disappeared 19 years ago at the age of 6, and Khenpo Khartse and Tenzin Delek Rinpoche, who are being denied medical attention. Canada's Ambassador for Religious Freedom recently met the Dalai Lama to reaffirm our commitment to the Tibetan community. Canada stands in solidarity with the people of Tibet. We call on the government of China to let people living in Tibet realize their political, cultural, religious, and linguistic rights. Thank you, Mr. Speaker.
The Honourable Member for Berthier-Masquinongé. Thank you, Mr. Speaker. Today I would like to underline the remarkable work done by Eureka Search and Rescue, a nonprofit organization whose volunteer members are specialized in looking for people who are missing. Last month, I met with the members of this group and I was impressed by their work and generosity. They work with the Sûreté du Québec and Quebec Emergency Preparedness in case of disaster and work to find people who have disappeared or are missing. These volunteers make a difference in an emergency situation and increase the strike force of Sûreté du Québec. On May 31st and June 1st, Eureka is organizing a yard sale in Saint-Saëns-de-Grès to raise funds for the purchase of equipment they so desperately need. I would welcome you to this yard sale, and let us make sure that Eureka has all the resources it needs to help our communities. Once again, I would like to thank all the volunteers who are involved in Eureka, who sometimes feel that they're working in the shadows. But please know that we welcome your action. Honourable Member for Lotbinière-Chaudière. Mr. Speaker, today I would like to educate people about an initiative that many people in our communities take up as a challenge, the Relay for Life. This friendly and inspiring against cancer. The Relay for Life is a global movement against cancer which takes place in 20 countries across the world, including Canada, in 500 different towns. From coast to coast to coast, in communities of all sizes, thousands of people come together to fight for life. Last year in Canada, there were 16,224 teams who amassed $46.5 million. Visit the cancer.ca site in order to find a relay that is organized in your region, or you can create a team of 10 to 15 people and stay up all night for a cause that touches all of us in one way or another.
The Honourable Member for Hamilton East, Stoney Creek.
Mr. Speaker, I rise today to pay tribute to a great Canadian Labour leader, Lynn Williams, who passed away on May 5th, just a few months short of his 90th birthday. Lynn started his union career in the late 1940s as a member of Local 2900 of the Steelworkers at the John Inglis plant. His links with the industrial and manufacturing core of the City of Toronto would later result in a street being named after him. Lynn also became the first Canadian to lead an international labour union when he was elected president of the Steelworkers in 1983. And in that role, he skillfully led the steelworkers until his retirement in 1994. He was a devoted man to his family, whom he believed was the reason for everything that he did on behalf of other working families. Lynn was known to many as a labour intellectual who considered all the consequences of his actions and those of the union he led. He understood politics, the nature of capitalism, and the need for social justice at every level. This made Lynn a much sought-after media commentator long after his so-called retirement. His wisdom, strength, and his love for Canada led to him being invested as an officer in the Order of Canada in 2005. Yes, Lynn Williams was a labour giant, a great Canadian. He was well loved, and he will be missed.
The honourable member for Sault Ste. Marie.
Mr. Speaker, on Canada's National Day of Honour this past Friday, Canadians across our nation paused to look back on our contributions and achievements in Afghanistan with tremendous pride and appreciation, knowing that those who served made a positive difference in the lives of the Afghan people. It was a privilege to represent Sault Ste. Marie at the National Day of Honour ceremony on Parliament Hill. This was an historical event that will be embedded in my memory forever. This was an occasion for all Canadians to remember the valour and dedication of our troops and pay tribute to the fallen, including Sault Ste. Marie's very own Master Corporal Scott Vernelli and Sergeant John Wayne Fott, both of whom made the ultimate sacrifice in service to Canada. We will remember their courage and bravery forever, lest we forget.
The honourable member for Mount Royal.
Speaker, we are in the midst of the third annual Iran Accountability Week, which occurs as nuclear negotiations with Iran risk overshadowing, if not sanitizing, the regime's massive domestic repression. It also coincides with the 6th anniversary of the imprisonment of Iran's Baha'i leadership, an execution binge that has seen 650 executions since Rouhani took office last August, and the continuing unjust imprisonment of more than 900 prisoners of conscience. Today, parliamentarians heard from FDD experts Mark Dubowitz and Ali Ofina on the importance of sanctioning human rights violators and terrorists, from former Iranian political prisoner Marina Namat and Suzanne Thomas of the Baha'i about the importance of standing in solidarity with political prisoners. The centerpiece of this week is the Global Iranian Political Prisoner Advocacy Project, which pairs parliamentarians with an adopted political prisoner on whose behalf they advocate, and I am advocating on behalf of the 7 imprisoned Baha'i leaders. 2 of the prisoners whose cases we took up last year, Nasreen Sotoudeh and Hamdi Ghassamashal, have since been released. Inspired by their courage and by the courage of those who remain in prison, we will continue to sound the alarm until the Iranian people.
The honourable member for Westlock St. Paul.
Mr. Speaker, on behalf of our Conservative government and Canadians across the country, I would like to commend law enforcement officers for their commitment to ensuring the safety and security of our communities. This week marks National Police Week, where we take a moment to think about the valuable services these men and women provide, and to thank them for their dedication and professionalism. Law enforcement officers work hard in our communities, on our highways and waterways, our airports, our ports of entry, and in foreign countries. During National Police Week, let's also think of the families of law enforcement officers. It is the people who are closest to them who really know the sacrifices they make to help keep us safe. This past weekend, there was an incident in my hometown of St. Paul, where the RCMP officers were injured while putting themselves in harm's way to keep their fellow Canadians safe. On behalf of our government, I wish a quick recovery to all of the injured officers, and a thank you to all law enforcement officers across our country for keeping us safe each and every day.
The honourable member for Hamilton Mountain.
Last night, the Conservatives disappointed Canadians and voted down improvements to the Unfair Elections Act. The Conservatives opposed giving the Commissioner of Elections Canada the power to compel testimony. They opposed requiring political parties to provide receipts and documentation for their activities. But we're now getting a better picture of why. Conservative lawyer Arthur Hamilton, who was already caught dragging his feet and not cooperating fully with authorities, has now been fingered for deliberately misleading investigators. He provided them with false information about Conservative calling scripts and then did everything possible to prevent witnesses linked to the Conservatives from providing information to investigators. The Unfair Elections Act will make it even harder to investigate and catch Conservative voter suppression. But then, that is what this bill is all about, stacking the next federal election in the Conservatives' favour. The Democrats are not going to let that happen. We've been showing up for work, standing up for Canadians, and getting ready to replace the Conservatives in the next election.
The honourable member for Durham.
Mr. Speaker, last Friday was the National Day of Honour, and Canadians gathered to mark the conclusion of the Canadian Forces' 12-year mission in Afghanistan. But our duty as Canadians to honour and remember that mission has really only begun. In my riding of Durham, last Friday we commemorated the National Day of Honour, and we will continue to remember the mission, standing alongside the families of Trooper Daryl Caswell and Colonel Jeff Parker, who gave their lives on our mission in Afghanistan. And I'm proud that our government has announced that we will build a permanent monument here in Ottawa for the Afghanistan mission. Whether it's the small town cenotaphs, Mr. Speaker, or a grand monument here in the nation's capital, these symbols will allow us to remember the service and sacrifice for generations to come, lest we forget.
Well done. Oral questions, questions orales. The Honourable Leader of the Opposition.
Can the Prime Minister please update Canadians on what assistance Canada is providing to help locate the 300 schoolgirls kidnapped by Boko Haram? Est-ce que le Premier Ministre?
Can the Prime Minister please explain to Canadians what assistance we will be deploying on the ground and that we will deploy in Nigeria to find these 300 girls kidnapped by Boko Haram?
Honourable Prime Minister.
Mr. Speaker, we condemn in the strongest possible terms these acts.
Boko Haram is obviously repugnant to everything that we believe in as Canadians, and I think that most people in the world believe in. Our hearts are obviously with these girls and their families. There are Canadian personnel who are now present in Nigeria, and they're there to provide liaison and to assist Nigerian authorities in their search.
The Honourable Leader of the Opposition.
Mr. Speaker, while thanking the Prime Minister for that answer,
Marc Nadon to resign from the federal court before naming him to the Supreme Court.
The Right Honourable Prime Minister.
Mr. Speaker, as I said before, we received expert legal opinion on the eligibility of federal court judges for appointment to the Supreme Court of Canada, as, by the way, had been long-standing practice, not just in case of previous processes, including processes with Quebec judges, but in cases where federal court judges have, of course, actually been named to the Supreme Court of Canada. The recommendation, the legal advice, was they could be directly named, and that's what I had done.
the Honourable Leader of the Opposition.
He suggests to Marc Nadon that he resign from federal court. We noticed we didn't get an answer. Quel employé du
Which employee of the Prime Minister's asked Judge Nadon to resign from the federal court, and was the Prime Minister aware of that or not? Mr. Speaker, we only know we had received legal opinions that told us that the appointment of Mr. Nadon was legitimate. I appointed him directly to the Supreme Court from the federal court. The Honourable Leader of the Opposition. In fact, he appointed him to the Supreme Court, and the question was if he asked him to resign from the federal court. Yesterday, criminal charges were laid following the disaster in Lac-Mégantic. The actions of these individuals and that company will therefore be judged before the courts. The fact remains that the safety of the entire railway network is at stake. Will the Prime Minister act and impose severe financial penalties on companies who breach the railway safety rules? We have already made improvements to the railway safety network since the accident and before, and we continue to review the situation in cooperation with our friends in the United States. But I would like to salute the work of the police in this case, and there have now been criminal charges laid against the company and these individuals because this case will be before the courts, and I have nothing further to add to that. The Honourable Leader of the Opposition.
Prime Minister's right. We have made together amendments. One of them was about 2 years ago when Parliament gave the government the power to enact financial penalties against unsafe railways. The problem is it's been 10 months since Lac-Mégantic, and they still haven't done a thing. What is the Prime Minister waiting for?
The Right Honourable Prime Minister.
Once again, Mr. Speaker, I think we need to look at the big picture and the facts here. The fact of the matter is, as I think many of us suspected, the rules in this case have not been respected. As you know, we congratulate the police who have now laid some criminal charges on the company and on a number of individuals. That matter will be before the courts. We're not going to comment on that, but obviously this government will continue to move forward on any measure necessary to improve railway safety.
The Honourable Member from Papineau.
Yet another great visit to Fort McMurray, where residents are frustrated at being taken for granted by this government. On top of that, we've learned from the C.D. Howe Institute that the Conservative decision to loosen temporary foreign worker program has actually increased unemployment in Alberta. Will the government adopt our plan and fix this program?
The Right Honourable Prime Minister.
Well, Mr. Speaker, I don't know what the Liberal plan would be. Until very recently, the Liberal Party was inundating us with demands to increase the number of temporary foreign workers to their ridings. That's the opposite of where this government has been going. We've tightened up rules over the past several years. Applications under the low-wage stream for temporary foreign workers have fallen by some 30%. In terms of as a result of the reforms we've put in place thus far. And, Mr. Speaker, we will continue to act to make sure, because it is our policy, to make sure as an absolute principle that if Canadians are available and ready to work, that Canadians get jobs.
The Honourable Member for Papineau.
In 2006, the Conservatives trumpeted that they had made it easier for employers to hire temporary foreign workers instead of Canadians. Their plan actually allowed businesses in Alberta and BC to stop looking for Canadian workers after only 1 week, instead of the month of advertising previously required. Our plan requires all possible efforts to hire Canadians first. Will the government adopt it?
The Right Honourable Prime Minister.
Well, Mr. Speaker, of course, the facts are quite the contrary. Until, I think, just a couple of weeks ago, the Liberal Party was continuing to demand that we bring in more temporary foreign workers. And, Mr. Speaker, obviously that has not been our position for the last 3 years. We have been concerned. We have brought in a tightening to the program. And, Mr. Speaker, we will continue to do so, recognizing the fact, while there is some need for temporary foreign workers, it must never become a business model, and eligible Canadian workers should never be counted out for work.
The Honourable Member for Papineau. The Quebec government has barely been elected, and their new Minister of Inclusion is leaving Ottawa in a huff. Because of the Conservative government's bad management of its temporary foreign workers program, both employers and those looking for jobs in Quebec are frustrated. Will the Prime Minister finally repair his broken program by adopting our plan? The Right Honourable Prime Minister. Mr. Speaker, the contradiction of the Liberals on this issue, the Liberal Party leader is now asking for more temporary foreign workers. Mr. Speaker, the unemployment rate's very high in Quebec, and that's the reason why we will continue to reform the program to ensure that unemployed Canadians will have the first opportunity to take jobs.
After claiming otherwise, the Employment Minister now admits he knew all about the low wages, terrible working conditions and abuse of the foreign workers program for years, and yet failed to fix it. And when he did act, it was based on faulty data. Mr. Speaker, no one is buying this minister's weak attempts to change the channel from his mismanagement. Why is he failing to protect jobs for Canadians, and why is he refusing a full and independent program audit?
The Honourable Minister of Employment.
Again, Mr. Speaker, we are in the final phases of a comprehensive review of the program designed to ensure that Canadians always come first in our labour market. And indeed, there are independent audits conducted by the new Integrity Branch of Service Canada to audit employers to ensure those that are non-compliant face the increased sanctions. But, Mr. Speaker, it's the NDP that wants various exemptions. They've written letters asking for streamlining and simplifying the LMO screening process. They want exemptions for the computer gaming industry. They want exemptions for the international musicians. Mr. Speaker, would the NDP, if they want to have a constructive role in this debate, actually come to a coherent position, please?
The Honourable Member for Saint-Lambert. Mr. Speaker, yesterday the Minister of Employment rejected the Quebec government's request, saying that a moratorium was necessary in order to clean up the temporary foreign workers program, especially since there is a high unemployment rate among youth and immigrants. Either the minister was running a fever or the light bulb just went on, because all of a sudden, voila, he's taking up all of the arguments we've been giving him for weeks. Since he now recognizes that the program has to be cleaned up, will he ask the Auditor General to get involved? The Honourable Minister of Employment. Mr. Speaker, we have no intention of interfering in the Auditor General's agenda. We will cooperate with the Auditor when he wants to study a particular file. There has been a study made by the former Auditor General on this program 5 years ago, and we put almost all of her recommendations into effect since that time. We'll continue to tighten the rules up for the program to ensure that Canadians come first on the job market, even against the NDP's recommendation. They want to make it easier for their constituents. The Honourable Member for Saint-Lambert. Mr. Speaker, the other problem that we've been raising for weeks is the absence of reliable data on the labour market. The Auditor General and the Parliamentary Budget Officer in particular have demonstrated that the government doesn't have the right tools to assess the workforce needs. To paraphrase Pat Burns, finding unemployment with bad data is like going bear hunting with a butter knife. When will the Conservatives seriously attack unemployment, beginning with giving themselves reliable job market data? The Honourable Minister of Employment.
The NDP that wants exemptions for all international musicians to come and take jobs from Canadian musicians without any screening. It's the NDP that wants to open the floodgates with no verification for the computer gaming industry in Montreal because I guess they talked to them. It's the NDP critic who lobbied me for a crane operator to come into a riding as a temporary foreign worker. It was the MP from Halifax who asked us to streamline the LMO screening process. It's the MP for the Western Arctic who said that our wage levels are too high in the temporary foreign worker program. Mr. Speaker, we won't listen to the NDP on this.
Honourable Member for Rosemont-la-Petite-Patrie. The 400,000 temporary foreign workers, and we have 1.4 million unemployed. It's their fault. It's shameful. Mr. Speaker, who am I? I am a part of the Prime Minister's group of friends who have been in trouble more than once. Wright? No. Duffy? No. Brazo? No. But I'm a former advisor to the Prime Minister accused by the RCMP of illegal lobbying. Again, I was hired in 2006, whereas I already had a criminal record. Who am I? Bruce Carson, of course. So, are there any ministers, ex-ministers, or Conservative government employees who were in contact with Carson when he was doing illegal lobbying? Yes or no?
Well, thank you very much, Mr. Speaker. Mr. Speaker, as you know, these allegations respect a private citizen who did not get a contract with the government, Mr. Speaker. As soon as we found out about these allegations, of course, we referred the matter to the RCMP, the Ethics Commissioner, and the Commissioner for Lobbying, Mr. Speaker. As you know, we will not tolerate rule-breaking, Mr. Speaker, and if this individual is found guilty, he should suffer the severest consequences available under the laws that we brought in.
The Honourable Member for Timmins, James Bay.
Well, speaking of being soft on crime, the Prime Minister hired convicted criminal Bruce Carson to be his chief advisor, who now stands charged not just of influence peddling, but illegal lobbying in the case of trying to rip off poor First Nations who need clean drinking water. Now, the PMO only called in the cops after the media started asking questions. So what was the Prime Minister thinking when he allowed a convicted criminal to slip through all the security checks so that he could be his chief advisor? What was he thinking?
Of course, Mr. Speaker, as I just said, these are allegations that concern a private individual who did not receive any government contracts. Mr. Speaker, as soon as we found out, we referred this to the Commissioner of the RCMP, the Commissioner for Lobbying, and the Ethics Commissioner. As you know, we brought in a number of rules, a number of very tough rules that the opposition consistently vote against, Mr. Speaker. If this individual is found guilty, he should suffer the severest consequences available under the rules that we brought in.
The honourable member for Timmins, James Bay.
I don't know, every time I hear that Elmer Fudd routine, I know that they're on the ropes, Mr. Speaker. But, you know, to be fair, it wasn't just the Conservatives who were hanging out with Bruce Carson. Daniel Gagnier, the senior advisor to the Liberal leader and co-chair of the Liberal Party, was also very chummy with this convicted criminal. So we know that APTN blew the whistle on this affair, but will the Prime Minister tell us, when was he first informed about Mr. Carson, his former chief advisors, illegal activities within his departments, with his staff, and his office? Will the Prime Minister tell us that?
Again, Mr. Speaker, as you know, it was this government that brought in the Accountability Act as one of the first measures that we passed. We knew that the opposition, of course, are consistently voting against those measures that would further accountability in government, Mr. Speaker. This particular person, if he's found guilty, should suffer the severest consequences available to him under the laws that this government has brought in. It is worth noting, of course, that as soon as we found out, Mr. Speaker, that we informed the Commissioner of the RCMP, the Commissioner of Lobbying, and the Ethics Commissioner, Mr. Speaker. Thank you.
The honourable member for Nanaimo Cowichan.
Mr. Speaker, over the last 30 years, at least 40 Indigenous women have gone missing or been murdered each and every year. Indigenous women are 3 times more likely to be murdered by a stranger than other women in Canada. Victims' families and communities need answers, justice, and hope. And more Canadians are echoing their calls. Why are the Conservatives deaf to the many voices demanding a national inquiry into the missing and murdered Indigenous women?
The Honourable Minister of Justice.
Mr. Speaker, that's factually incorrect. We are not only listening, we are taking concrete, substantive action, Mr. Speaker. In addition to the 30 justice bills, we have taken steps to ensure we are specifically targeting funding for programs, targeting funding for significant steps to address the issues of violence on reserve, taking efforts to support women on reserve, including giving them matrimonial property, renewing the Aboriginal Justice Strategy, Mr. Speaker. The time for talking about this has passed. We have many reports, many studies that have directed us, and that is exactly what we are doing, taking action.
The honourable member for Manicouagan. The Conservatives continue to tell us day after day that they're taking steps to protect Aboriginal women, except that they continue to disappear and be murdered. So what they are claiming doesn't hold water. To the Minister of Justice, who keeps repeating that the time for studies is over, I would like him to tell me, as a result of previous studies, what the main cause of the disappearances and murders is, and what specific measures proposed by this government will prevent any more disappearances and murders from occurring. The Honourable Minister of Justice.
I invite the honourable member to read some of those reports, those many reports that point to the specific causes, and they are, first and foremost, criminality and violence directed at women, Mr. Speaker. That is why we are working closely with law enforcement across the country, giving them more tools. That's why we put in place a national centre for missing persons, Mr. Speaker. That's why we've worked with law enforcement to improve their databases, worked to improve the ability that we have to investigate and find the perpetrators. In addition, Mr. Speaker, programs aimed specifically at aiding Aboriginal women who fall victim. Mr. Speaker, continuing to improve the life and quality of life of Aboriginal women is what this government is doing.
The honourable member for Abitibi. That must be one of the reasons that they're cutting back on First Nations services. If it would be so effective, it's very sad, and the list wouldn't get longer day by day. because they have no idea what the profound causes of this sad reality are. We understand that what's happened, but to prevent this happening again, we have to have a public inquiry. Can the minister at least give me one single reason why these murders and disappearances are happening? Honourable Minister of Justice.
Mr. Speaker, we know what the causes are. The causes, in fact, Mr. Speaker, are well known and have been outlined in numerous reports. In fact, the Uppal report out of British Columbia quite recently went into significant detail to direct us to ensure that we are working closely with law enforcement, that we are working directly with communities on reserve, with advocates, listening to those who ensure that we are getting the information that we need to respond directly to Aboriginal women and girls. Mr. Speaker, I would encourage the member opposite, and I say to him emphatically, work with us to come forward with solutions. This is not going to happen overnight, clearly. This is going to require significant...
Honourable member for Toronto Centre.
Mr. Speaker, StatsCan has released jobs data for April, and the news is dire. Among young people aged 15 to 24, employment fell by 27,000. Among women between 25 and 54 years old, employment fell by 29,000. Overall, 31,000 full-time jobs were lost in April. This is a dreadful employment picture, particularly for young Canadians and women. When will the government fix this jobs crisis and stop laughing about it?
The Honourable Minister of Finance.
Mr. Speaker, individual monthly numbers can be volatile, so we sympathize with those Canadians who lost their jobs in April. But as we've said repeatedly, Canada is not immune to the fragility of the international economy. However, our job growth record has been very strong since the depths of the global recession. We're among the best in the G7, have created over 1 million net new jobs, nearly 85% in the private sector, nearly 90% full-time.
The honourable member for Markham Unionville.
Mr. Speaker, soon after taking office, this government started loosening every rule in the book on temporary foreign workers. From looser advertising requirements to accelerated labour market opinions, and they even let employers pay less for foreign workers. The minister is now working to tighten what his predecessor loosened, trying to put the toothpaste back in the tube. Is this not a tacit admission that Monty Solberg and the now Minister of Public Works had it all wrong? If not, why is he undoing all their work?
Hear, hear.
The Honourable Minister of Employment.
Mr. Speaker, in point of fact, this program exists as a last resort where employers are unable to find qualified Canadians available for specific jobs. We are concerned about reported incidents of abuse, and we do want to ensure that this program does not lead unintentionally to distortions in the Canadian labour market, which is why we tightened it last year and why we'll be announcing further reforms in a few weeks' time to further tighten the program, ensuring that it does not result in the displacement of Canadians, but that our economy can continue to grow in all cylinders.
Honourable member for Bourassa. Mr. Speaker, my question is for the chair of the Procedure Committee. He had a motion passed asking the House administration to send him all documents on the subject of mass mailings by the NDP. Mailouts were sent to my riding in Bourassa. My constituents deserve answers because House resources were used. Did the committee receive these documents? If not, when will they receive them, and will they make them public?
Thank you, Mr. Speaker. First of all, it's a special occurrence to be asked a question in question period, and it's great to be up. In preparation for the visit this Thursday from the Leader of the Opposition at committee on the issue of using House resources for political benefit, we've been trying to gather a number of documents together, and even this morning at committee we discussed the documents that still weren't delivered, including the ones on the mailings, and when I endeavour with my hard-working committee clerk to ensure that we receive them today or by Thursday.
The honourable member for Victoria.
question, though.
The omnibus budget implementation bill conceals a very alarming clause. It would allow CRA officials to secretly transfer Canadians' tax information to police without a warrant. We've no objection to information being given to the police, but there has to be adequate oversight. If government feels the information should be provided, it should follow procedure and await the issuance of a warrant. Why is the minister trying to do away with this important safeguard? The Honourable Minister. Mr. Speaker, there are occasions where CRA officials become aware of potential evidence of serious crime. Officials cannot convey information if they merely suspect the commission of a criminal offense, unless there's been a request from police, a properly authorized request. Under changes to the legislation, officials will be able to convey information.
Victoria.
Mr. Speaker, given the way these Conservatives consistently mount personal attacks against anyone who disagrees with them, Canadians rightly want their personal information they provide to their government to be properly safeguarded. If there's a good reason for government to be sharing around people's personal information, they should make that case to a judge. Tax data is the second most sensitive kind of data that citizens share with their government after health information. So, does the minister think it's appropriate to permit the sharing with police of deeply personal information without a warrant?
Mr. Speaker, our government will continue to protect Canadians, particularly their tax data, while ensuring their privacy is protected. There are rare occasions, I repeat, when CRA officials, in the course of their ordinary duties, become aware of information that any reasonable person would believe is evidence of serious criminal activity. Let me be clear. Information cannot be shared on the mere suspicion of criminal activity or based on a request initiated by law enforcement authorities. It should be noticed this legislation responds to a recommendation from the OECD for member countries to adopt such measures.
The Honourable Member for Rimouski. Mr. Speaker, the most recent job numbers from Statistics Canada show nearly 30,000 Canadians lost their job in April. According to the Canadian Chamber of Commerce, 95% of the jobs created are part-time. The youth unemployment rate is still twice the national average, and household debt keeps growing. When will the Finance Minister take steps to help the middle class and the economic recovery by reviving the hiring tax credit for SMEs? Honourable Minister of Finance. Mr. Speaker, our government is focused on what's important to Canadians, jobs and economic growth. Although the world economy remains fragile, our policies have helped protect Canada. More than 1 million new net jobs have been created since July 2009, almost 80% full-time, and in the private sector.
That was quite an answer. I hope we have better ones from the minister tomorrow when we have 4 hours together at the Committee of the Whole. You'll have some support. Conservatives have once again been caught making up stats about the economy. This time it was the Bank of Canada who shed a little light on the reality of the Canadian economy. The real fact is that long-term unemployment has not improved since the start of the recession. The real fact that is, according to the Chamber of Commerce, that 95% of all jobs created in 2013 were in the part-time wage sector. And the fact that Toronto is now seeing unemployment almost at 10%. Will the minister drop his make-believe stats and admit that the jobs that have been created are precarious, part-time, and of a poorer quality?
The Honourable Minister of Finance.
We know that the honourable member has problems with numbers and problems listening. The fact is there are over 1 million new jobs created. The member is picking and choosing amongst different studies. There are different ways to analyze it. The fact is Canada is doing better than most other G7 countries, and we're very very confident that we're going to continue the growth and reach a budgetary surplus next year.
The honourable member for Edmonton Centre.
Mr. Speaker, yesterday in Edmonton, the Prime Minister announced the introduction of Quanto's Law. The story of Quanto's sacrifice certainly touched Edmontonians and many others. This legislation will ensure that those who harm law enforcement, service and military animals will face serious consequences. I know that the member for Richmond Hill was instrumental in getting this bill to the House. Can the Parliamentary Secretary, the Minister of Citizenship and Immigration, tell us a bit about this signature piece of legislation?
The Honourable Parliamentary Secretary.
Mr. Speaker, I thank my honourable colleague for the question. The inspiration for my private member's bill was the tragic death of Brigadier, a Toronto Police Service horse killed in the line of duty. I was touched by the many constituents who share the tragic tale of Brigadier. Quanto's Law will honour the memory of Edmonton Police Service dog Quanto, as well as a Brigadier and many other law enforcement animals that made the ultimate sacrifice. It is my hope, Mr. Speaker, that my colleagues opposite will join us in supporting this important piece of legislation to ensure its speedy passage through the House. Thank you.
The honourable member for Hochelaga. Mr. Speaker, the Conservatives promised in 2013 to transfer the Building Canada Fund to the cities and municipalities by April 2014. But the Conservatives keep changing the rules and requiring more information from the municipalities, which slows down project approvals. The Conservatives are creating utter confusion at the height of the construction season. The municipalities don't even know how to apply for infrastructure projects. Why are the Conservatives obstructing the municipalities at the last minute? The Honourable Minister. The only confusion is in the NDP's understanding of things. The cities know full well that in Quebec, all municipalities have to apply first to the province, so the province can decide what to do with the gas tax. Quebec is working with the government, and as there will be no missed construction opportunities. The work will go ahead, the work that everybody wants in Quebec. The honourable member for Hochelaga. Mr. Speaker, urban centres all across the country are waiting for funding to repair their aging infrastructure, but some projects could be delayed by a full year because of this. We're talking about jobs in construction that will never be created. We're talking about a delay of 1 year for major infrastructure projects. The federal government has only one job to do: get the money out the door. Can the minister do that? Municipalities aren't going to be able to replace the minister. The honourable minister. Mr. Speaker, it's incredible. Never in the history of this country has any government done more than ours for infrastructure. Never before. Mr. Speaker, after billions in investments, which the NDP have always opposed, not only do they not understand the programs, but they vote against the measures we take. It's absolutely illogical. It's absurd. The municipalities know they can count on us, that the money will be available as of April 1st, and there's just a few provinces that still have to sign on for the gas tax.
Conservative mismanagement of the Building Canada Fund is leaving municipalities struggling to get shovels in the ground on vital infrastructure projects. Municipalities are raising concerns that the application process is causing delays and leaving provinces like British Columbia struggling. This year's construction season is already underway. These projects are too important for them to be stalled in Conservative red tape for another year. Why is this government making it so hard to get the funds flowing to these much-needed infrastructure projects?
The Honourable Minister of Infrastructure.
Mr. Speaker, this year there's still $6 billion of the former program will flow all across the country this summer, Mr. Speaker. That's already done. And the new program is on its way. We were working with the provinces and territories. FCM was at all the roundtable was held during the process to set up the new program. They know everything what's going on in this project, and all the information are available on the Infrastructure Canada website, Mr. Speaker.
The honourable member for Beaches, East York.
Mr. Speaker, ever since the Liberals' 1996 budget took funding for housing out at the knees, Toronto's infrastructure has been neglected by the federal government. Now Canada faces a deep and deepening infrastructure crisis in our cities.
Mr. Speaker, Conservatives are playing games with the rules, municipalities are fed up with the gamesmanship, and Torontonians are frustrated. So when will the Conservatives do what the Liberals failed to do and make real investments in Toronto's infrastructure?
Hear, hear. The Honourable Minister of Infrastructure.
Mr. Speaker, 71% of the funds of the new program go directly to municipalities of the country. 71%. That's more what the FCM was asking at the beginning of the process. For sure, we'll continue to work with the provinces and territories and municipalities. We don't prioritize the project. They are doing that, and we'll continue to support them. $53 billion, Mr. Speaker, $70 billion on 10 years, including the federal investment in our organization, in our own buildings, and we'll continue to support the municipalities and provinces. All of them.
Honourable Member for Scarborough-Guildwood.
Mr. Speaker, NASA has now confirmed that the ice melt in the western Antarctica is, quote, almost certainly unstoppable, and that, quote, a 3-meter rise in sea levels is now almost inevitable. Meanwhile, we have a Minister of the Environment from Iqaluit, which will almost certainly disappear, giving nonsense answers in question period. If the minister refuses to give meaningful answers here, will she at least this afternoon meet with the press and share her thoughts on this impending climate catastrophe?
Honourable Minister of the Environment.
Thank you. For the record, I'm from Joe Haven. Since 2006, our government has invested significant funds in more efficient technologies, better infrastructure, and adaptation in clean energy. We have taken actions on 2 of the largest sources of emissions in this country, transportation and the electricity sector. And in fact, in the first 21 years of our co-regulations, we expect to see cumulative reductions in greenhouse gas emissions, equivalent to removing about 2.6 million vehicles per year from the road. Thank you, Mr. Speaker.
The Honourable Member for Vancouver-Quadra.
Mr. Speaker, soon the Conservatives will make their decision on the Northern Gateway Pipeline. Because of environmental concerns, Indigenous peoples, the Kitimat community, and British Columbians do not support it. The Supreme Court of Canada itself requires that the federal government consult and accommodate First Nations interests, but this has not happened. Yesterday, the UN top advocate for the rights of Indigenous peoples agreed, saying the government should not go forward with this project. Will the government finally listen to these collective voices and reject this pipeline?
The Honourable Minister of Natural Resources.
First Nations have and will continue to make important contributions as a full partner in the development of our natural resources. In fact, natural resources sector is the largest private employer of First Nations people in Canada, and the success of this sector depends on their full participation, from environmental stewardship to the economic benefits of responsible resource development. Thank you, Mr. Speaker.
The Honourable Member for Dartmouth-Cole Harbour.
Thank you, Mr. Speaker. Conservatives promised greater transparency with their new Social Security Tribunal. Instead, surprise, surprise, there's more secrecy than ever. You see, before the new tribunals were established, all decisions were made public. Since, only 18 of nearly 1,000 decisions have been made public. I mean, Canadians are left wondering, what do the Conservatives have to hide? What is the government going to do to make sure that this problem is corrected?
The Honourable Minister of Employment.
Well, Mr. Speaker, so we've been embarrassing that the member opposite doesn't know or understand that this is an independent quasi-judicial body that is not managed by the government. Those charged with responsibility for the Social Security Tribunal determine what they report publicly. They tell me that they'll be increasing the number of decisions that they put online. Mr. Speaker, so if he has an issue with this, I encourage him to contact the chair of the quasi-judicial independent Social Security Tribunal.
The Honourable Member for Trois-Rivières. Mr. Speaker, transparency and equal access to justice are non-negotiable principles. That's why the Quebec Bar is worried. A year after its creation, the Social Security Tribunal has published less than 2% of its decisions, and yet they'd said that the vast majority of them would be made public. Government lawyers have access to all the case law, but not counsel for the claimants. Can the minister tell us when the tribunal will publish all its decisions, and why wasn't this done in the first place? The Honourable Minister. I'll say the same thing in French, Mr. Speaker. The Social Security Tribunal is a quasi-judicial, arm's-length tribunal. The chairperson of the tribunal said that more decisions will be published, but if the member wants a change in policy from the tribunal, I would suggest he contact the head of the independent quasi-judicial tribunal himself.
Mr. Speaker, last month the Minister of Transport met with stakeholders from my province of New Brunswick and listened to the concerns regarding CN's plan to discontinue rail operations in the Newcastle subdivision. Yesterday, my home province was pleased to host the Minister for an important announcement regarding passenger rail service in New Brunswick. Can the Parliamentary Secretary to the Minister of Justice please update this House on the agreement reached between VIA and Canadian National Railway?
Mr. Speaker, I'd like to thank the hard-working member for Miramichi for her great work. It's important to deliver the goods again, Mr. Speaker. Our government supports an efficient use of taxpayers' dollars, Mr. Speaker, all when delivering a rail service that meets the needs of today's Canadian citizen. And we're very pleased to announce that VIA and CN have made a tentative agreement on the remediation, the repair of the middle portion of the rail in the Newcastle subdivision in northern New Brunswick. That's good news. Mr. Speaker, this represents a $10 million investment on VIA in the repair of the tracks. And of course, Mr. Speaker, we're doing this in an efficient manner, and this shows our government's commitment to the local economies of New Brunswick and northern. Order. Can we move on now? The Honourable Member for Guelph.
Mr. Speaker, during last year's NHL playoffs, the government spent over $1 million on ads for a job grant that did not exist. You remember that? Feeding on Canada's heightened sense of veterans issues, now they're running ads on an underfunded and failing Veterans Career Services program during this year's playoffs. Why? Why would they spend millions of dollars more on ads while not properly funding the very programs that veterans have been pleading for?
The Honourable Minister of Veterans Affairs.
Mr. Speaker, that assertion is absolutely incorrect. I've heard time and again that Veterans Affairs needs to improve the communications with Canadian veterans and indeed Canadians, Mr. Speaker. Canadian veterans need to know that they have financial support available to them, in addition to the rehabilitation and mental health support that they need. Is that member really saying that we should not be telling veterans and informing them and their families how they can access benefits?
Ottawa Centre.
Last month, the Sri Lankan government launched a smear campaign against international civil society groups, including ones right here in Canada. These groups helped lead the successful push for an international independent investigation into the atrocities committed during the Sri Lankan Civil War. What actions are the government taking to protect peaceful Canadian citizens against the Sri Lankan ban? And will the minister consider targeted sanctions against those responsible for abuses and repression, as was recommended by the Foreign Affairs Committee in 2009?
The Honourable Minister of Foreign Affairs.
Mr. Speaker, no government anywhere in the world, no leader of any government in the world has stood up more strongly and more loudly than the Prime Minister of Canada when it comes to the challenges facing the people of Sri Lanka.
Absolutely correct.
I want to tell the member opposite we're certainly very pleased to continue our strong leadership on Sri Lanka. We're pleased to work with him and hear ideas and suggestions on how we can build on the strong record that we've taken to stand up against war crimes, to call for accountability, and to stand up against the growing authoritarian trend across Sri Lanka, Mr. Speaker.
Member for Nipissing, Mr.
Mr. Speaker, this week is National Mining Week. The mining sector is very important to the residents of my riding of Nipissing-Temiskaming and the Canadian economy as a whole, supporting 400,000 jobs and contributing $60 billion to our GDP.
Hear, hear.
Mining workers and communities across Canada can count on our government to stand up for their jobs. Can the Minister of Natural Resources update this House on the action our government has taken to support the mining sector?
Hear, hear. The Honourable Minister of Natural Resources.
For his tireless efforts in showcasing North Bay as a world-class mining service and supply centre. We're proud of Canadian mining activities here at home and abroad. We have a strong record of support for the mining sector, supporting workers, extending the mineral exploration tax credit, renewing the geomapping for energy and minerals program, to name a few. We'll continue to attract investment, support innovation, and maintain Canada's position as a world leader in mining through responsible resource development. Thank you, Mr. Speaker.
The Honourable Member for Beauharnois-Salaberry. Mr. Speaker, at a time when manufacturing is struggling to recover from the crisis of 2008, the Conservatives are neglecting to support our companies looking to take advantage of new markets abroad. Conservative mismanagement has led to a $40 billion shortfall for Canadian exporters, according to the Governor of the Bank of Canada. According to the Canadian Chamber of Commerce, Canada should do like the US, UK, and New Zealand and renew our trade policy to boost exports. When will this government snap out of it and implement policy that will genuinely support our exporters? The Honourable Parliamentary Secretary.
To thank the member for the question. Actually, the Canadian Chamber report showed that the progress our government is making is in the right direction, opening new markets for Canadian exporters, expanding the Trade Commissioner service. If the NDP would finally show their true colours and show Canadians that they oppose trade agreements. We've heard from over 80 witnesses at Trade Committee, Mr. Speaker, most of whom are really excited about these new markets and the jobs that come from them. It's only the NDP witnesses that are there to hold back trade and keep jobs suppressed, Mr. Speaker.
The Honourable Member for Haute-Gaspésie, La Métis-Matane-Matapédia. Mr. Speaker, it's high time Quebec's cheese and dairy producers were given the straight goods on the agreement with Europe. The federal government should stop keeping them in the dark over the compensation they'll get to offset the losses due to the additional 17,000 tons of European cheese imports. The Quebec Minister of Agriculture has officially asked Ottawa for details and wants the situation of Quebec's producers taken into account. When will the Agriculture Minister fully inform Quebec's cheese and dairy producers? And when will they get their compensation? The Honourable Minister of Agriculture.
Entitled to compensation, we haven't actually finalized the deal through this House of Commons, so I'm not sure what the member is talking about. Those consultations continue with dairy farmers, with the cheese producers across Canada. We look forward to positive results of that trade agreement, Mr. Speaker.
That concludes question period for today. Orders of the day is a point of order. The Honourable Minister of Immigration has a point of order.
Where's their cap?
I would like to raise a point of order. The NDP really likes to pretend that they're very virtuous, but during a question last week, the member for Ekensee-Bathurst, who is also the official language critic, deliberately tried to mislead this House, which is a shame. This member insinuated that we reduced funding for the Moncton Intercultural Association.
Order. Order. The Honourable Minister seems to be getting up to allege that a member has deliberately misled the House, which is normally raised as a question of privilege, not a point of order. And I haven't received any such notice. It's normally a requirement, unless it happened in this immediate question period. I think he indicated there was a question period from some time ago. The Honourable Minister might want to clarify.
Mr. Speaker, your guidance to us has been to correct the record as soon as the opportunity arose. This was the first opportunity, Mr. Speaker.
it seems like if the minister has reason to believe that a member has deliberately misled the House, then of course he can raise that as a question of privilege with the due notice. Otherwise, it sounds like it might be a continuation of debate and a different interpretation of the facts. So I'll await if there's a notice of a question of privilege. Of course, the chair will deal with it accordingly. At the great risk of continuing what seems to be continuation of debate, the honourable member for Bathurst is rising on the same point.
Well, Mr. Speaker, if the Minister of Immigration wants to start the debate, I'm ready for it.
I think I'll call orders of the day, order du jour.
Government orders. Government Bills Commons. Resuming debate at third reading of Bill C-23, Fair Elections Act, and on an amendment.
There are 9 minutes left for questions and comments for the honourable member for Nipissing-Temiskaming. Questions and comments. Questions and commentaire, the honourable member for Winnipeg North.
Yes, thank you, Mr. Speaker. I think one of the questions that really does need to be answered is why it is the government has chosen not to amend the legislation or election laws that would enable the commissioner or elections to compel a witness. Mr. Speaker, by not doing that, it's important that we recognize that the Government of Canada is actually weakening our election law in a very important part of it. That is one of the reasons why, Mr. Speaker, we were not able to get to the bottom of the matter at hand in terms of the many violations of election laws. Both the elections chief electoral officer has indicated he needs the ability to have the ability to compel, and so does the Commissioner, Mr. Speaker. My question to the member is, why is the government not recognizing the value of allowing Elections Canada to be able to compel a witness?
For Nipissing-Temiskaming.
Where the brand, you know?
I thank my honourable friend for the question, Mr. Speaker, and quite frankly, as I've indicated in my speech, that we listened hard to people, constituents across Canada. We listened to experts. We had a great deal of discussion at committee. You know, quite frankly, we've never done this, what the honourable member suggested before, and it's quite frankly that is an area of policing jurisdiction. So I think we've come up with a bill that is not perfect, but it certainly goes a long way to improve elections in Canada.
Questions and comments? Question et commentaire. L'honorable député.
The Honourable Member for Pierrefonds-Dollard. Thank you, Mr. Speaker. And I'd like to come back to the answer that my colleague just gave, because I don't agree with what he said. It's not just the opposition who is calling on the Conservatives to give this bill more teeth, to give more powers to the Commissioner to investigate. There's the annual report of 2012 of the Auditor General, who underscores the importance of obliging someone, compelling someone to testify. Does my colleague think that the Federal Elections Commissioner doesn't know what tools are useful for that? Because, Mr. Speaker, even if we saw that there was major electoral fraud in 2011, and to this day we haven't been able to identify the people who were guilty, so I think that that's the proof that this bill doesn't have enough teeth. People don't have enough powers to investigate, and the Conservatives, we see that they don't want to give the Commissioner those tools. Why, Mr. Speaker, why?
Member for Nipissing-Temiskaming.
Thank you, Mr. Speaker. I thank my honourable member for the question. As I've indicated, we've consulted far and wide, thorough consultation on this bill. This was deemed an area of policing jurisdiction, and therefore, we did not deem that it was necessary in the changes of the bill. We stand firm and fast behind our amendments. Thank you, Mr. Speaker.
Questions and comments? Question et commentaire. The honourable member for Yukon.
Speaker, and I'd like to thank my honourable colleague for his intervention. He mentioned in his speech a little bit about improving the integrity of the electoral system. And of course, now we've heard the opposition say that yesterday they were saying there was no fraud. There was absolutely no fraud, therefore no need to deal with any fraudulent issues. Then today they're up talking about robocall fraud, and there's still no need to make any changes. So which is it? Was there or wasn't there? Do we need to make changes? Don't we? And I think my honourable colleague made it very clear that despite their incoherent position on this topic, the fact of the matter remains is to protect the integrity of the electoral system. These changes are needed before a problem exists. We don't need to wait until one happens. We're moving forward to make sure that we deal with this before there's a problem. I just invite my honourable colleague to talk a little bit about those important changes that will only serve to strengthen the electoral process. Thank you, Mr. Speaker.
The honourable member for Nipissing-Temiskaming.
Well, thank you, Mr. Speaker. And I'd like to thank the member from Yukon, my honourable friend, for that question. And he is right. The basis, the way we've attacked this bill is we want to improve on our electoral system. We want to look at the measures that would tighten up the system, and right throughout this whole process, Mr. Speaker, we've used positive measures that would make the election system stronger. We fully realize that there were problems in the 2011 election, and we don't want those problems to persist. So we've been thorough in our analysis and consulting with experts, consulting with Canadians, and consulting in our own caucus and amongst other members. And we feel we've come up with a package that will improve the integrity of the Canadian voting systems. And that's what we're proud of in Canada, and that's what we want to maintain. Thank you, Mr. Speaker.
Questions and comments? The Honourable Member for Beauport-Limoilou. Thank you very much, Mr. Speaker. The member for Nipissing-Temiskaming is grabbing at straws. Now, you know, Mr. Speaker, the Conservatives are seeking to create confusion around the irregularities linked to the identification of voters. But there is no case of fraud linked to that, and the Conservatives are really twisting words in that regard. So I would like to remind my colleague, as my other colleague did, that there was an alleged case of fraud that involved the Conservatives' database. Unfortunately, the Commissioner of Elections Canada ended his investigation because he was not able to get to the bottom of things. So on March 12th, 2012, they voted with us in favor of a motion to broaden those powers. So why is he going back on his word?
Thank you, Mr. Speaker, and I'd like to thank my honourable member for his question. Quite clearly, there's no confusion with respect to that particular item. We're clear on where we wanted to go with vouching right from the get-go, and it's clear from some surveys and polls that have been taken that 86% or nearly 9 out of every Canadians agree with it. So there's absolutely no confusion, Mr. Speaker. The only confusion that exists is the confusion in the opposition party, where they continue to fearmonger and create all kinds of misgivings about this particular legislation that isn't valid.
Questions and comments? The honourable member for Ottawa South.
Mr. Speaker, for Canadians who have been studying and watching this debate about this bill, they have they've come to a natural conclusion. Normally, when you tamper with something or change something as fundamental as our election system, you would expect all-party consensus. That's how most governments have operated in the last century. But here's what they also hear. 100-plus experts in Canada and around the world opposed. Former head of Elections Canada opposed. Existing head of Elections Canada opposed. Former Auditor General Sheila Fraser, the Conservative hero for a decade, opposed. Commissioner of Elections Canada opposed. My question, Mr. Speaker, is simple. Why is it all of these experts who are seized with this question of democracy in Canada and our election system, why is it every single one of them is wrong?
Honourable member for Nipissing-Temiskaming, you have about 30 seconds.
Well, thank you, Mr. Speaker, and I'd like to thank the honourable member for his question. He mentioned several people that are opposed. Well, I just told you, 86% of the Canadian people are for us. 9 out of every Canadian are for us. We're not for satisfying elites. We're for satisfying the majority of the election that we represent. Thank you, Mr. Speaker.
Resuming debate, reprise de débat, the honourable member for Hamilton Centre.
Thank you very much, Mr. Speaker. That last answer was a bit rich. First off, I will be sharing my time with the member, my colleague from the riding of Louis Saint Laurent, Mr. Speaker. So, okay. Only got 10 minutes, so it doesn't give a lot of time to try to hit the highlights and the low lights of C23. I'm glad to see the chair of the committee is here to join in heckling. He doesn't get to do that when we're at committee. Glad you get a chance to do it now. Bring her on. First thing I want to talk about is the fact that C23 really does deserve to be called the Unfair Elections Act. And I ask anybody watching to hear the evidence and conclude for themselves whether or not they believe the process was anything close to fair or reflects Canadian values or the way that we should be making laws in this country. First off, no consultation with anyone who didn't have a Conservative membership card. We did not find one witness, although I think the leader of the Green Party said that she had an opportunity to give some input on something. But there was no experts, no involvement of the opposition parties. There was no consultation with anyone except card-carrying Conservatives. In fact, I'd be surprised if that bill was even drafted here on Parliament Hill. I suspect it was probably drafted out in the private sector somewhere at a law firm that's a good friend of the government, but that's mere speculation, Chair. We didn't have time to go down that road. So, right off the top, one would think that common sense would dictate that if you're going to change our election laws, that the first thing you would do is talk to the Chief Electoral Officer. Like, is that so shocking and so difficult to figure out that step one of changing our election laws is to talk to the individual that is mandated not by the government, but by Parliament, works for Parliament, hired by Parliament, accountable to Parliament on our election laws, the Chief Electoral Officer, not even consulted. After the minister tried to make his little 1-hour meet and greet, howdy-do, tried to turn that into a consultation. That didn't work because it wasn't. The Commissioner of Elections Canada, not consulted. Both of their opinions on this bill, both don't support it. Neither do either of their predecessors. How did the opposition feel about having involvement in C23? We didn't get any. There was no involvement by anyone who didn't carry a Conservative membership card. So when my friend across the way makes comments that they represent ordinary people, they don't want to hear from elites, fine. If they want to call the Chief Electoral Officer an elite, they can play whatever word game they want. But the fact remains, that's the person Canadians trust, not this government, and sure as heck not the Minister of Democratic Reform. They trust the Chief Electoral Officer, who they didn't talk to, and when we, the opposition, gave him voice, he was against it. And he had serious concerns about it, as did the Commissioner of Elections, and as did the Director of Public Prosecutions, whose whole department is being moved. He wasn't consulted either, and he expressed some concerns. So what happens? The government doesn't talk to anybody. They bring in this Unfair Elections Act. It comes into the House in first reading, and the first thing we did, Speaker, was still try to save the government from themselves, if you will, if they were sincere about a fair process. And we offered to use a mechanism that's here in the House, and we adopted it at Queen's Park back in the day when I was there, because it's a good mechanism. And what it is, that the Minister of the day can take an issue that's brought to the House on first reading and send it directly to committee. Now, the reason you do that is because it's second reading, where we all put political skin in the game, where we're arguing what our point of view is, defending attacks from others, and taking a position and voting. And by the time you get to third reading, it does get politically difficult to start making major changes in position after you've been at second reading. So by sending it to committee ahead of time, members are free to set aside their partisan membership card and just be an MP. And just work at the committee as an MP. Then it can come back to the House at second reading, and if they do their work, and in a fair world, that report would come back having the unanimous support of all members who are on that committee, which would hopefully lead the House to support that unanimously. Then we've got an election law that we can all agree on. And this was brought in when the Olympics were on, if you recall, a major distraction, of course. But the fact is, it's a good example, because in the Olympics, it wasn't the host country that decided on what the rules would be for the Olympics. Those are decided when? Ahead of time. And everybody agrees on them. And then they have the races and the jumps and the swims and all the things they do, because they've all agreed on the rules, that you're not fighting. Remember when we were kids and you'd spend most of your time in the back alley, pickup game of ball, you spend half your time fighting about what the rules are going to be rather than actually playing the game. So you set the rules ahead of time, everybody agrees, everybody understands. Great, now let's get to the business at hand. And in the case of Olympics, it's sports. In the case of making laws, it's getting unanimity in this House around election laws and rules, so they're fair for everybody. We weren't seeking any advantage. If anything, we're trying to stop the government from putting advantages in the bill for themselves. So we offered to do that. They said no. It came second reading. Guess what happened right away? Boy, this time goes quick. What happens at second reading? Boom! Boom! The government brings in closure. That's it. Shuts down debate. No more debate. So let's see now. We got this right. Only Conservatives had input. The Chief Electoral Officer wasn't spoken to. The Commissioner of Elections wasn't spoken to. There was nobody else spoken to. And when they brought it in the House for debate, the first chance they had, they shut down debate. Where's the fairness? No fairness. Where's the fairness in that? So off we go to committee. And the first thing that we as the official opposition want is to take the bill, guess where? Out into the public, to let Canadians who actually own the election laws, to give them an opportunity to comment in the communities that they live. They wouldn't go for that. We had a rather protracted filibuster to make our points. We did the best we could. At the end of the day, the government has a majority. They win every vote 10 times out of 10. We had the hearings. The government's now saying, well, you know, we shut it down in the House because we send it to committee, because that's where the work gets done. The real work gets done in the committee. So, you know, it doesn't mean anything we shut down debate in the House, the floor of the House of Commons. We get to the committee, so you would think that we would take this 240-page, two-page bill, and that we would go through it very carefully, line by line, and make comments and vote on the clauses and amendments if necessary. You would think so. We didn't even get halfway through the amendments, and we did not even get halfway through the bill when the May 1st 5 p.m. deadline came along, and boom again, democracy was shut down. So, Speaker, there's probably this much of the bill that nobody who doesn't have a Conservative membership card got a say in, because there was no consultation ahead of time and it wasn't reviewed at committee, and we can't review it now because this debate is being shut down through closure. So this part here, at the very least, is pure Conservative Party documentation, because nobody else has had a chance to look at it, because they shut down debate. That alone should worry people, that there's so much shutting down of debate about a Fair Elections Act. I want to get this in. I know you're going to be the 1 minute speaker. I just got to get this in. I don't have my segue's not there. I'm going to say this anyway. It needs to be said. May the 20th, just the other day, Senator Marshall, who's the government whip in the Senate, said this, quote, "As the government whip in the Senate, when a government bill comes forward, I would expect our Conservative senators to support it," end quote. So anybody who's under any kind of illusion that there's real democracy happening over there, even if it's not happening here, is wrong. There's no democracy there. There's no democracy here. There's no fairness there. There's no fairness here. We will continue with every breath that we have and every vote that we have to try to stop this bill and amendment to its very end, which is coming real quick. But make no mistake, Canadians know that this is a bill that's meant to help the Conservatives get re-elected, not make our democracy stronger. And the NDP will stand up for a proper and fair elections process every day.
Questions and comments? Questions and comments? Questions et commentaires? The honourable member for York West.
Mr. Speaker, and I have to tell you that I agree absolutely every single thing that my colleague has said. This is an affront to democracy no matter what you say, because if the government had confidence, they wouldn't be afraid of having hearings on something as important as the future of democracy in this country. Rather, I suggest that what they're trying to do is completely get it so in a way, not only did they use the rules and go around everything possible last election to win, they have less confidence in winning the next one, so they're rejigging every rule possible to make sure they win the next one. That's what they think. I'd like to hear more comments from my colleague on that issue.
Honourable member for Hamilton Centre.
Well, thank you very much, Mr. Speaker, and I thank my colleague for her comments. And it is true, as far as we're concerned on the opposition benches, this isn't a partisan matter. The shame of it is that the government has made it a partisan matter, and we are united on the opposition benches. But let me give a key example of something. The government makes a big deal about the changes they made. There are big changes still that didn't happen. For instance, quickly, Speaker, there is now a registry for robocalls, which the government is touting as a great thing. That's not a bad idea. Originally, they were only going to let the records be kept for 1 year. Through pressure, we got them to move it to 3. But the fact remains that information is still not going to be sent from the companies that do the robocalls to the CRTC. If you send it to the CRTC, they will have that information, it will be protected, and it will be dealt with as part of a public trust. The bill doesn't do that. It still leaves it in the hands of the individual. So if there are investigations after, we don't have the power to have compel witnesses to give testimony, and so they're going to have to chase these people. And what happens if somebody sets up a robocall firm before the election and declares a bankruptcy afterward? What happens to all that information that's supposed to be kept? Gone. And that's why we said put an amendment in that sends it to the CRTC right away, and then it's there and it can be used if necessary. They wouldn't do it, and that's just one more example to you, Speaker, and my colleague, of the unfairness that exists in C-23.
Questions and comments? Questions et commentaires. The Honourable Parliamentary Secretary to the Minister of Agriculture.
Thank you very much, Mr. Speaker. My colleague made some comments about nobody's had time to see this bill, nobody's had time to study this bill, the House hasn't been informed on this bill. But, Mr. Speaker, I would like to tell this House what Canadians probably, hopefully already know. There were a total of 15 committee meetings on this specific bill, amounting to roughly 31 hours of study. There were 72 witnesses, Mr. Speaker, that came in front of committee to present their viewpoints on this bill. And, Mr. Speaker, in terms of debate here in the House, it's going to be in approximately 22 hours of debate. So I'd ask this member to apologize to Canadians for having misled them on the amount of exposure that this bill has both had within Canadian society and within the House. He should apologize, Mr. Speaker.
The honourable member for Hamilton Centre.
Yeah, like that's going to happen. The fact of the matter is they can make 22 hours sounds like a lot, but in this place that's not very much. Let's look at the record. I've already said that the committee nor the House has had a chance to look at half this bill. Half the bill has not been looked at by the House nor the Standing Committee. So how can anybody say that it's been thoroughly looked at when the pages weren't even turned?
Questions and comments? The Honourable Member for Louis Saint Laurent. Short question. I sincerely thank my colleague from Hamilton for his speech and for his work on this issue from the very outset. I find it particularly outrageous to hear the question posed such as the one that just came, knowing that my colleague and I sit on that committee. We have a very good knowledge of what happened during those hearings, and if the Conservatives had taken into account a single opinion of any of those experts that came and appeared before the committee, we might have said, okay, well, maybe they changed their ideas on certain things, but that was not the case. So stop boring us with those hours of consultation that they're talking about when we know very well that the government side just sat there nodding and the witnesses left and they never changed their position by one iota on this bill. So I'd like to hear his comment on that and to hear just how outrageous it is that even if so many people came, their opinions were not taken into account.
So I thank my colleague for the question. Two things. Every time the bill has come to the House, the government has imposed closure, meaning they've shut down debate. Every single time, this is another time. And when we were in committee, the government said on May the 1st at 5 p.m., no matter where we are, we're done reviewing it. On May the 1st, we were done only half. This has not been thoroughly dealt with. There was no consultation on this. The last thing this is a Fair Elections Act. The process was totally unfair. The government knows it, the public knows it, and they're going to pay a price.
Resuming debate. The Honourable Member for Louis Saint Laurent. Thank you, Mr. Speaker. Thank you very much. I want to start my speech by reiterating, and I want to particularly thank my colleague from Hamilton Centre and my colleague from Toronto Danforth on their exceptional work on this issue from the outset. I think that these are people who really hold our interests in our democracy at heart. They have that at heart. They have worked so hard, and they continue to put pressure on the government on this issue. And I think we really managed to make them back down on a few points that were really just poisonous on this issue. So I really want to thank them. They give me hope in our country and in our democracy each time they intervene. I'd like, therefore, to come back to what my colleague was saying earlier and elaborate a bit more on the various stages of the process that was set up for this bill. So, first of all, I was here yesterday. I was making a speech that unfortunately was very similar to this because we were at report stage of Bill C-23 when I was here yesterday. And what I said during that speech was talking about the process in general, and I gave a brief history of how these events unfolded. Today I'd like to talk a little bit more specifically about some aspects of things that happened in committee and certain amendments that were rejected, which in my opinion really see as a great problem. And it shows to what degree things can become unpleasant between parties where they don't listen to anyone but their own friends. They're plugging their ears and governing like despots. As I said earlier, the Conservatives continue to repeat ad nauseum about the 72 witnesses that we heard from committee, the some 30 hours of committee hearings, and then obviously the bill that was well studied and thoroughly studied, and what's the opposition complaining about? And I find that contemptible. The reality is that I was sitting there at the committee during all of those hours, hearing witness after witness tell us that this is a huge problem with the bill, you should take this out completely. This is another problem that you should start from scratch with. Here's another problem. And it just piled up and piled up and piled up. And through all of that, the Conservatives never said, oh, that's interesting. We hadn't seen it from that perspective. Perhaps we could fix that or do it a different way. No, never. They just dug in their heels and stuck with their original position. Some witnesses, Aboriginal women's groups, for example, they were practically looked at with contempt. They weren't listened to at all. They were told, oh, let me explain to you how this worked. And this was in a really paternalistic way. And I was embarrassed to be sitting there and to be part of this process when it was unfolding in that kind of a way. It was terrible. And at the end of the day, when we started clause-by-clause study, my colleague was mentioning that we went through only half of the amendments. So, but when we talk about the bill itself, we only got to page 44 out of 250 pages. So do you think that that's a process that is appropriate when we're changing our electoral laws? It is one of the most important pieces of legislation in our democracy. But they're saying, oh, no, it's fine. We studied it long enough. That's good. You know, we're done. And we're putting an end to the debate, and we won't have any more. So for me, it is a huge problem. And I'll go into more specific details. I have different aspects that I wanted to address here today, things that happened at the committee. For example, one of the most contentious elements concerned Section 18 that concerned Elections Canada's powers. So in C-23, what they tried to do was to completely muzzle the Chief Electoral Officer and Elections Canada by forcing Elections Canada to not be able to communicate except as concerned extremely basic information like where to vote, how to vote, and who can vote. So all they were saying was that Elections Canada can no longer communicate with the public outside of that very narrow scope of that sort of information. So many people came and said to the committee, that is unheard of, that makes no sense. There's no other democracy on the planet that functions in that way. And there were so many people who came and protested against it. So they stepped down on that. But what is that? It's hard to understand it.
What the change they made was that now Elections Canada can no longer advertise except on those limited points. So the idea is that they can still hold a press conference on this, that, or the other thing. That's not so bad. It's better than before. So the amendment is better than the original C-23. But they added another thing. The CEO can do democracy promotion among primary and secondary school students. Why did they add that? Mr. Speaker, at committee 4 times I asked my colleagues, does that mean they can do outreach at universities? Can they do outreach to promote democracy among First Nations and other target groups that Elections Canada may feel need the outreach? And I got no answer. And I really tried. I really tried to ask repeatedly. I just want to know. Maybe that's not the case. The way I read it, it gives the impression that they can't do anything else. But I just wanted to know. Prove me wrong. I'd like it if they could do that kind of outreach. But I don't think they could with this amendment. I don't think the other target groups can. I don't think they'd be allowed to do that. Another thing is the voter ID card. That will not be usable to establish a person's ID. We fought to try to keep that. I think we had excellent arguments for the continued use of that card for ID purposes. And after really trying everything under the sun to keep that card in use, but no, they were apparently determined to stop allowing its use. And so we said to ourselves, okay, well, let's try to limit the damage. For anyone going to vote with that card, why not amend the bill to say to the Chief Electoral Officer that on the voter identification card, why not write in all caps and bold, "This cannot be used to identify yourself when you go to vote"? As simple as that, just to avoid confusion, so that people wouldn't show up at the polling station with their voter identification card and another piece of ID thinking they'd be allowed to vote. Because what's going to happen when maybe they take their lunch hour at work, maybe they've traveled far to get to the polling station? We want to avoid situations where people get there and get sent home and told, you know, you can't vote, sorry. I really don't understand the logic behind this. I can't think of a single reason why you would refuse having it indicated clearly on the card that you can't use this as ID. I asked that committee, I said, could you tell us why? What's the reason for disallowing or refusing to indicate clearly on the card that this can't be used as ID? And I can't find a single reason. I haven't been given a single explanation. There's no explanation. I've searched high and low. I've tried to get an answer, but ultimately, there's none. And finally, as my colleague mentioned in question and answer earlier, everything that has to do with the list of companies that have contacted voters, I think it's a good thing on the whole, better than nothing at all. But what a lot of witnesses pointed out was that it wouldn't be very useful because they don't have to keep the phone numbers they called and they don't have to record the calls. I mean, it would be totally simple to do that. There's absolutely no reason not to, but ultimately, no. The list will be kept for too short a time. It won't indicate the script or the phone numbers that were called. So basically everything that would make the list, the register, useful is not going to be kept. So I think this is a real missed opportunity. C23 is a missed opportunity to make genuine change in full respect of our democracy, and it's a real crying shame, Mr. Speaker.
Question et commentaire. Question.
Questions and comments?
The honourable member for Ottawa South.
Merci, Monsieur le Président, et merci.
Thank you, Mr. Speaker, and thanks to my colleague for her speech. I'd like to ask her a question. It has to do with the Conservatives' approach to this whole debate. And this has been the case ever since this Prime Minister was elected. The Conservatives have a bad habit, and this includes personal attacks. Since this government took office, they've attacked Linda Keane, who was fired, the former parliamentary budget officer, the head of Statistics Canada, more recently the Chief Justice of the Supreme Court of Canada, Ms. Fraser. Last week, the CEO of Via Rail was personally attacked, the leader of the Chief Electoral Officer, and so on. And it just keeps on going. What does she think of this approach to something as important and as fundamental to Canadian society as electoral reform? The Honourable Member for Louis Saint Laurent. Thank you, Mr. Speaker. I'd like to thank my colleague from Ottawa for his question. I truly believe this is a major problem that we've never before encountered in Canada. It shows disdain, a total disrespect for people who are completely non-partisan. Not that I think that we should be launching into personal attacks on a partisan basis either, but these are officers of Parliament who work in the interests of Canadians, and they are under relentless attack by the Conservatives. And I think that's particularly serious in the case of this bill. The attacks against Mr. Méran. When a minister goes so far as to say that if Mr. Méran is opposed to C23, it's because he wants more money and more power, I personally was disgusted by that, because I think that since the beginning, Our chief electoral officers have done outstanding work. They've tried by all means possible to be as fair as possible, to do their job in the best possible way, and they really did not deserve to be attacked in that fashion. Questions and comments?
The honourable member for Abitibi Bay James, Nunavik, AU.
Thank you, Mr. Speaker. And I'd like to thank my colleague from Louis Saint Laurent for her excellent presentation. We're fortunate to have her as a colleague. I'm not a member of the committee that she sits on, but her speech really explains the situation very well, the troubling situation that we find ourselves in today. I wasn't even sure, listening to her, that she could possibly be talking about Canada, our country. Since I got here 3 years ago, I've been witnessing the dismantling of the institutions of our country by the Conservative government, dismantling of the economy, of the environment, and now, very surely, the dismantling of our electoral system. And this troubles me, Mr. Speaker. These people opposite, despite the reasoned amendments that we have suggested to improve this bill, because it's important to say so, Mr. Speaker, we're talking about the democratic legislation of Canada. The honourable member for Louis Saint Laurent. 1 minute. Thank you, Mr. Speaker. Of course, I'd like to thank my colleague from Abitibi, James Bay, Nunavik, AU for his question and comments. I think he gets it. He knows what the issues are. And I think, yeah, it's a real problem when you get to the point that something as fundamental as democracy is being attacked here. In this case, this is an act that will affect all Canadians without exception. It's going to change things fundamentally, and it's going to undermine our democratic institutions. And the background to all this, in short, I'll quote our leader. I think he does a good job of summing up the Conservatives' mentality, and that is that they love power, but they don't like governing.
Resuming debate, reprise de débat, the Honourable Parliamentary Secretary to the Minister of Citizenship and Immigration.
Thank you, Mr. Speaker. And Mr. Speaker, it is with great pleasure that I arise today to speak in support of the Fair Elections Act, and I appreciate the opportunity to do so. Bill C-23 addresses important issues that are fundamentally essential to a strong democracy and has succeeded in bringing them to the forefront for public discussion. It is important that my constituents in Richmond Hill and that Canadians across our country are aware of how this important legislation strengthens the integrity of our voting processes. That is why I am pleased to highlight some of the important improvements this bill brings to our democratic system. Bill C-23 will ensure that everyday citizens are in charge of their democracy. It responds to many of the issues identified by the Chief Electoral Officer in terms of where improvements are needed. In fact, the Fair Elections Act implements 38 of the recommendations that the Chief Elections Officer found in his report following the 40th general election and in his more recent report on deceptive communications. The Fair Elections Act addresses many of the recommendations made in the Neufeld report, which was commissioned by Elections Canada following the 2011 general election, such as the recommendation to, and I quote, further support the simplification of procedures for polling staff, request an amendment to the Canada Elections Act to reduce as much as possible the number of verbal oaths required from electors. Where legal formality is warranted to ensure procedural integrity, instead requires signed declaration forms. And I close the quote. And the recommendation, Mr. Speaker, to ensure there is a supervisor in charge at every voting station, that their authority is clear, and that each supervisor has the power to ensure polling staff comply with legally required procedures, as well as the recommendation to investigate ways to reduce the number of voters who have their identity and address of residence vouched for on elections day. For instance, by improving and extending the pre-vote advertising campaign that encourages electors to bring appropriate identification to the polling site with them. Mr. Speaker, Bill C-23 addresses important issues, like the significant drop in voter turnout that has been taking place over the last 25 years, and the need to improve the integrity of our voting system. We simply need to do a better job of motivating electors to vote. Citizens in countries around the world have fought and died for their access to democracy and their right to vote. We here in Canada must not be complacent, nor should we take this very special privilege for granted. We cannot afford to stand still on these issues, and we won't. Let me explain how Bill C-23 will improve the integrity of our democratic system. The amended bill proposes to eliminate identity vouching. The fact this is currently allowed has actually been a surprise for many of my constituents and to many Canadians who were dismayed to learn that this practice even exists. By Elections Canada's own admission, the practice of vouching, where someone states that they know someone else who has no identification, is rife with irregularities. I would like to read into the record an important passage from Elections Canada's own compliance review, or the Neufeld Review, as it is commonly referred to, that was undertaken following the 2011 election, and I quote, all Canadian citizens 18 years of age or older have the right to vote in the federal electoral district in which they reside. The Canada Elections Act provides a wide range of procedural safeguards designed to protect the integrity of the electoral process. A subset of these safeguards requires voters to demonstrate eligibility, identity, citizenship, age, and residency before they can receive a ballot. For the vast majority of electors that are already registered at their correct address, Elections Day procedures involve a simple, efficient check of a single piece of photo ID to confirm identity and address of residence. However, for any persons who are not registered or do not possess accessible identification documents at the time of voting, election officers must administer special exception procedures prescribed in legislation. Ensuring voter eligibility through the administration of these special exception procedures is an expected part of election officers' duties. Errors that involve a failure to properly administer these procedures are serious. The courts refer to such serious errors as irregularities, which can result in votes being declared invalid. Mr. Speaker, the report goes on to say that most Canadian elections officers struggle to administer the complex rules of exception procedures they are expected to conduct as part of their temporary Elections Day roles. I quote again from the Neufeld report. An estimated 15% of voters need some type of exception process to be administered before they can be issued a ballot. While administering regular voting procedures is usually straightforward, the audit showed that errors are made in the majority of cases that require the use of non-regular processes. Serious errors of a type the courts consider irregularities that can contribute to an election being overturned were found to occur in 12% of all Elections Day cases involving voter registration and 42% of cases involving identity vouching. Overall, the audit estimated that irregularities occurred for 1.3% of all cases of Elections Day voting during the 2011 election. Mr. Speaker, more than 12 million Canadian citizens cast ballots on May 2, 2011, and the audit indicates that the applications of specific safeguards in place to ensure each elector is actually eligible to vote were seriously deficient in more than 165,000 cases due to systemic errors made by elections officials. Averaged across 308 ridings, elections officers made over 500 serious administrative errors per electoral district on elections day. Obviously, this is unacceptable. I think that most Canadians would be concerned to hear that serious errors, ones that can contribute to an election being overturned, were found to occur in 42% of cases involving identity vouching. In the 2011 election, the Neufeld report found that there were 45,868 cases where no record was kept of who the voucher or the voter was. Yes, that's 45,868 cases where no record of the voucher or the voter was kept, Mr. Speaker. This same report goes on to suggest that public trust in proper administration of the electoral process is at serious risk if these error rates are not addressed. It says that the overly complex procedures to administer vouching cannot be remedied simply by improving quality assurance, and concludes that redesign through simplification and rationalization is necessary in order to reduce the risk of such errors. That, Mr. Speaker, is precisely why we have brought forward Bill C-23, the Fair Elections Act, to address these concerns in a practical, transparent way. The status quo is simply not an option. I agree with this statement in the Neufeld report, which says citizens' trust in their electoral institutions and democratic processes are put at risk when established voting rules and procedures are seen not to be followed. Even the perception of problems can be extremely detrimental to this trust. Public trust in an electoral process is fundamental to perceptions about the legitimacy of democratic governance. How does Bill C-23 propose to solve these problems, as identified by Elections Canada? By allowing electors to vote with two pieces of identification that prove their identity, and by taking a written oath as to their residence, provided that another elector of the same polling division who proves his or her identity and residence by providing documentary proof also takes a written oath as to the elector's residence. The difference between this and what we have now is that electors will have to prove their identity. There are 39 pieces of possible identification that could be used, including a driver's license, a health card, a citizenship card, birth certificate, social insurance number card, student ID card, utility bill, hospital bracelet worn by residents of long-term care facilities, correspondence issued by a school, college, or university, a statement of government benefits or attestation of residence from a shelter, a soup kitchen, a student, or senior residence. This new measure will allow those who do not have identification proving their residence to register and vote on polling day. By ensuring electors can properly identify who they are within these acceptable 39 ways, we are helping to restore faith and trust in the system. To ensure the integrity of the vote, we are also proposing a verification of potential non-compliance to be conducted after polling day, and an audit of compliance with registration and voting rules after every election. These changes will add procedural safeguards to protect against duplicate voting and impersonation. I would also like to highlight how the important ways that Bill C-23 provides better customer service for voters. In 2011, indeed, 60% of non-voters cited everyday life issues as the reason for not voting. This included reasons such as traveling, work or school schedules, not enough time, or lack of information. We believe that better customer service will help remove these practical obstacles, Mr. Speaker. For example, Bill C-23 adds an additional day for advanced voting. It also brings forward changes that will reduce congestion at the polls. Additional election officers will be appointed at the polling stations, Liaison officers will be appointed to facilitate communication between the Chief Electoral Officer and returning officers in writings, and the time allowed for election officer training will be increased, Mr. Speaker. Mr. Speaker, Bill C-23 will return the role of Elections Canada back to the basics. As noted earlier, voter turnout in general has decreased from 75% in 1988 to 61% in 2011. During this same time period, Elections Canada had the responsibility for promotional campaigns. A Library of Parliament analysis also shows that from 1984 to 2000, the voter turnout for youth aged 18 to 24 dropped 20 percentage points. Unfortunately, this trend has not been reversed in recent years. It has been found that the main reasons for youth not voting were not knowing where or when or how to vote. The job of an election agency is to inform citizens of the basics of voting, where to vote, when they can vote, and what ID they need to bring. It is also incumbent upon the agency to ensure disabled people know the extra tools available to help them vote, such as wheelchair ramps, sign language services, or Braille services for the visually impaired. We need to devote our full attention to getting this complete information into the hands of electors, Mr. Speaker. Bill C-23 will define the public information and education mandate of the Chief Electoral Officer by specifying that advertising by the Chief Electoral Officer is to focus on informing electors about the exercise of their democratic rights, on how to be a candidate, when, where, and how to vote, and what tools are available to assist disabled electors. The Chief Electoral Officer may also support civic education programs for primary and secondary schools. In addition to these important changes, the Fair Elections Act also proposes to protect voters from roll calls and impersonation with a mandatory public registry for mass calling, prison time for impersonating elections officials, and increased penalties for deceiving people out of their votes. It also allows the Commissioner to seek tougher penalties for existing offences, bans the use of loans to evade donation rules, and upholds free speech by repealing the ban on the premature transmission of election results. It provides for more than a dozen new offences, making it easier for the Commissioner to combat big money, roll calls, and fraudulent voting. Mr. Speaker, we have listened to Canadians and our colleagues throughout this important debate and have supported a number of amendments to the original bill. To make it even better, I thank everyone involved in this process, including the witnesses at committee, my colleagues, and my own residents of Richmond Hill for their input. Some of these amendments I have already mentioned, like the allowing of vouching for residency, and the clarification of the mandate of the Chief Electoral Officer to include the support of civic education programs for primary and secondary schools. Other amendments, Mr. Speaker, include retaining current appointment process for central poll supervisors, eliminating the proposed exception as to what constitutes an election expense in the case of expenses incurred to solicit monetary contributions for past supporters, amending the provisions to require that the Chief Electoral Officer consult with the Commissioner of Canada Elections before issuing an advance ruling or interpretation note. This provides more time for the Chief Electoral Officer before he has to issue an advance ruling or interpretation note, while reducing the consultation period with the registered parties and giving advance rulings precedential value for the Chief Electoral Officer and the Commissioner with respect to similar activities or practices carried out by other political entities. Requiring calling service providers to keep copies of scripts and recordings for 3 years instead of 1. Allowing the Chief Electoral Officer and Commissioner of Canada Elections to exchange information and documents, and allowing the Commissioner to publicly disclose information about investigations where it is in the public interest. Increasing the spending limit for elections with a longer writ period than the 37-day period. adding a clear prohibition against a third party unable to show a link to Canada incurring more than $500 in an election, clarifying the intent of giving the Commissioner the unrestricted ability to begin investigations by removing the bill's proposed evidence threshold before the Commissioner may begin an investigation, clarifying the intent of having no limitation period for offences under the Canada Elections Act that require intent, making the term of the Chief Elections Officer non-renewable, clarifying that all those who apply for a special ballot and vote at the office of the returning officer must prove their identity and residence as they would at a polling station, thereby closing a potential loophole, clarifying that the annual report of the Director of Public Prosecutions must contain a section prepared by the Commissioner of Canada Elections through which the Commissioner reports on the activities of his office without providing information about specific investigations. These are common sense principles, Mr. Speaker, and Canadians agree. The Chief Electoral Officer has been very clear in saying that reform needs to be in place before the next general election. Mr. Speaker, I applaud the good work of the Minister of Electoral Reform in preparing this bill, which will significantly restore confidence in the electoral system and improve voter turnout. I am proud to support this bill, and I urge all of my colleagues in this House to support it. Thank you, Mr. Speaker.
Questions and comments? Questions et commentaires. Honorable député de Beauport-Limoilou.
The Honourable Member for Beauport-Limoilou. Thank you, Mr. Speaker. The member for Richmond Hill is boasting about this bill, but I don't know how he can go out and meet his voters and look them in the eye and say that his party is improving the election process. Mr. Speaker, in December 2005, at my first federal campaign, during my press conference, I really showcased the fact that 40% of our voters in Canada, unfortunately, do not turn out to exercise their right to vote. And in that group, this proportion of 40%, well, there's a lot of young people who don't participate either. Neither do Aboriginals. They do not participate. They don't turn out to vote in large numbers either. So in the most vulnerable groups of our society, those people are taken hostage by the powers that be. This voter turnout rate is even lower. It's somewhere between 30 and 40%. Now, Joseph Stiglitz, the Nobel Prize winner for economy, talked about this Tea Party style approach, people who want to exclude the most marginal groups of society by using processes that we see in Bill C-23. So I would ask the member for Richmond Hill how he can exclude the most marginal groups from society in his riding from this democratic process.
Thank you, Mr. Speaker, and I thank the member for his question, although I find his commentary rather disturbing. First of all, let me assure the member that I'm very proud to represent the good people of Richmond Hill, sir, and through you, Mr. Speaker. And I have every I make every attempt to engage my constituents in important pieces of legislation and the work that happens in this House, as I do with this one. And I can tell the honourable member that despite his fear-mongering and very partisan commentary to his question, I can assure him that my constituents in Richmond Hill are with the 86% of Canadians across this country that support this legislation, and they are on side with the 89% of all Canadians, Mr. Speaker, that say that we need to have some form of identification in order to vote. 165,000 cases, Mr. Speaker, in the 2011 election. I say to the honourable member the following. If he can look at his constituents and tell them that they can trust that every single one of the cases of vouching across this country that has ever happened or will happen if things were to transpire the way that he would like to see it happen are honest, then I would say to you that he would be disingenuous in communicating with his constituents. Thank you.
Questions and comments? Question et commentaire. The honourable member for Ottawa South.
Thank you, Mr. Speaker. I have a very direct and specific question for the member.
Why does this bill not provide the Commissioner of Canada Elections with the power already held by the Commissioner of Competition under Section 11 of the Competition Act? That is, the power to ask a judge to compel witnesses to testify in cases of electoral fraud. Why does this bill not contain the power already held by several provincial chief electoral officers or commissioners? New Brunswick, Nova Scotia, Quebec, Ontario, Manitoba, Alberta, and Yukon. Internationally, other electoral management bodies have this very same power. Australia, the United States. So without bobbing and weaving, without making up facts or inventing crises, can the member explain to his constituents of Richmond Hill why this is the only order of government in Canada right now that is preventing this power from going forward?
Honourable Parliamentary Secretary.
Well, Mr. Speaker, I find it somewhat questionable that the member from the party that invented bobbing and weaving would be using those two words in a preamble to his question. But his question was specific as to the role of the Commissioner. And, Mr. Speaker, it's very clear. The Commissioner, and this is a direct answer to the member, and I hope that he stops speaking over there and he listens to the answer because he asked for it. The Commissioner has the same powers, similar powers, as the RCMP, Mr. Speaker. We have made him completely independent, giving him sole control of his staff in this bill, sole control of his budget, and his investigations. We also give, in this legislation, the Commissioner new offences to help him in his investigations. Now, if the member would stop chirping over there, he might be interested to know that for the first time the Commissioner will now have powers like obstructing an investigation and providing false information as extra tools that he can use to enforce his power during his election investigation. So I say to the honourable member, stop fear-mongering, stop with this nonsense, get on board with this legislation so that we can all be proud of the results of the 2015 election process, Mr. Speaker.
Questions and comments. Question et commentaire. The Honourable Parliamentary Secretary to the Minister of Agriculture.
Thank you very much, Mr. Speaker. I would like to ask my colleague about the opposition position. Mr. Speaker, they've staked out their ground on vouching and on the argument that somehow Canadians should be able to vote without any ID whatsoever. They've fought a long and hard pitched battle on this one aspect of the bill, Mr. Speaker. But as I look in front of me here on the Elections Canada website, I see 39 different pieces of ID that Canadians can use to prove their identity, including library cards, credit debit cards, liquor identification cards, student ID card, health card, passport, driver's license. Mr. Speaker, the list goes on. Unfortunately for the opposition, Canadians do not agree with them, and they find it quite reasonable that Canadians provide some ID to exercise their right to vote. I'd like to ask my colleague if he could comment further on that and on what Canadians, from his perspective, what has he heard about vouching and about providing ID? Is that reasonable based on what he's heard, Mr. Speaker?
The Honourable Parliamentary Secretary to the Minister of Citizenship and Immigration.
Thank you, Mr. Speaker, and I thank my honourable colleague for that question. For me to try to understand what the logic or strategy is behind the opposition, trying to justify the lack of providing some kind of identification when you show up to vote, the most sacred right that we have as Canadian citizens, is not something that I wish to attempt. However, what I will say is this, because I want to add to the list that we heard from the honourable member. Voters will have 39 forms of authorized ID to choose from, Mr. Speaker. It is reasonable, I think, to expect Canadians to bring ID when they cast a ballot. It is reasonable for Canadians to expect that their fellow citizens will prove who they are when they come to cast a ballot. The list is 39 different types of pieces. And I see members of the opposition over there. Maybe they're concerned about not being able to obtain one of these 39 pieces. Canadians can get them. I don't know why they're having trouble getting them, Mr. Speaker. But I see that I'm coming to the end of my response time here. But I'd like to field some more questions if possible. Thank you.
Une autre question.
A final question. Questions and comments. The honourable member for Atkinson Bathurst. A brief question, please.
Speaker, you want another question? I'll throw one at him. I mean, you know, he's talking about Canadians that will go vote and they are like kind of not want to tell the truth and all kind of stuff and do fraud and all that. I mean, you know, Canadians know who had the problems of in and out in the election of 2006 was the Conservative government, the Conservative Party that went into the in and out. Do they think that all Canadians are like the Conservative Party? I mean, they are the one that got caught with it, went to court, and stopped the court until that probably they lose the next election. Why don't we go to court and find out who say the truth?
The Honourable Parliamentary Secretary, you have about 40 seconds.
Well, Mr. Speaker, that's the most ridiculous question anybody's ever asked me in the House, but I will answer it to the honourable member. It's unbelievable, Mr. Speaker. The only party that was caught by taking illegal union fees, dues, donations into their party and had to pay it back was the New Democratic Party, Mr. Speaker. Of all the nerve to stand up here and question, here's what I believe, Mr. Speaker. Canadians in large majority, 99.9%, I would say, are honest, hard-working people that would be very sincere when they show up to vote on Elections Day. But we want to make sure that other 0.1%, or whatever that percentage is, does not have an opportunity to perpetrate fraud on Election Day. Thank you very much, Mr. Speaker.
I understand the member for Oxford has a motion.
Thank you, Mr. Speaker. Discussions have taken place amongst all parties in the House, and I believe if you seek it, you will find unanimous consent for the following: that during the debate on Wednesday, May the 14th, 2014, on the business of supply, pursuant to the Standing Order 81 sub 4, no quorum calls, dilatory motions, or requests for unanimous consent shall be received by the Chair, and within each 15-minute period, each party may allocate time to one or more of its members for speeches or for questions and answers, provided that, in the case of questions and answers, the minister's answer approximately reflect the time taken by the question, and provided that, in the case of speeches, members of the party to which the period is allocated may speak one after the other.
Does the honourable member have the unanimous consent of the House to move the motion? Agreed. The House has heard the terms of the motion. Is it the pleasure of the House to adopt the motion? Carried. Order. À l'ordre. Conformément à l'article 38.
Pursuant to Standing Order 38, it is my duty to inform the House that the questions to be raised tonight at the time of adjournment are as follows. The Honourable Member for Manpeck, Public Safety. The Honourable Member for Cape Breton-Canso, Employment.
Resuming debate, reprise de débat, l'honorable député de...
The Honourable Member for Saint-Laurent, Cartierville. Thank you, Mr. Speaker. I'd like to say that I'm going to share my time with the member for Lac Saint-Louis, my esteemed colleague. Mr. Speaker, rarely will a bill have shown so many weaknesses that deals with the most fundamental aspects of our democracy, the rules that oversee federal elections. C-23, the Fair Elections Act, has been attacked from all sides and for very good reasons. The government can blame itself for this. They did not consult anyone, and they treated all those who had different opinions from theirs with hostility. This is a solid democratic tradition in Canada that says that the Elections Act should be one that is drafted with the greatest consensus possible. The government has isolated itself. However, even with the greatest pressure brought to bear on it, it did withdraw certain aspects of its worst aspects from its bill. Before this series of amendments, C-23 was a bill that was flat out dangerous. And so they have transformed a dangerous bill into a simply bad bill. The government really should have made additional efforts to make it a good bill, but that was too much to ask for, apparently. Let us congratulate ourselves still for some of the steps that the government took back. We managed to deal with loopholes that they wanted to create in the Elections Act for spending. However, C-23 would give the ceiling for donations and let them be much higher, and it was a change that would help parties that had very long lists of small donators, and the results of this would have been unfair elections and democratic equity. The government decided to make the returning officers appointed by the winning parties, and the risk of politicization was much too flagrant. However, it is unfortunate the government should have probably pushed their mea culpa a little farther. They should have followed the recommendations of the Neufeld report, which said that electoral officials should be based solely on merit. The choice should be made, rather, solely based on merit. And that is in compliance with established international elections legislations. Another partial defeat for the government is that they decided not to completely do away with the vouching system, the way that people who don't have ID can identify or can be allowed to vote. They can swear an oath now if they can find someone from the same electoral district who will stand as a guarantor. And so this will allow many people to vote who might not have been able to, primarily Aboriginal seniors and students, and quite by chance, people who are less likely to vote Conservative. Whereas C-23 in the first version took away any opportunity for vouching, the new version allows people who can find someone who lives near them, or someone who can prove rather their residential address, can attest to another person's living nearby. However, the government refused to allow the voter identification card to be recognized as an ID for the voter. C-23
card as identification that can be used to vote. The government failed to support Liberal amendments to restore the voter identification cards, the only universal piece of federal identification to contain an address and widely used by the population. There has been no proven fraud using voter identification cards. Removing the identification card is a solution in search of a problem. The facts on the voter identification card are clear. The data of the cards is based on regular updates from driver's license bureaus, the Canada Revenue Agency, Citizenship and Immigration Canada, and various other authoritative sources. During the election period, revision activities at the local level also increased the accuracy of the voter identification card. This likely makes it a more current document than even the driver's license, which is authorized by law and used by the vast majority of voters. The Chief Electoral Officer has pointed out that seniors who live in long-term care facilities and who vote on site and do not have proper ID or utility bills rely heavily on voter identification cards to vote. Eliminations of the voter identification cards will disenfranchise many Canadian seniors. J'en viens aux atteintes à la liberté.
And there is then the undermining of the Chief Electoral Officer's ability to speak.
The Chief Electoral Officer to continue public education and information programs to students at primary and secondary levels, the government is still severely limiting how the Chief Electoral Officer and Elections Canada can communicate with Canadians. The chief electoral officer is specifically limited to speaking publicly only about where, when, and how to vote. Elections Canada n'aura plus le droit.
Elections Canada will no longer have the right to promote voter participation or publish its research reports on the electoral process. Canada will find itself alone among democracies to impose to muzzle their officials in that way. We find ourselves in this absurd situation where Elections Canada will be able to promote election votes participation among children, but not amongst adults. So they will be able to encourage the voting participation when speaking to people who can't vote, but not when people can. That's ridiculous, Mr. Speaker. If you can follow this, so much the better, because Canadians aren't really following what's happening here. On another front, that against election fraud, the government has dug in its heels and refused to put into its bill anything about the principal recommendation of the Chief Electoral Officer and the Commissioner of Elections Canada, which is to give the Commissioner the powers to ask a judge for an order compelling a person to provide relevant information to an investigation.
The Conservatives failed to support a Liberal amendment to finally give the Commissioner of Canada Elections the power he desperately needs to enforce the Canada Elections Act, the power to ask a judge to compel witnesses to testify. The Commissioner has stated that this would force him to abandon the election fraud investigations. Are the Conservatives not willing to give the Commissioner the power to compel witness cooperation because they are afraid of what this might reveal about the source of the fraudulent elections calls and who may have used the Conservative database to deny Canadians their right to vote during the 2011 election? So the question the Minister failed to answer is the following. Why doesn't his bill provide the Commissioner of Canada Elections with the power already held by the Commissioner of Competition under Section 11 of the Competition Act, or the power already held by several provincial chief electoral officers or commissioners? This includes New Brunswick, Nova Scotia, Quebec, Ontario, Manitoba, Alberta, and Yukon. Internationally, other electoral management bodies have this power. This includes the Australian Electoral Commission and the Federal Election Commission of the United States. Pour conclure, Monsieur le Ministre.
In conclusion, Mr. Speaker, if the Minister is determined to not include this honest and sensible clause in his bill, we in the Liberal Party commit to doing so as soon as Canadians have elected a Liberal government.
The government should say no to this unfair Elections Act. Merci, Monsieur le Président.
Questions et commentaires, questions and comments. L'honorable député de...
The Honourable Member for Louis Saint-Laurent. Thank you, Mr. Speaker. I would like to thank my colleague from Saint-Laurent-Cartierville for his speech. I know that he followed the progression of this bill very closely through the stages in the House and at committee, and I think that he has given a very interesting speech that comes to demonstrate, in my opinion, very problematic portions of the bill. And he concluded with one of the points on which I really share his opinion. It's a major shortcoming of the bill, and that is the power that the Commissioner of Elections should have to compel testimony. I would like to tell you what the Commissioner himself said when he appeared before the committee. He said, if this change is not made to the bill, the investigations will continue to be long, very long, and even some will collapse because of our inability to get to the bottom of things. So the Commissioner himself came to committee and said that to us. And I think that if this person, who is the person who will investigate elections fraud in Canada, says something so strongly and clearly, I'd like for him to explain to me why, in his opinion, this amendment was not included among those that the government tabled, and why would you deny this right to the commissioner, which seems to be so important, so that the commissioner can really get to the bottom of election fraud in our country? The member for Saint-Laurent-Cartierville. I thank my colleague for her question, and also thank her for the efforts that she's made over the last few weeks alongside us to get answers from the government. And my answer is, why is what's good for Quebec, Yukon, Ontario, Manitoba, in terms of the commissioner's powers against collusion and the competition commissioner has that. Why is it good for them, but it's not good for the elections commissioner? And the only answer that the minister gave, is which he answered like a parrot in here, and everyone knows it, is, well, they have the same powers as the police. Well, the police has all kinds of powers and recourse that the commissioner does not. He's comparing apples and oranges. If we put apples and apples together, the government that's soft on crime right now is the Conservative government. Questions and comments?
The honourable member for Ottawa South.
Thank you, Mr. Speaker. A question for my colleague. I'd like to ask him if he could help us interpret, and Canadians interpret, what's going on with the government's approach to this bill, because weaving its way through the debate in terms of tone and character from the government is what I think most Canadians would describe now as just simply meanness. Meanness. And I think it perhaps culminated or peaked, Mr. Speaker, when the minister responsible for this bill made specious and spurious allegations at Senate in the other place in committee when he alleged that the head of Elections Canada was opposed to this bill because he was personally looking for more power and for more money. Now, for Canadians who are watching this, it's the tone of meanness that is, I think, now getting them very worried indeed about this bill. And we've seen a pattern of conduct, Mr. Speaker, in other areas manifested by the government, other firings, other pushing out of senior officers of Parliament, Linda Keane at the Canadian Nuclear Safety Commission, the former parliamentary budget officer, a recent attack on the Supreme Court of Canada Chief Justice, an attack on Sheila Fraser, the former Auditor General of Canada, an attack last week on the head of Via Rail, its outgoing president, and of course this ridiculous and unacceptable attack on Mr. Mayrand as head of Elections Canada. Can you help us understand what's at play here? What is it that motivates this regime to personalize their attacks when there are dissenting voices that speak truth to power?
The
honourable member for Saint-Laurent-Cartierville. You have 40 seconds.
Honourable colleague from Ottawa South asked me a very difficult question. I'm afraid I have no answer. The government is behaving as if the government was paranoid. The government was sure that they were surrounded by enemies. Elections Canada, enemy. The Chief Justice of Canada, enemy. That is the style the Prime Minister gave to his way to govern this country. Well, it's time to end it.
Hear, hear. Bravo.
Reprise the débat.
Resuming debate. The honourable member for Lac Saint-Louis. Thank you, Mr. Speaker. It's a pleasure to follow my colleague, the member for Saint-Laurent. I think we can agree that whether you're a member of the opposition or even a member of the government party, I think we can agree that the bill on fair elections was a mess from the very beginning to the end. We have in this bill the reflection of the incompetence and the stubbornness of the Conservative government. Stubbornness and not wanting to deal with facts and with the reality of what's actually going on the front lines, Mr. Speaker. And also what's not happening. Because this is a bill that's trying to eliminate fraud that hasn't been seen yet. And also, Mr. Speaker, the bill is a reflection of the bad faith that this government habitually shows in its way of governing. And my colleague from Saint-Laurent and also my colleague from Ottawa South has mentioned as well. The government has invented some boogeymen to justify certain measures that they put into the bill. What we've seen here in the House, Mr. Speaker, and what Canadians across the country have seen is an ideological approach on the part of this government, as usual, in fact. And no, that's not even the only thing. We've also seen a very partisan approach. We have seen a case of petty politics here, and even worse, we're not as far ahead in terms of improving the system than we might have been before that bill was tabled. And we could even say that things were better before the government messed things up. We have taken a step backwards. It's an upset because of the fact that the credibility of the election system in the eyes of the population has been questioned. Whereas the government has been feeding all kinds of cynicism that they have done. They have done this through this overly aggressive approach and their manipulation. I would like to say that the government was successful in two regards, and I'm sure they will congratulate themselves for this. First of all, they drew the attention of Canadians to the ins and outs of our election system. And this isn't an everyday topic of discussion. It's not something that people talk about around the dinner table every night. We don't often discuss in family, in the family about elections legislation. But because of the controversy swirling around this bill, I've seen, in my riding at least, that people were pretty up to date on what was going on and that they didn't like what they were seeing. Their reaction was rather negative. And the second thing that the government managed to do is to open Canadians' eyes to the way the Conservatives operate, to make Canadians aware of their leanings that the Conservatives seem to have for petty politics, as I already mentioned, and they would like to see them be a little more serious and more noble. And I would add, Mr. Speaker, that the government has harmed itself a great deal in the eyes of the public in this. At the beginning of the month of March, Angus Reid published a poll, and I will translate a portion of what they said. And in fact, they were saying that the more Canadians were aware of what was in Bill C-23, the Fair Elections Act, the more they were apt to be against it. And furthermore, apparently according to the same poll, about 2/3 of Canadians believed firmly that the government was using this bill to settle some accounts. I imagine with Elections Canada in particular, but there might have been other political parties involved in that as well.
Mr. Speaker, why such a negative reaction from Canadians to this bill? Well, I would submit to you, Mr. Speaker, that Canadians hold very dear the value of fair play, and this bill flies in the face of fairness. In other words, Canadians recognize from the outset that the ground rules shouldn't be changed without the consent of all interested parties, all stakeholders, including voters themselves. A number of times the government was asked to go around, get out there and consult Canadians on this controversial bill, and they repeatedly said, no, we don't feel like it. Better to just stay here in Ottawa. And we won't listen to the reaction coming from Canadians. We'll just discuss it here amongst ourselves on Parliament Hill. Mr. Speaker, others have said this already. This bill doesn't go far enough. If someone has knowledge of electoral fraud, they can't be compelled to testify under this bill. But on the other side, it goes too far, gives the commissioner, it takes powers away from the chief electoral officer and gives them to the director of public prosecutions. And it's the DPP that will now investigate. These are powers that the DPP didn't even want. It's a farce. They take responsibility or power away from one and give it to someone who didn't even want it in the first place. And the director of public prosecutions said it's dangerous to give him the oversight power over the electoral system because there's an apparent conflict of interests and it undermines trust. When you have an apparent conflict of interest, this undermines public trust. And our electoral system is sacrosanct, Mr. Speaker. We mustn't undermine Canadians' trust in their electoral system. It's very dangerous. Very dangerous, Mr. Speaker, in my opinion. So as I said, this is practically a farce. The powers, the person being given these new powers says, no thanks, I don't want them. And then there's also the whole issue of vouching. Vouching was apparently working just fine. There hadn't been any complaints about the system. And this system that wasn't broken, well, they want to fix it anyways. They want to change it, even though it wasn't in need of change. There was no evidence of fraud when it came to vouching, Mr. Speaker. So I was listening to the member earlier, the member for Don Valley West. In his speech, he was saying, he was comparing the ID you need to get a hospital card in Ontario. You need to present 3 pieces of ID, so it's quite a strict procedure. And my colleague from Saint-Laurent was talking about the same thing. The government is constantly comparing apples and oranges when they talk about these things. There is fraud with health insurance cards, and that's something we all know. When a person obtains a health insurance card fraudulently, well, the motive is clear. Somebody's trying to get free health care. But when you're talking about a voter who shows up to vote because he or she has the right to vote, there's no financial gain to be had. The person's not really helping anyone other than maybe a political party, but it's not clear that that person will be elected or that that's going to affect anything. So it's really comparing apples and oranges. That's all I have to say for the moment, Mr. Speaker. But this bill is a disaster, and I think the opposition will speak quite convincingly against this bill shortly. Thank you, Mr. Speaker. Questions and comments? The honourable member for
Beauharnois-Salaberry.
Beauharnois-Salaberry. Thank you, Mr. Speaker. I fully agree with my colleague when he says that this bill is not at all democratic. There are fewer and fewer people who will be encouraged to get out and vote, who will understand what ID they need. This isn't at all what the Chief Electoral Officer was recommending when it came to investigative powers and cracking down on election fraud. What makes me sad, Mr. Speaker, is that there are many young people who won't be able to exercise their right to vote because they won't have access to the information they need. Apparently, the chief electoral officer will be able to do outreach in primary and high schools, but not at universities and colleges. So university and college students won't have access to information because the chief electoral officer will not be able to do outreach and education at those levels of education. And there are also seniors, or in my riding in Akwesasne, there's a First Nations reserve, and there'll be no outreach or education possible with those target groups. So I'd just like to know what my colleague thinks about the lack of information that will be made available to future voters. The Honourable Member for Lac Saint Louis. Thank you, Mr. Speaker, and I meant to deal with that in my speech, but I ran out of time quite quickly. But it's very disappointing that the chief electoral officer will no longer be able to encourage people to get out and vote. What was said in the Senate was that that power had to be taken away from the CEO because there was a conflict of interest. The CEO had an interest in encouraging people to get out and vote and in making sure there was no fraud. So what they appeared to be suggesting was that if the CEO, well, he'd be in a conflict of interest because if on one hand he wasn't going to crack down on fraud because he's trying to get more people out to vote. It makes no sense whatsoever. Those tasked with regulating and overseeing the financial markets, they have a dual role. They have to make sure the system is fair, but they also have to watch out for abuse. So that's a false argument. It's specious, Mr. Speaker. Questions and comments. The Honourable Member for Saint-Laurent-Cartierville. Yes, Mr. Speaker. 3 quick questions. First of all, does my colleague know of any other democracy that limits or prohibits, well, just limits the responsibility of the chief electoral officer to encourage people to get out and vote? Secondly, is there any other democracy that can promote voting among everyone but those who are of age to vote? And my third question, is my colleague aware of any study, a single study, that would show that the main reason young people don't vote is because they don't know when, where, and how to vote? Is there any place like that in the world? The Honourable Member for Lac Saint Louis. Yes, Mr. Speaker, I know of no such study. To answer the third question, I can't think of any country for the first question, nor for the second question. What was really interesting was that this bill is harming Canada's reputation internationally. There are even experts in the U.S. who have spoken out in criticism of our legislation. And in Europe, we've heard voices saying, don't do that. That's a big mistake. It's a blunder. As a country, we should be holding high the flame of Canadian democracy. We shouldn't be trying to starve it of oxygen. We shouldn't be trying to put it out. We had a reputation as a sound and healthy and developed democracy, and that's suffering. Thank you, Mr. Speaker. Resuming debate.
The Honourable Member for Elgin, Middlesex, London.
Thank you, Mr. Speaker. It's great to be able to stand and speak on the Fair Elections Act. As the chairman of the Committee of Procedure and House Affairs, I've gone what seems many months not being able to say too much about what I won't say was forced to sit and listen to, but it certainly was a long study. I was proud to commit the time to try and move forward and work together with the members of the committee on this piece of legislation. I'd certainly like to start off with the fact that the members of the committee worked very hard together and worked fairly well together. I'm sure we have our rough points, but we work pretty hard. If you will indulge me, Mr. Speaker, the member from Louis Saint Laurent contributed well and even had to celebrate her birthday one night at a night meeting of the committee, and so we thank her for that sacrifice. the member from Toronto Danforth, and the member from Hamilton Centre, whose voice rings in my ears even when I'm away from this place, the member from Regina Lumsden Lake Centre, the member from Wild Rose, the member from Etobicoke Centre, a great fill-in member, the member from Oxford, who was there a lot, the member from Lanark, Frontenac, Lennox and Addington, and even the member from Saanich and Gulf Islands, who spent a great deal of time with us at committee to try and look at this legislation and move it forward. They tell me, we know it was long hours, they tell me it was something around 31 hours of study at committee, and as the chair, you must pay attention. And so the hours seemed much longer than the 31. I know you would know, Mr. Speaker, from sitting there, how you must listen, at least appear as though you're listening to what we're saying out here. Some 72 witnesses appeared at committee. On top of the 72 witnesses, many more briefs on top of that, people who were unable to attend or people who sent us briefs with their opinions. We had witnesses by teleconference from Australia, more than one from the United States, and from across Canada by teleconference and in person at the committee. Every witness that was asked for by every party in this House to attend was asked to come. Those that could, did. Those that couldn't sent briefs or at least shared with us their information. We wanted to make sure that we gave every opportunity to each person who asked, could people attend. Right from the beginning, the committee set a date for its completion of its study by motion to the committee, so it wasn't a surprise to anybody in the committee where we were going to end, what date it might be. The pile of work heading towards that date sometimes seems like it wouldn't move, but in fact it did. The reason for the date for the conclusion, the Chief Electoral Officer had told us ahead of time election legislation coming forward needed to be in his hands by a certain date so that by the election of 2015 in October, he would be able to run an election on that piece of legislation. So we had set the date. All members knew of this deadline. As I said, as we worked through it, many of us knew what was happening. Some chose to use their time for other purposes. Some chose to use their time for much longer debate than perhaps was needed. But all in all, we shared good information with each other. As a committee, very thankful we were able to work together and at the end of the day, take a pretty good or great piece of legislation and make it even better with some amendments that we were able to move forward and do. And let me discuss just some of those, Mr. Speaker, if we could. Really what I'd like to start off with is that Canadians have spoken. The information that we're hearing from Canadians is certainly on the voter identification side, they're reasonably pleased with where we're headed here. But I can give you now what I heard in my riding, what I heard in coffee shops, what I heard at church suppers, and yes, I do attend the odd one. What I heard even in my constituency office, when people would come in and talk about and ask questions about the Fair Elections Act, and I could share with them. There's a number of people who watch this on TV, and I know you. You're the guy from the Fair Elections Act, and yeah, I know I've got a cult following out there now. But even in my own constituency office, was able to share with them, where we're headed, and they would say, "Well, what about this voter ID thing?" And I would share with them, "Well, I know you as a good Canadian citizen. What part of it's bothering you?" And they said, "Well, I'm hearing some people won't get to vote." And I suggested to them, "Well, do you believe that people in Canada in a modern democracy should be able to go to the polls and not have to prove who they are? Not have to prove who they are." And every person I spoke to, bar none, in my riding suggested, "What do you mean people can vote without proving who they are? What do you mean no identification is needed?" And I said, "Well, this is the difference. This is what we're discussing. at this committee that we're trying to deal with is it okay for people to come in and have someone else say who they are, or should they have to pull out something and say, this is who I am. This is who I am, and this is where I live. We've made it a change, an amendment to the bill to help with that last part, that this is where I live. Because we think that if someone can say, hi, this is who I am, then someone else that lives in the same poll who has identification could help them with where they live. You know, I had many people in the riding during that time talk about, but it's 18 months till the next election. If someone knew right now they didn't have the identification that they needed, couldn't they go do it? And yes, and we heard this from even some of the testimony at committee. There's some great community groups out there that even in the people that they were suggesting might not have the ID to go vote, might not be able to have exactly what they needed to vote. We have some great, I think it was the London Homeless Coalition member who came and spoke to us at the committee who said, we have a whole group that does nothing but help people get ID. Because they don't need it just for this. This is really important to them, and they really want to make sure people can vote. But the piece they worry about, people need identification for some other basic things in life, and so they have a group that helps people find identification. And so, in talking with the voters in the riding, the constituents in the riding, they suggested that, you know, with enough notice and what the requirement might be, people should be able to go out and find ID in order to vote. Both of the parties across from me used the requirement for ID to vote in specific party functions in their parties. You must show ID if you're going to pick a leader of either of the opposition parties. And so all we're saying in Canada's constituents, the great citizens of Elgin, Middlesex, London at least, agreed with me at the time that probably be a good idea to have to show ID to vote. While we're doing this committee, as I said, many people are following us, whether it's on CPAC or other ways. I had a high school group in my riding who was following closely on CPAC, and after one of the meetings, I did a meeting by Skype with them. I'd love to get out and go to all the high school groups that we can go to and speak to them about what the job of the Member of Parliament is like. But they spent a great deal of time following this committee, and I couldn't, because of the length of the meetings and stuff, always be back in the riding. So I met with them on Skype one day, and we kind of went through the room online with them and suggested, is there anybody in this room that couldn't vote tomorrow? And they all suggested no, that there was ID, that there was ID available to them, or that could be available to them if they wanted to go out and get it, and certainly could by the October 2015 deadline do just that. So, but again, as I suggested, we can make a great piece of legislation even better by amending it and putting in the taking an oath. If a member goes to vote and can prove who they are by showing ID, and at a polling station where there is someone else who has shown ID of who they are and where they live, they can both sign an oath attesting to the address for the person who doesn't have the ID with an address on it. But as one of my constituents said to me, how is it that someone can go out and do all the work of getting all the ID that's needed, and as I do, I believe he was a farmer, but as I do, how could I can get all the ID I need to go vote, and yet other people can go into a voting station without all that ID? Why don't they just do the same work I did to get the ID? I wanted to also share that in my time on this committee, and it's been a number of years now, and after a number of elections, every time after every election, the Chief Electoral Officer sends a report to our committee for us to review. And I would suggest I've now been through 3 of them. It might be 4, but I've been through 3 of them. 3 times the Chief Electoral Officer has sent us a group of recommendations for us to look at. And many of what I've heard over the years from the Chief Electoral Officer for additions or changes to the Elections Act is in fact in this Fair Elections Act. And so I wanted to make sure that we shared that also. And while I'm talking about the Chief Electoral Officers and his powers, his ability to run elections, we should compliment Elections Canada on what they do. Think of this. I know in my riding, over 200 polls. Take that by 308 ridings across this country and suggest you're going to run an event that has that many points of interest, that has that many places where someone can go, and hopefully you get all of the people to the right place at the right time, which is part of why I think the great suggestion is that Elections Canada do spend the majority or all of its time on telling people when and where and what time to go vote. Many of the surveys that we heard during this study and have heard at Procedure and House Affairs when looking at previous Chief Electoral Officers' reports tell us often why people don't vote. The question is always asked after every election, after the votes are cast and we're all here. Elections Canada does a pretty good job of doing surveys itself or hiring other people to do surveys to find out, well, if you didn't vote, why didn't you? And in every case, the leading answer is, I was really busy. I didn't find the time. And yet we've even created in this piece of legislation one other whole day of pre-election, of election dates that you can now vote at. But many citizens say in those same surveys, well, I didn't know I could go to the election office and vote at any time during an election. I didn't know there was the special ballot. I didn't know about all of the different election days there was. I thought if I didn't show up on election day and I didn't really know where it was, that's why I didn't vote. So telling people where and when and what ID to bring is a pretty important piece. I was looking through the paper on the weekend and trying to decide what else I might do. And I was in the movie section. And there's some great ads for movies. And they told me what time they started and what theater they were at. And I could make my decision based on that, what I might go do that evening. There was no place in the ad that told me why I should go see that movie. I might have listed who the stars were, and that might help me make my mind up. But I think it's our job, 308 men and women in this House, who really provide the why to voters. It's our job to tell people why they should come out and vote for Joe. Why, indeed, they should at any time come out and exercise a ballot. I'm not clear that it's anybody's job but the political people in this country to do the why. And if indeed the Elections Canada group does a great job of telling people the where, the when, what ID to bring, the different methods, the visit to the returning office or the special ballot or even offshore, the using of the special ballot to vote, that would be one job absolutely taken care of, and leave it up to us to talk about the why. As I said, I spent some time in this job talking to schools. I love going to schools and talking to them about my job as a member of Parliament. By the way, the best job one could ever have. And we certainly share that. I told you earlier in my statement about even my use of Skype to be able to talk to high school classes. And we've asked that the Chief Electoral Officer keep that in place. Another way of making a great bill better was an amendment to ask Elections Canada to please let's keep in place things like student vote. I've been active, and I know many of my colleagues from both sides of the aisle have been very active in student votes in past elections. We get high school students talking about how elections work what they look like, what being a candidate, what it takes to be a candidate, and then actually holding a election at the high school level. We get them very interested in being voters from that point on. I'm glad with the changes in allowing the Chief Electoral Officer to use a program run by Civics called Student Vote back in the schools is a fantastic change to this piece of legislation. Mr. Speaker, one of the other things that we talked a lot about at committee and we heard about, but we heard so much more about it before the legislation came forward and maybe less about it after, and that is the use of CRTC as a way of watching and regulating voter contact. I think I could safely say in the last election, I'll try and underestimate it, that I made about 200,000 phone calls in my constituency by 2 town hall meetings where we would call every house in the riding, and then a number of other, whether it was get out the vote or tell people about advanced poll day, where we called just about everybody there too. So a great number of phone calls to the riding. Did I ever hear from anybody? Did I ever hear from CRTC? No, because if there's rules and you follow them, this is not a problem. If the phone call comes in and it's, "Hi, I'm Joe Preston, I'm your Conservative candidate, and I..." Yes.
It's unparliamentary to use a member's name, including one's own name. I have to say it's the 3rd time it's happened in the last week, so you're not the only one guilty of the practice, but it in fact is improper.
I can't refer to members of Parliament, and including myself. I take it back, Mr. Speaker, and I apologize profusely for that breach of procedure. That's probably wrong that the Chair of Procedure and House Affairs didn't do that right. Watch how I do this. We made a number of phone calls, but every one of them said what my name was and who I was representing, and a phone call where I could be reached, and then went on to whatever the message was. You know, hey, advanced polls are tomorrow, and at the end of it, again said what my name was and where I could be reached. And if you did that properly, there was no trouble at all. CRTC at committee told us that there's much good use of telephone during campaigns, and they would be able to take on the role of how we work together as politicians during campaigns. And there would be certain rules to follow, and we should all know them ahead of time, and we should all be aware of them if we're not. But that CRTC would be able to take over and tell us if anything like robocalls happened. So, again, by adding this piece, by taking that whole electronic monitoring of this and putting it in CRTC, I think we've been able to make it a better piece of legislation also. Mr. Speaker, if I can just finish again by thanking the committee and thanking all of our witnesses and thanking Canadians who cared a lot about how we elect ourselves and how important it is that we do it properly and how important it is that it's a rules-based system. In a mature democracy, from what I've heard from my constituents, in a mature democracy, asking someone to prove who they are before they vote is probably appropriate. And again, I thank my helpers, the other members of the committee, for doing the hard lifting. Thank you.
We will have only about 4.5 minutes for questions and comments. Question et commentaire. The honourable member for Hamilton Centre.
Thank you, Mr. Speaker. As one of the honourable member's little helpers, I'm pleased to ask a question. I think the member tries very hard to be a fair-minded chair. I think he was a little more successful when a minority, but that's probably as much a biased comment as anything. But I want to ask, I'll be very direct, Speaker. My question is this. Given that the member worked very hard as the chair of HoC to be seen as fair-minded and reasonable, I'd like to ask him, does he not believe that it would be fair-minded and reasonable before any government were attempting to change the election laws in Canada, that they would at least consult the Chief Electoral Officer and the Commissioner of Elections of Canada. Does it not make sense, common sense, to consult at least those two people before any government were to bring in a brand new election law?
The honourable member for Elgin, Middlesex, London.
Well, Mr. Speaker, as I said, I hear that voice in my sleep. Sometimes I sleep with the TV on, and he might very well be on. Of course, and the answer is, as I shared during my speech, over my number of years as the Chair of Procedure and House Affairs, the Chief Electoral Officer has had much contact with us, has appeared at committee a number of times after each election, and shares with us a group of recommendations that he would like to see changes to the Elections Act before the next election. He, of course, has done that, and I think some 38 of his recommendations are in the Fair Elections Act. So the consultation at the committee level, and certainly even in conversation with the Chief Electoral Officer, has taken place.
Questions and comments? Question et commentaire. The honourable member for Cape Breton, Canso.
Thank you very much, Mr. Speaker, and to my friend and colleague and my big London Knights fan. I have to. In his speech, he identified the fact that Elections Canada shouldn't be putting forward a reason why Canadians should be going to vote. They should not be involved in the why, just where and the when. Yet his government last year, in the Canada Jobs Grant ads that they spent millions and millions of dollars on, they told Canadians why they should be accessing this program that didn't even exist. But there was a why there. Could he square that circle for me? Thank you.
The honourable member for Elgin, Middlesex, London. You have about a minute and a half.
Oh, great, thank you. And I do thank the member for his notice of my green suit today in honour of the London Knights. And we have had a great deal of good times together, and when he served on Procedure and House Affairs, he remembers our good times together and what we're able to do. Look, and I can't speak for the Canada Job Grants. I guess the Chair of Human Resources could stand up here and tell you about that one. But as the Chair of Procedure and House Affairs and the number of witnesses that we've heard, and in my own anecdotal parts of the speech, I suggested why the why was our job. And I know in his writing he's the why, and in my writing, hopefully I'm the why, and the other candidates that might be up against me. Thank you.
It being 5:15, pursuant to order made on Thursday, May 8, 2014, it is my duty to interrupt the proceedings and put forthwith every question necessary to dispose of the third reading stage of the bill now before the House. The question is as follows. Mr. Polyev, seconded by Mr. Duncan, Vancouver Island North, moved that Bill C-23, an act to amend the Canada Elections Act and other acts and to make consequential amendments to certain acts, be now read a third time and do pass. The reason amendment, Mr. Scott, seconded by Mr. Thibault, moved the following amendment, that the motion be amended by deleting all the words after the word that and substituting the following. Cette Chambre refuse de...
This House declined to give third reading to Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts, because, among other things, it, A, was rushed through Parliament without adequately taking into account the concerns raised by over 70 expert witnesses and hundreds of civil society actors that speak to a wide array of provisions that remain problematic in this bill. B, prohibits the Chief Electoral Officer from authorizing the use of voter information cards as a piece of voter identification to be used alongside a second piece of identification, despite such cards being a method of enfranchisement and promoting smoother administration of the election day vote, And despite there being no basis for believing these cards are or are likely to be a source of voter fraud.
To legislate the powers necessary for full compliance with and enforcement of the Canada Elections Act in light of experience with fraud and breach of other electoral law in the 2006, 2008, and 2011 general elections, notably the power of the Chief Electoral Officer to require registered parties to provide receipts accounting for their election campaign expenses, and the power of the Commissioner for Canada Elections to seek a judicial order to compel testimony during an investigation into electoral crimes such as fraud. D.
Eliminates the power of the Chief Electoral Officer to implement public education and information programs designed to enhance knowledge of our electoral democracy and encourage voting other than for primary and secondary school students, and
the influence of money in politics through unjustified increases in how much individuals may donate annually and how much candidates may now contribute to their own campaigns, thereby creating an undue advantage for well-resourced candidates and parties. The question is on the amendment. I repeat, the question is on the amendment. Is it the pleasure of the House to adopt the amendment? All those in favor of the amendment will please say yea. All those opposed will please say nay. In my opinion, the nays have it. Call in the members, convoquez les députés.
La question est la suivante. M. Poliev, appelé par M. Duncan, île de Vancouver-Nord, propose que le projet de loi C-23, loi modifiant la loi électorale du Canada et d'autres lois et modifiant certaines lois en conséquence, soit maintenant lu une troisième fois et adopté. Mr. Scott, seconded by Mr. Thibault, moved the following amendment. The motion be amended by deleting all the words after the word that and substituting the following. This House declined to give third reading to Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts because, amongst other things, it, A, was rushed through Parliament without adequately taking into account the concerns raised by over 70 expert witnesses and hundreds of civil society actors that speak to a wide array of provisions that remain problematic in this bill. B, interdit au directeur général des élections d'autoriser l'emploi de la carte d'information de l'électeur comme pièce d'identité pouvant être utilisée conjointement à une autre pièce d'identité, bien qu'une telle carte constitue une méthode d'admission au suffrage et qu'elle simplifie l'administration.
Mr. Poliev, seconded by Mr. Duncan, moved that Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts.
Necessary for full compliance with and enforcement of the Canada Elections Act in light of experience with fraud and breach of other electoral law in the 2006, 2008, and 2011 general elections, notably the power of the Chief Electoral Officer to require registered parties to provide receipts accounting for their election campaign expenses, and the power of the Commissioner for Canada Elections to seek a judicial order to compel testimony during an investigation into electoral crimes such as fraud.
D, eliminates the power of the Chief Electoral Officer to implement public education and information programs designed to enhance knowledge of our electoral democracy and encourage voting other than for primary and secondary school students, and
que les élèves de niveau primaire et secondaire. E, increases the influence of money in politics through unjustified increases in how much individuals may donate annually and how much candidates may now contribute to their own campaigns, thereby creating an undue advantage for well-resourced candidates and parties. Questions on the amendment? All those in favor of the amendment will please rise.
Monsieur Mulcair.
Monsieur Mulcair.
Madame Laverdière.
Madame Laverdière.
Ms. Sims Newton North Delta.
Sims Newton North
Mr.
Delta.
Alan Wellen.
Mr. Alan Wellen.
Ms. Duncan Edmonton Strathcona.
Ms. Duncan Edmonton Strathcona.
Mr. Harris St. John's East.
Mr. Harris St. John's
Madame
East.
Boivin.
Madame Boivin.
Ms. Leslie.
Ms. Leslie.
Mr. Julian.
Mr. Julian.
Ms. Davies Vancouver East.
Ms. Davies Vancouver East.
Mr. Christopherson.
Mr. Christopherson.
Ms. Nash.
Ms. Nash.
Mr. Cullen.
Mr. Cullen.
Ms. Crowder.
Ms. Crowder.
Monsieur Godin.
Mr. Godin.
Mr. Martin.
Mr. Martin.
Mr. Scott.
Mr. Scott.
Mr. Bevington.
Mr. Bevington.
Madame Mourabiti-Témiscamingue.
Madame Mourabiti-Témiscamingue.
Mr. Donnelly.
Mr. Donnelly.
Mr. Massey.
Mr. Massey.
Madame Leblanc-Lassalle-Mar.
Madame Leblanc-Lassalle-Mar.
Mr. Kelway.
Mr. Kelway.
Madame Brosseau.
Madame Brosseau.
Monsieur Toon.
Monsieur Toon.
Madame Turmel.
Madame Turmel.
Ms. Charlton.
Ms. Charlton.
Mr. Chisholm.
Mr. Chisholm.
Monsieur Boulris.
Mr. Boulris.
Mr. Angus.
Mr. Angus.
Mr. Marston.
Mr. Marston.
Madame Hughes.
Madame Hughes.
Monsieur Caron.
Monsieur Caron.
Mr. Rankin.
Mr. Rankin.
Mr. Harris Scarborough Southwest.
Mr. Harris Scarborough
Mr.
Southwest.
Thibault.
Mr. Thibault.
Madame Papillon.
Madame Papillon.
Madame Ayala.
Madame Ayala.
Madame Lou.
Madame Lou.
Mr. Stewart.
Mr. Stewart.
Mr. Garrison.
Mr. Garrison.
Madame Blanchette-Lamotte.
Madame Blanchette-Lamotte.
Monsieur Aubin.
Monsieur Aubin.
Monsieur Dubé.
Monsieur Dubé.
Madame Grosguet.
Madame Grosguet.
Madame Boutin-Souis.
Madame Boutin-Souis.
Monsieur Saganache.
Monsieur Saganache.
Monsieur Nantel.
Monsieur Nantel.
Madame Péclet.
Madame Péclet.
Monsieur Gravel.
Monsieur Gravel.
Monsieur Maille.
Monsieur Maille.
Madame Michaud.
Madame Michaud.
Monsieur Giguère.
Monsieur Giguère.
Monsieur Rousseau.
Monsieur Rousseau.
Monsieur Genet-Jourdain.
Monsieur Genet-Jourdain.
Monsieur Lapointe.
Monsieur Lapointe.
Monsieur Côté.
Monsieur Côté.
Monsieur Dussault.
Monsieur Dussault.
Monsieur Choquette.
Monsieur Choquette.
Mr. Sandou.
Mr. Sandou.
Madame Sella.
Madame Sella.
Monsieur Dionne Labelle.
Monsieur Dionne Labelle.
Madame Freeman.
Madame Freeman.
Mr. Tsabaïsen.
Mr. Tsabaïsen.
Madame Doré Lefebvre.
Madame Doré Lefebvre.
Madame Quash.
Madame Quash.
Madame Borg.
Madame Borg.
Monsieur Nichols.
Monsieur Nichols.
Monsieur Bramy.
Monsieur Bramy.
Monsieur Blanchette.
Monsieur Blanchette.
Mr. Sullivan.
Mr. Sullivan.
Madame Reynaud.
Madame Reynaud.
Mr. Comartin.
Mr. Comartin.
Madame Morin-Saint-Hyacinthe-Bagotte.
Madame Morin-Saint-Hyacinthe-Bagotte.
Monsieur Jacob.
Monsieur Jacob.
Monsieur Nunez-Mello.
Monsieur Nunez-Mello.
Monsieur Pilon.
Monsieur Pilon.
Monsieur Genet.
Monsieur Genet.
Mr. Stoffer.
Mr. Stoffer.
Monsieur Chicoine.
Monsieur Chicoine.
Mr. Cleary.
Mr. Cleary.
Monsieur Morin-Chicoutimi-Lefiard.
Monsieur Morin-Chicoutimi-Lefiard.
Madame Latendresse.
Madame Latendresse.
Madame Morin-Notre-Dame-de-Grâce-Lachine.
Madame Morin-Notre-Dame-de-Grâce-Lachine.
Mr. Benskin.
Mr. Benskin.
Monsieur Morin-Laurentier-de-Labelle.
Monsieur Morin-Laurentier-de-Labelle.
Mr. Atamanenko.
Mr. Atamanenko.
Monsieur Trudeau.
Monsieur Trudeau.
Mr. McCauley.
Mr. McCauley.
Mr. Goodale.
Mr. Goodale.
Monsieur Leblanc-Beauséjour.
Monsieur Leblanc-Beauséjour.
Mr. Easter.
Mr. Easter.
Ms. Fry.
Ms. Fry.
Mr. Regan.
Mr. Regan.
Monsieur Bélanger.
Monsieur Bélanger.
Mr. Valeria.
Mr. Valeria.
Mr. Lamoureux.
Mr. Lamoureux.
Monsieur Dion.
Monsieur Dion.
Ms. Gros.
Ms. Gros.
Ms. Bennett.
Ms. Bennett.
Mr. Bryson.
Mr. Bryson.
Mr. Cutler.
Mr. Cutler.
Mr. Cuzner.
Mr. Cuzner.
Mr. Eiking.
Mr. Eiking.
Mr. McCallum.
Mr. McCallum.
Mr. Pachetti.
Mr. Pachetti.
Ms. Duncan, Etobicoke North.
Ms. Duncan, Etobicoke North.
Ms. Murray.
Ms. Murray.
Mr. McGinty.
Mr. McGinty.
Mr. Scarpalegia.
Mr. Scarpalegia.
Madame Saint-Denis.
Madame Saint-Denis.
Mr. Sims, Bonavista, Gander Grand Falls, Windsor.
Mr. Sims, Bonavista, Gander Grand Falls.
Mr. Andrews.
Mr. Andrews.
Mr. Shue.
Mr. Shue.
Mr. Casey.
Mr. Casey.
Ms. Jones.
Ms. Jones.
Monsieur Dubourg.
Monsieur Dubourg.
Ms. Freeland.
Ms. Freeland.
Monsieur Plamondon.
Monsieur Plamondon.
Monsieur Fortin.
Monsieur Fortin.
Monsieur Patry.
Monsieur Patry.
Mr. Rathgaber.
Mr. Rathgaber.
Mr. Heyer.
Mr. Heyer.
All those opposed to the amendment will please rise.
Mr. Harper.
Mr. Harper.
Mr. Fletcher. Ms. Leach.
Mrs. Leach.
Mrs. Glover.
Mrs. Glover.
Mr. Fantino.
Mr. Fantino.
Monsieur Valcourt.
Monsieur Valcourt.
Monsieur Blaney.
Monsieur Blaney.
Ms. Finley Haldeman Norfolk.
Ms. Finley Haldeman Norfolk.
Mr. Nicholson.
Mr. Nicholson.
Mr. McKay Central Nova.
Mr. McKay Central Nova.
Mr. Van Loan.
Mr. Van
Monsieur
Loan.
Lebel.
Monsieur Lebel.
Mr. Oliver.
Mr. Oliver.
Mr. Clement.
Mr. Clement.
Mr. Ritz.
Mr. Ritz.
Mr. Kenny Calgary Southeast.
Mr. Kenny Calgary Southeast.
Mr. Moore Port Woody Westwood Pocahontas.
Mr. Moore Port Moody Westwood Pocahontas.
Mrs. Aglukat.
Mrs. Aglukat.
Mrs. Shea.
Mrs. Shea.
Mr. Fast.
Mr. Fast.
Ms. Ambrose.
Ms. Ambrose.
Ms. Findlay Delta Richmond East.
Ms. Finley Delta Richmond East.
Mr. Alexander.
Mr. Alexander.
Mr. Benoit.
Mr. Benoit.
Mr. Ashfield.
Mr. Ashfield.
Mr. Chong.
Mr. Chong.
Mrs. Trupe.
Mrs. Trupe.
Mr. Dykstra.
Mr. Dykstra.
Mr. O'Brien.
Mr. O'Brien.
Mr. Gourde.
Mr. Gourde.
Mr. Poilievre.
Mr. Poilievre.
Mr. Bernier.
Mr. Bernier.
Mr. Gossal.
Mr. Gossal.
Mr. Goodyear.
Mr. Goodyear.
Mr. Duncan Vancouver Island North.
Mr. Duncan Vancouver Island North.
Mrs. Yelich.
Mrs. Yelich.
Mrs. Wong.
Mrs. Wong.
Ms. Bergen.
Ms. Bergen.
Ms. Rampel.
Ms. Rampel.
Mr. Upal.
Mr. Upal.
Mr. Sorensen.
Mr. Sorensen.
Mr. Holder.
Mr. Holder.
Mr. Anderson.
Mr. Anderson.
Mr. Carey.
Mr. Carey.
Mr. Camp Pitt Meadows Maple Ridge Mission.
Mr. Camp Pitt Meadows Maple Ridge Mission.
Mrs. Ablancy.
Mrs. Ablancy.
Mr. Merrifield.
Mr. Merrifield.
Mr. O'Connor.
Mr. O'Connor.
Mr. Rajat.
Mr. Rajat.
Mr. Reed.
Mr. Reed.
Mr. Velicott.
Mr. Velicott.
Mr. Anders.
Mr. Anders.
Mr. Albus.
Mr. Albus.
Mr. Strahl.
Mr. Strahl.
Mr. Trottier.
Mr. Trottier.
Mr. Braid.
Mr. Braid.
Mr. Deckert.
Mr. Deckert.
Monsieur Gauguin.
Mr. Gauguin.
Mr. Bazan.
Mr. Bazan.
Ms. Brown and Marquette Aurora.
Ms. Brown, Market Aurora.
Mr. Calandra.
Mr. Calandra.
Mr. Lukiski.
Mr. Lukiski.
Mr. Gill.
Mr. Gill.
Ms. James.
Ms. James.
Mrs. Block.
Mrs. Block.
Mrs. McLeod.
Mrs. McLeod.
Mr. Leon.
Mr. Leon.
Mr. Saxton.
Mr. Saxton.
Monsieur Lemieux.
Mr. Lemieux.
Ms. Adams.
Ms. Adams.
Mr. Watson.
Mr. Watson.
Mr. Menegakis.
Mr. Menegakis.
Mr. O'Toole.
Mr. O'Toole.
Mr. Hahn.
Mr. Hahn.
Mrs. Gallant.
Mrs. Gallant.
Mr. Lunny.
Mr. Lunny.
Mr. Schellenberger.
Mr. Schellenberger.
Mr. Allison.
Mr. Allison.
Mr. Brown Leeds Granville.
Mr. Brown Leeds Grenville.
Mrs. Greywall.
Mrs. Greywall.
Mr. Hoback.
Mr. Hoback.
Mr. Hebert.
Mr. Hebert.
Mr. Komarnicki.
Mr. Komarnicki.
Mr. Crown Prince Edward Hastings.
Mr. Crown Prince Edward Hastings.
Monsieur Lauzon.
Monsieur Lauzon.
Mr. Miller.
Mr. Miller.
Mrs. Smith.
Mrs. Smith.
Mr. Preston.
Mr. Preston.
Mr. Trost.
Mr. Trost.
Mr. Warrock.
Mr. Warrock.
Mr. McKenzie.
Mr. McKenzie.
Mr. Albrecht.
Mr. Albrecht.
Mr. Allen to Big
Mr.
Mactaquac.
Allen to Big Mactaquac.
Mr. Brown Barry.
Mr. Brown Barry.
Mr. Bernouge.
Mr. Bernouge.
Mr. Calkins.
Mr. Calkins.
Mr. Cannon.
Mr. Cannon.
Mrs. Davidson.
Mrs. Davidson.
Mr. Galipo.
Mr. Galipo.
Mr. Mays.
Mr. Mays.
Mr. Norlock.
Mr. Norlock.
Mr. Shipley.
Mr. Shipley.
Mr. Storseth.
Mr. Storseth.
Mr. Sweet.
Mr. Sweet.
Mr. Van Kesteren.
Mr. Van Kesteren.
Mr. Wallace.
Mr. Wallace.
Mr. Walkerton.
Mr. Walkerton.
Mr. Clark.
Mr. Clark.
Mr. Bowen.
Mr. Bowen.
Mr. Harris Caribou Prince George.
Mr. Harris Caribou Prince George.
Mr. Dreeshan.
Mr. Dreeshan.
Mr. Kerr.
Mr. Kerr.
Mr. McColeman.
Mr. McColeman.
Mrs. O'Neill Gordon.
Mrs. O'Neill Gordon.
Mr. Payne.
Mr. Payne.
Mr. Richards.
Mr. Richards.
Mr. Shorey.
Mr. Shorey.
Mr. Western West Vancouver Sunshine Coast to Sky Country.
Mr. Western West Vancouver Sunshine Coast to Sky
Mr.
Country.
Woodworth.
Mr. Woodworth.
Mr. Young Oakville.
Mr. Young
Mr.
Oakville.
Sopak.
Mr. Sopak.
Mr. Aspen.
Mr. Aspen.
Mr. Butt.
Mr. Butt.
Mr. Chisu.
Mr. Chisu.
Mr. Hayes.
Mr. Hayes.
Mr. Hillier.
Mr. Hillier.
Mr. Leaf.
Mr. Leaf.
Mr. Lizon.
Mr. Lizon.
Mr. Opitz.
Mr. Opitz.
Mr. Seaback.
Mr. Seaback.
Mr. Tote.
Mr. Tote.
Mr. Wilt.
Mr. Wilt.
Mr. Williamson.
Mr. Williamson.
Ms. Young, Vancouver South.
Ms. Young, Vancouver
Mr.
South.
Zimmer.
Mr. Zimmer.
Ms. Crockett.
Ms. Crockett.
Madame Bateman.
Madame Bateman.
Mr. Adler.
Mr. Adler.
Mrs. Ambler.
Mrs. Ambler.
Mr. Stanton.
Mr. Stanton.
Mr. Daniel.
Mr. Daniel.
Mr. Carmichael.
Mr. Carmichael.
Mr. DeVolen.
Mr. DeVolen.
Mr. Falk.
Mr. Falk.
Mr. McGuire.
Mr. McGuire.
Mr. Del Mastro.
Mr. Del Mastro.
Yeas pour 123, 123. Nays contre 146, 146.
I declare the amendment defeated. The next question is on the main motion. The question is as follows. Mr. Polliver, seconded by Mr. Duncan, Vancouver Island North, move that Bill C-23, an act to amend the Canada Elections Act and other acts, and to make consequential amendments to certain acts, be now read a third time and do pass. Is it the pleasure of the House to adopt the motion? Yes? Oh, no, okay. All those in favor, please say yay. And all opposed, please say nay. In my opinion, the yeas have it. All those in favor of the motion will please rise.
Mr. Harper. Mr. Fletcher. Ms. Leaf. Mrs. Glover. Mr. Fantino. Monsieur Valcourt. Monsieur Blaney. Ms. Finley Haldeman Norfolk. Mr. Nicholson. The McKay Central Nova. Mr. Van Loan. Monsieur Lebel. Mr. Oliver. Mr. Clement. Mr. Ritz. Mr. Kenny Calgary Southeast. Mr. Moorport Woody Westwood Pocahontas. Mrs. Aglukat. Mrs. Shea. Mr. Fast. Ms. Ambrose. Ms. Finley Delta Richmond East. Mr. Alexander. Mr. Benoit.
Benoit.
Mr. Benoit.
Mr. Ashfield.
Mr. Ashfield.
Mr. Chong.
Mr. Chong.
Mrs. Troupé.
Mrs. Troupé.
Mr. Dykstra.
Mr. Dykstra.
Mr. Aubry.
Mr. Aubry.
Mr. Gourde.
Mr. Gourde.
Mr. Poilievre. Mr. Bernier. Mr. Gossard. Mr. Goodyear. Mr. Duncan Vancouver Island North. Mrs. Yelich. Mrs. Wong. Ms. Bergen. Ms. Rempel. Mr. Upal. Mr. Sorensen. Mr. Holder. Mr. Anderson. Mr. Carey. Mr. Campit Meadows River Ridge Mission. Mrs. Oblancy. Mr. Merrifield. Mr. O'Connor. Mr. Rajat. Mr. Reed. Mr. Velicott. Mr. Anders. Mr. Albus. Mr. Strahl. Mr. Trottier. Mr. Braid. Mr. Deckert. Mr. Gauguin. Mr. Bazan. Ms. Brown and Marquette Aurora. Mr. Calandra. Mr. Lukiski. Mr. Gill. Ms. James. Mrs. Block. Mrs. McLeod. Mr. Leong. Mr. Saxton. Mr. Lemieux. Ms. Adams. Mr. Watson. Mr. Menegakis. Mr. O'Toole. Mr. Hahn. Mrs. Gallant. Mr. Lunny. Mr. Schellenberger. Mr. Allison. Mr. Brown Leeds Granville. Mrs. Greywall. Mr. Hobach. Mr. Hebert. Mr. Komarnicki. Mr. Cram Prince Edward Hastings. Mr. Lauzon. Mr. Miller. Mrs. Smith. Mr. Preston. Mr. Trost. Mr. Warawa. Mr. McKenzie. Mr. Albrecht. Mr. Allen. Tobik Mactaquac. Mr. Brownberry. Mr. Brenouge. Mr. Calkins. Mr. Cannon. Mrs. Davidson. Mr. Galipo. Mr. Mays. Mr. Norlock. Mr. Shipley. Mr. Storsett. Mr. Sweet. Mr. Van Kesteren. Mr. Wallace. Mr. Walkerton. Mr. Clark. Mr. Bowen. Mr. Harris Caribou Prince George. Mr. Dreeshen. Mr. Kerr. Mr. McColeman. Mrs. O'Neill Gordon. Mr. Payne. Mr. Richards. Mr. Shorey. Mr. Weston West Vancouver Sunshine Coast Sea to Sky Country.
Mr. Weston West Vancouver Sunshine Coast Sea to Sky Country.
Mr. Woodworth.
Mr. Woodworth.
Mr. Young Oakville.
Mr. Young Oakville.
Mr. Sopak. Mr. Aspen. Mr. Butt. Mr. Chisu. Mr. Hayes. Mr. Hillier. Mr. Leaf. Mr. Lizon. Mr. Opitz. Mr. Seaback. Mr. Tote. Mr. Wilkes. Mr. Williamson. Ms. Young Vancouver South. Mr. Zimmer. Ms. Crockett. Madame Bateman. Mr. Adler. Mrs. Ambler. Mr. Stanton. Mr. Daniel. Mr. Carmichael. Mr. DeVolen. Mr. Falk. Mr. McGuire. Mr. Del Mastro.
Mr. Del Mastro.
All those opposed to the motion will please rise.
Monsieur Mulcair. Madame Laverdière. Ms. Sims, Mr. North Delta. Mr. Alan Welland. Mr. Duncan and Mr. Strathcona. Mr. Harris St. John's East. Madame Boivin. Ms. Leslie. Mr. Julian. Ms. Davies, Vancouver East. Mr. Christopherson. Ms. Nash. Mr. Cullen. Ms. Crowder. Monsieur Godin. Mr. Martin. Mr. Scott. Mr. Beddington. Madame Mourabitibi-Témiscamingue. Mr. Donnelly. Mr. Massey. Madame Leblanc-Lassalle-Mare. Mr. Kelway. Madame Brosseau. Monsieur Toon. Madame Turmel. Ms. Charlton. Mr. Chisholm, Mr. Boulris, Mr. Angus, Mr. Marston, Madame Hughes, Mr. Caron, Mr. Rankin, Mr. Harris Scarborough Southwest, Mr. Thibault, Madame Papillon, Madame Ayala, Madame Lou, Mr. Stewart, Mr. Garrison, Madame Blanchette-Lamotte, Monsieur Aubin, Monsieur Dubé, Madame Grosguet, Madame Boutin-Sweet, Monsieur Saganas, Monsieur Nantel, Madame Péclet, Monsieur Gravel, Monsieur Maille, Madame Michaud, Monsieur Giguère, Monsieur Rousseau, Monsieur Genet-Jourdain, Monsieur Lapointe, Monsieur Côté, Monsieur Dussault, Monsieur Choquette, Mr. Sandou, Madame Stella, Monsieur Dionne Labelle, Madame Freeman, Mrs. Sabaïson, Madame Doré Lefebvre, Madame Quash, Madame Borg, Monsieur Nichols, Monsieur Bramy, Monsieur Blanchette, Mr. Sullivan, Madame Reynaud, Mr. Comartin, Madame Morin-Saint-Hyacinthe-Bagotte, Monsieur Jacob, Monsieur Nunez-Melo, Monsieur Pilon, Monsieur Genet, Mr. Stoffer, Monsieur Chicoine, Mr. Cleary, Monsieur Morin-Chicoutimi-Lefiard, Madame Latendresse, Madame Morin-Notre-Dame-de-Grâce-la-Chine, Mr. Benskin, Monsieur Morin-Laurentier-de-la-Belle, Mr. Atamanenko, Monsieur Trudeau, Mr. McCauley, Mr. Goodale, Mr. Leblanc-Beauséjour, Mr. Easter, Ms. Fry, Mr. Regan, Mr. Bélanger, Mr. Valeriak, Mr. Lamoureux, Mr. Dion, Ms. Grote, Ms. Bennett, Mr. Bryson, Mr. Kusner, Mr. Eiking, Mr. McCallum, Mr. Pachetti, Ms. Duncan-Etobicoke North, Ms. Murray, Mr. McGuinty, Mr. Scarpaleggia, Mr. Cotler, back to Mr. Cotler.
Mr. Cotler,
Madame Saint-Denis.
Scarpaleggia, then Madame Saint-Denis.
Mr. Sims, Bonavista, Gandergat Falls, Windsor.
Mr. Sims, Bonavista, Gandergat Falls, Windsor.
Mr. Andrews.
Mr. Andrews.
Mr. Shue.
Mr. Shue.
Mr. Casey.
Mr. Casey.
Ms. Jones.
Ms. Jones.
Monsieur Dubourg.
Mr. Dubourg.
Ms. Freeland.
Ms. Freeland.
Monsieur Plamondon.
Monsieur Plamondon.
Monsieur Fortin.
Monsieur Fortin.
Monsieur Patry.
Monsieur Patry.
Mr. Rathgaber.
Mr. Rathgaber.
Mr. Heyer.
Mr. Heyer. Yeas pour 146, 146. Nays contre 123, 123.
I declare the motion carried. It being 6:08, the House will now proceed to the consideration of private members' business as listed on today's order paper.
Private members' business, private members' bill, consideration at the second reading stage of Bill C-571, an act to amend the Meat Inspection Act and the Safe Food for Canadians Act.
Order. We're on. Is it on the orders of the day? Okay. We're on resuming debate. The honourable member for Sydney, Victoria.
Thank you, Mr. Speaker. I rise to speak to Bill C-571, an act to amend the Meat Inspection Act and the Safe Food and Canadians Act. I'll begin by stating that the Liberal Party supports this bill. I'd also like to recognize and thank all those who have written letters and share their thoughts and concerns with me surrounding this piece of legislation. I've heard from many of our American neighbours also who want to see this bill enacted. Bill C-571 amends the Meat Inspection Act and the Safe Foods for Canadian Act to ensure that any horse slaughtered for human consumption has a medical record containing all treatments over the course of its lifetime. There are serious health concerns regarding horse meat that may contain harmful substances if that horse was not raised primarily for human consumption. Horses sent to slaughter come from various backgrounds, and because the majority of them are not raised as food animals, they often receive medications that are banned from the food chain. Now, currently, record keeping for horses bred and raised in Canada or the United States is not mandatory, and the transfer of information regarding the substances of a horse received is not required when that animal is sold. This bill seeks to provide a reliable system for recording medications given to horses throughout their entire lifespan and prevent forbidden substances often found in horse meat from entering our food chain. Before we came here to vote tonight, I spoke to the member from British Columbia Southern Interior who has introduced this similar piece of legislation last year, Bill C-322, which did not have the parliamentary support needed to withstand a vote at second reading. C-322 would have prohibited the transportation, import or export of horses or horse meat for human consumption altogether. Now, what this new draft C-571 is an extension of the previous bill, which now provides for an exemption to that prohibition. Only horses raised primarily for human consumption that are occupied by a complete medical history will be transported for slaughter for meat. Now, this expansion of Bill C-322 better confirms the trade regulations and would fulfill Canada's food safety requirements. Most Canadians do not realize how much horse meat we sell all over the world. In 2013, more than 72,000 horses were slaughtered in Canada. That's nearly 1,400 killed each week. It's important to reiterate that Canada has $19 million worth of a horse meat industry, mostly for export. 85% is exported, which employs 500 Canadians. And we do not want to take any livelihoods away from the people who make a living from it. The U.S. eradication of its horse meat industry in 2007 leaves not only 2 countries in North America who use horses for slaughter, and one is Mexico and ourselves. There are only 5 processing plants across Canada. 2 are in Quebec, 2 are in Alberta, and 1 in British Columbia. While the consumption of horse meat is not very popular with Canadians, there is a growing interest in Quebec, where it is often sold in supermarkets. Horse meat is also eaten in many other countries around the world, over 15 that we export to, including France, Russia, the stands, all the stands in the Russian orbit. It goes to China, it goes to Italy. And I believe this bill achieves the necessary balance to sustain the horse meat processing sector while respecting those that chose to incorporate this type of meat into their diet. C-571 proposes that we are to continue with our industry, and we should breed horses similar to how we breed other livestock, such as cows and pigs, ensuring that these animals are not injected, because the rest of the animals in our livestock industry are not injected with chemicals that might hurt into the food chain. So these animals are not injected or fed anything that would render the meat unsafe. All the bill is saying that there needs to be some sort of assurance so that we do not endanger human health. Some argue that this is overly an emotional debate. However, it's not actually. There's a lot of evidence showing that horses not bred for slaughter carry medications that could actually harm people. In the year 2000, a couple of years ago, Belgian authorities notified the European Commission about reported presence of 2 forbidden substances in the horse meat imported from Canada. So, Mr. Speaker, the whole issue surrounding the humane treatment of horses that are sent to slaughterhouses is another issue. But it's important to address that here. Personally, horses for me, because I'm a horse owner, and but my parents were from the Netherlands and Europe, and horse meat was a staple of their diet. But sometimes it can be emotional for myself also. But it's an industry and it's very important. And I think we also have to address how we treat these animals before they're slaughtered. There has been many documented cases of cruelty and neglect in the Canadian slaughterhouses. And I think the larger issue is when these great creatures are with us, they should be treated in a humane manner, where it's not currently the case in many instances. The reality is that current transportation regulations for horses are poor, allowing for horses to be transported for up to 36 hours without food, water, or rest in confined trailers. Now, Bill C-571 will impose certain limits on horse slaughter industry that did not exist before. It's not only, of course, the main objective, of course, is to have safer horse meat that we can export around the world. This legislation will help in modernize regulations within the horse meat processing sector in terms of food safety. But it may also pave the way to adjust the transportation of these animals when they're sent to slaughter for human consumption. So, Mr. Speaker, in conclusion, as the agriculture critic, I believe this Bill C-571 is a step in the right direction. The question here today is not about should we be using horse meat or should we be disposing of horses in this way. The question today is the horse meat safe? And we got to make sure it's safe and there's not chemicals or medications in that meat when we sell it or we consume it ourselves in this country. So it is a step in the right direction in maintaining and improving the horse meat processing sector in Canada, which is still a big industry that we have here. So thank you very much, Mr. Speaker. We support this bill.
Resuming debate, the honourable member for Vancouver East.
Well, thank you very much, Mr. Speaker. And first of all, I'd like to thank my colleague from BC Southern Interior, who I've known for many years as a very great member of Parliament in this House, for bringing forward this bill. And I know that the member for BC Southern Interior is a member of Parliament who is very diligent in his work, is a member who has a long history in the agricultural industry. He at one point was our agricultural critic for many years in the NDP, and I know that the riding that he represents that has a number of agricultural producers, so it's an issue that he's very familiar with. I also know that he's a member who is very diligent in the research that he does and the issues that he brings forward to this House. So I was very interested when he first brought forward this bill, Bill C-571, an Act to amend Meat Inspection Act and Safe Food for Canadians Act, concerning the slaughter of horses for human consumption, because I know he brought forward this bill because of the research that he's done, because of the people that he's spoken to, because of the concern that he has that the status quo that we have in Canada is very unsatisfactory. Indeed, it's not safe, and is something that needs to be debated in this House and something that needs to be looked at. So I think it's very meritorious that this bill has been brought forward and that we are having the debate in this House, and in fact we will have a vote. I believe it's tomorrow. And I would like to agree with my honourable colleague who spoke just before me from the Liberal Party that for many people it is an emotional issue, and I think he articulated very well the fact that he himself is a horse owner. His family comes from a community where horse meat is eaten, and yet there are these issues that we have to sort out. And I think, Mr. Speaker, for us as parliamentarians, the primary issue is to ensure that the safety of Canadians is paramount, that that's our first priority, and that our food supply system, our food chain, is safe in this country. And in fact, we know from some of the quite shocking cases that have come forward of contamination in various plants across the country, we know that this is something that the federal government must have not only oversight, but we must have strict laws and regulations and inspections that are in place to guarantee. It's not a chance thing. It has to be a guarantee that our food supply system, our production system, our food processing, the whole, from beginning to end, is something that Canadians can rely on. And I think that our faith in that system has been shaken on a number of occasions. And so all the more reason that with this particular bill, we need to look at this issue sort of in the cold light of day and to examine whether or not the provisions that we have in Canada that supposedly do provide the protections that are needed, whether they are actually working. And I would say that reading the material that we've had sent to us from many different perspectives, certainly by the member from BC Southern Interior, but also by others, I would say that this bill is something that is needed. It is a bill that is worthy of being sent to committee for further examination. And I think we have to recognize that the system that we have in Canada in terms of horses going to slaughterhouse is not foolproof. And in fact, there are many loopholes. And so the fact that we have an industry where horses, particularly where they've been used in racing, but in other activities as well, that those animals they contain all kinds of medications and drugs that are unfit for human consumption, and that for those particular medications to be in our food chain is something that's very, very serious. So I do agree with the underlining and I think fundamental premise of the bill that it's really important, it's critical that we ensure that there's a separation of streams, that if horses are being raised primarily for the food chain, and that's accompanied by a lifetime record, such as we see in the European Union, in chronological order, with all the medical treatments, so that there's a very clear record, that's fine. So the issue here is not about whether or not there's consumption of horse meat and whether that's good or bad. That's a matter of people's choice and a consumer choice, as it is globally. The issue here is whether or not there's a separation and a prohibition to ensure, to absolutely guarantee that horses that are being conveyed to slaughter that don't have that full medical record are then being used for human consumption. And I think, Mr. Speaker, on this issue, we do have to err on the side of caution. We do have to take the precautionary principle and ensure that the measures that are in place are foolproof, they are transparent, not just random sampling, and that there are proper inspections that take place, and that these lifetime records, such as we've seen in the European Union, are something that actually are valid and can be counted on. You know, Mr. Speaker, I'm the health critic for the NDP and very proud to do work as the health critic, and I can tell you that every day when I'm speaking with constituents, with stakeholders, with organizations, the issue of food safety, the issue of labeling, of transparency, of ensuring that our food industry is working in a way that the safety of Canadians is the first item, is something that I hear about very, very frequently. And I do think that there is a lot of concern in this country about the fact that the federal government has retreated and that we don't have the kinds of inspections, for example, under the Canadian Food Inspection Agency. And in fact, we know that there are no laws or restrictions in place that exclude racehorses from entering the slaughter system. There's no law that prevents that. Now, supposedly, we have something called an equine ID document that requires that for the previous 6 months, you have to show what medications there are and so on. But that is something that has been so easy to get around. And I know that the member from BC Southern Interior, because I just talked to him a few minutes ago before the debate here tonight, that he has information from horse owners and people who have recently bought horses to show that the so-called documentation that they get, sometimes it's non-existent, and it's certainly not containing the kind of information that's required to give someone a sense of what the record has been of that particular animal's life. And so, Mr. Speaker, I am glad that we're debating this bill. I know that there are differing perspectives, But I do think it comes down to the need to make sure that there is a clear separation in terms of animals that are, or horses that are raised specifically for meat, and there should be very clear rules around that. But for other horses that are not, who have been in other activities, we have to make absolutely sure that they're not part, they do not end up being part of our food chain and our food system. So I want to thank the member from BC Southern Interior for having the courage to bring forward this private member's bill to allow us to have this debate. I do hope that members will consider the principle of the bill and on that basis agree that it should be supported to go to committee, because I'm sure there'll be all kinds of interesting witnesses who will want to come forward. There'll be questions, there'll be amendments. That's what our process is about here. That's why we have it. But at this point, we're here debating this bill in principle. And on that basis, Mr. Speaker, I do support the bill, and I congratulate the member for the work he's done in bringing forward this important issue. Thank you.
Resuming debate, the honourable member for Argenteuil-Torpino-Mirabel. Thank you, Mr. Speaker. I rise in this House today to participate in the debate on the bill presented by my friend from BC, dealing with the slaughter of horses, as is the case with my colleague from Welland, who is the agriculture critic, and as he's already said, this would essentially put an end to the slaughter of horses in Canada, because it would require that horses must be raised primarily for slaughter and have a medical record. But, Mr. Speaker, in Canada we know that we don't raise horses with the idea of slaughtering them. Most are raised for other reasons, whether it's for racing or for other recreational uses. And I have to give you some context. In the States, funding for the American Department of Agriculture for inspections was canceled. Therefore, as the industry is no longer subject to federal inspections, they're unable to export their meat. And as a result, because the horse meat that was that they were slaughtering, it was primarily for the export market, not the domestic market, and they had to close their facilities, and they had to slaughter the horses elsewhere, so the horses were transported to Canada. And since then we've seen in the United States that there are more horses that are abandoned, whereas they could have been sent to a meat packing plant. In my riding, there's one of the only meat plants in the country that slaughters horses. That's the Viande de la Petite Nation. It employs 70 persons in Saint-André-Avarin, a municipality of less than 4,000 people, so it's therefore a very important employer in the MRC de Papineau. At this plant, the treatment of horses is considered to be one of the best in North America. The slaughter is done according to government regulations. The meat is tested, examined, and consignments are identified in order to avoid problems. And if ever there is any contamination, the entire consignment is retraced and withdrawn. It's a modern system for handling animals at the plant. And in this particular plant, the Viande de la Petite Nation, it was designed by Dr. Temple Grandin of the University of Colorado State. And it was in with the objective of having the most respect for the animals to decrease their stress. All of the horses that are slaughtered at the Viande de la Petite Nation are sent to Europe. It's all for export. And even the slaughterhouse itself is not responsible for buying the horses. It's European companies who purchase them and have them slaughtered and packaged at VPN. And I'd like to emphasize as well that there are already legislative provisions concerning the health and safety within this industry. We have regulations on the transportation of horses, the ways in which they're slaughtered, the kind of medications that they're allowed to be given, and all of this comes under the CFIA. It's always possible to improve inspections, we know that, so that the horses that are sold at auction meet all of the rules and regulations of the CFIA. Now, some people are also concerned, and with reason, about the subject of phenylbutazone. And in fact, the Canadian Food Inspection Agency takes these concerns very seriously. We can see that phenylbutazone is on the list of the designated substances, and it may be banned. The evidence concerning phenylbutazone is clear, so no one is challenging that. It's a dangerous substance. In my opinion, no member should challenge the evidence in question. But in the end, what we're saying is that the rules have to be followed in order to avoid phenylbutazone being used and that meat being exported. This does represent jobs in my riding, and it's something that we've seen in the United States. They've gotten further down this path than we have, but it decreases the poor treatment of horses. And so really I have to say that in order to really well represent my constituents in Argenteuil, Papineau, Mirabel, I have to say that I disagree with my colleague from British Columbia, Southern Ontario, and therefore I will not be supporting this bill.
Reprise de débat.
Resuming debate. The Honourable Member for Abitibi-Témiscamingue. Thank you very much, Mr. Speaker. I'm pleased to be able to rise in this debate. I think that it's a bill that is worth examining, and you look at our current situation. What you have to understand, and I really want to make this clear here, is that the bill is not dealing with whether or not horses should be slaughtered in general. Personally, I support the fact that if the meat is safe, that is to say, I agree that it could be slaughtered and that it could be consumed. It wouldn't bother me at all to eat some of it. I would say happily do that if I knew it was safe. The problem here is the problem raised in my colleague's bill, and it is actually the safety of horse meat. What you have to understand is that the systems that are in place in terms of food safety, and we've seen that with the various crises we've had in the food industry, we need to take care and assure that the meat we eat is safe. I don't think anyone here would like to eat meat that might make them sick. And having said that, what we can see is that often horses that we currently are slaughtering in Canada are animals that were not raised, they weren't taken care of with the ultimate objective of slaughtering them for human consumption. We're talking about race horses that are slaughtered, and they will be given many different medications and treatments. They'll be given analgesics, and many of those products can be found in the meat of the horse and then in the food chain afterwards. So unfortunately, we're talking about certain drugs. Some are not even detectable if you do an analysis of the meat. So even if you proceed to such an analysis to see if the horse was contaminated with those kinds of products, well, you might have a horse that has a test that comes up negative because the substance in the meat isn't present in significant enough levels to be detected, but it would still be toxic to a human being consuming that. So even with conventional analyses, it could be a dangerous substance. So that's currently the problem that we're experiencing. So what my colleague is saying here concretely is that as we are awaiting to have safe food systems for horse meat, we can't continue to do nothing. We can't carry on knowing that there's this kind of meat that's consumed in Canada and is also exported, because it's really a food safety issue, and we have to look at the bill from that perspective. I think that we all understand that someone who might have a horse that raises the horse so that it might eventually be slaughtered and eaten wouldn't be given the same substances to eat as a horse that they might want to make a very highly performing animal for. And so the substances won't be found in the same way in those two different instances. When you take the issue of raising animals, generally speaking, for example, if I'm raising a herd of cattle, well, I know that in the end, they're going to wind up on somebody's plate. So I'm going to be more careful about what my animal is going to consume. I'm going to respect the rules and regulations that are in effect. There are standards that have been established both through scientific research and other areas that will determine whether or not that meat for that animal, from that animal, can be safe for human consumption and what we can do to ensure the food safety. There will be inspection standards, and people, for example, might lose their licenses or the right to raise these animals if they don't respect those standards. So there are very clear rules and regulations that are in effect when we're talking about horses. Currently, there aren't really people who raise horses primarily for human consumption here. If it's the case that someone decides to launch that kind of a production, and they have medical records for the horses, we're quite in agreement with them being able to use them in that way. We'll be confident of the food safety issue at that point in time, but unfortunately at this point in time that is not the case. Therefore, if the government is prepared, for example, to pass the bill, my colleague's bill, and afterwards put in place measures that will ensure that the horse meat in the country is safe, well, the bill that will potentially have been passed here will no longer be necessary. But in the meantime, we cannot continue to allow people to eat meat that's not safe. And very often, when we have food products that are, how can I put this, less safe, often those products, if I can put it this way, are cheaper in stores, and perhaps there are people who are particularly vulnerable who might eat that meat thinking it's safe, because most people feel that if it's sold in Canada, it must be safe. Most people think that. So they say if it's on the shelf in my grocery store, it must be safe for me to eat. Might be people who have health problems, who are more vulnerable, or families who have children to feed. They might think, well, that meat's cheaper, so I'm going to buy it and give it to my kids. But it might potentially cause them health problems, particularly if we're talking about children who are more sensitive to these kinds of substances.
So, I'd like to point out, Mr. Speaker, what you have to understand about this bill, and it's very important. This isn't a bill that's for or against slaughtering horses. It has more to do with the safety of eating horse meat. That's what's important to understand here. I think there's enough literature available to understand that as things stand, horse meat is not safe to eat, and that's why in the United States there has been litigation because it's problematic. In the United States, they've taken action, and horses that you can't even touch in the U.S. are sent to Canada to be slaughtered, and I think that makes no sense. And one of the government's priorities should be to ensure food safety, and that's why I would encourage my colleagues to vote in favor of this bill. Not just vote in favor of this bill, but I would also encourage them, particularly my conservative colleagues, if they refuse to take action, then it'll have to be up to the NDP in 2015. But I would encourage my colleagues to pass this bill and then try to come up with some solutions to ensure the safety of horse meat, and perhaps come up with a more complete bill to deal with the issue. Because, of course, with private members' bills, there's a limit to what you can do. They can't involve the spending of money from the public purse. So I would encourage the Conservative members to first pass this bill in the meantime, because we can't just do nothing. There's too great a risk to public safety. Too many people are getting very ill or even dying from eating unhealthy products. So we need to act right away to deal with the issue of the safety of horse meat for human consumption. And as I said, I'm not against the slaughter of horses. If I was offered horse meat and there was a guarantee that the meat was safe to eat, I would be quite happy to eat that meat with you, Mr. Speaker. And that's what I had to say about this bill, Mr. Speaker.
Resuming debate. À la prise de débat. Accordingly, I invite the honourable member for British Columbia Southern Interior for his 5-minute right of reply. The honourable member for British Columbia Southern Interior.
Thank you very much, Mr. Speaker. I'd like to begin by thanking all of my colleagues who will be supporting my bill, especially those that have taken time today to speak out in favour of it, and also especially the official party support from the leader of the Green Party and the health and agriculture critics of the Liberal Party. C571 is about the safety of our food supply. Parliamentary Secretary for Agriculture in his speech on March 31st said, I quote, "While this bill is being presented as such, in fact, it is not." Mr. Speaker, this is false. He also stated that this bill includes preventing horses from moving from one province to another within Canada. This is also false. Mr. Speaker, Annex E, Equine Information Document of the CFIA on page 20, clearly states that phenylbutazone is one of the long list of veterinary drugs not permitted for use in equine slaughter for food, meaning that no safe limits have been established. On page 21, there's a list of drugs permitted with a 6-month withdrawal period. Bute is not on this list. Therefore, we can conclude that the Parliamentary Secretary was incorrect in his comments regarding the Equine Information Document, and I quote, "The 6-month period exceeds the recommended withdrawal period for a number of veterinary drugs, including bute." This is more false information. Mr. Speaker, let me turn to the speech of my honourable colleague from Welland, the agriculture critic for our party. He stated that the CFIA takes concerns about bute seriously and has made sure it is not allowed. Well, a couple of years ago, the New York Times printed an expose on the problem of doping in the horse racing industry, which prompted the U.S. government to conduct a committee study. The transcript of testimonies by veterinarians, breeders, trainers, and owners of all these committee hearings were shocking to me in the revelations regarding the overuse and abuse of a wide variety of legal and illegal medications on American racetracks. The CFIA has no laws or restrictions in place excluding racehorses from entering the slaughter system. In fact, Canada's horse meat industry is deriving a significant portion of its product from racehorses, which should alarm us. It has been shown time and time again that our EID system is fraught with loopholes. In fact, the European Commission's Veterinary Office has deemed these documents to be frequently fraudulent. I received an email today from a woman who recently purchased 3 horses at a horse auction. She did not receive any information about previous owners, nor were there any EIDs accompanying the animals. She also found out that the previous owner was not required to fill out an EID, and I quote, she says, "If I were a kill buyer, this casual transaction would please me greatly. I could then obtain fresh EIDs, fill them out as I pleased, while stating with complete honesty that, to my knowledge, the horses have not been given any substance banned for human consumption." Mr. Speaker, according to Henry Svergen, former director of Natural Valley Farms in Saskatchewan, I quote, "The system as it stood when we were killing horses was in no way, shape, or form safe. In my opinion," he states, "we did not know where these horses were coming from and what might be in them or what they were treated with." Mr. Speaker, Equine Canada has upset many of its members over their lack of consultation before taking a position against C571 and issuing a lobby letter to me and my honourable colleagues. Many members of this organization are strongly opposed to horse slaughter. Furthermore, the position Equine Canada has taken seems to be based on a few misconceptions. They state in their letter, quite incorrectly, that record-keeping such as would be required by C571 does not take place for horses in other countries, whereas in fact, in the EU, Canada's main market for horse meat requires that all horses, not just slaughter horses, have a passport within 6 months of the horse's birth or by December 31st of the year of its birth. And with this passport, the horse's comprehensive lifetime medical record must be maintained. Mr. Speaker, I find it striking that by presenting arguments based on food safety science, legal accountability, renowned international equestrian Victoria McCullough and Florida State Senator Joseph Abruzzo recently effected a nearly unanimous and nonpartisan decision in the U.S. Congress to keep American slaughterhouses closed to horses. Should we not be holding ourselves to at least as accountable to food safety as the U.S. when it comes to slaughtering horses for human consumption? Should the same high standards that we require for all animals not also apply to equines? Let's get Bill C-57 to committee for the debate it deserves and that Canadians are expecting. Thank you, Mr.
Speaker. The question is as follows. Mr. Adamanenko, seconded by Ms. Duncan in Edmonton Strathcona, moved that Bill C-571, an act to amend the Meat Inspection Act and the Safe Food for Canadians Act, slaughter of equines for human consumption, be now read a second time and referred to the Standing Committee on Health.
Is it the pleasure of the House to adopt the motion? All those in favor of the motion will please say yea.
Opposed will please say nay. In my opinion, the nays have it. Pursuant to Standing Order 93, the division stands deferred until Wednesday, May 14th, that being tomorrow, 2014, immediately before the time provided for private members' business. And now, in accordance with Standing Order 38, a motion to adjourn the House is deemed to have been made and seconded at this time. Therefore, the question is that this House do now adjourn. The Honourable Member for Malpeque.
Thank you, Mr. Speaker. It's Mr. Speaker. On March 31st, I asked the Minister of Public Safety about neglecting to ensure that Canada's laws are maintained by the Canada Border Services Agency. I referred to a directive by a Director General who stated, in part, and I quote, "Export examinations, including outbound smuggling of narcotics, should not be undertaken." End of quote. Imagine, Mr. Speaker, imagine a directive from the Minister of Public Security's agency to not look for narcotics. I asked, can the Minister now come clean and explain how this directive was put out there and if he is going to maintain Canada's laws? The question I posed to the Minister on March 31st has yet to be answered, although the Minister had ample opportunity to answer that question, and I hope I see his Parliamentary Secretary. I hope she'll answer that question tonight. But, Mr. Speaker, let me go back to the quotation that is in a document on July 29, 2012. It was to the Regional Directors General from Maureen Tracy, Director General, Border Programs, and the subject was Export Program Examination Priorities. And I'll go to the quote that is really worrisome. Quote, "Given the significant role the CBSA plays in the GC export community," meaning the Government of Canada export community, "and the limited number of resources available for export examinations, other commodities, including outbound smuggling of narcotics, unless there is an intelligence lookout, should not be undertaken." End of quote. That's a directive, Mr. Speaker, to not look for narcotics, coming from an agency that the Minister is responsible for. There can be no more serious issue related to this minister's file than that of ensuring our borders are secured and that illegal narcotics are intercepted. When I asked the minister on March 27th if he accepts responsibility for this directive, which instructs CBSA officers not to take proactive action with respect to the interception of narcotics, the minister stated that he would get back to me. I repeated the question on March 31st, and on that occasion the minister again failed to respond as to whether he was aware of the instructions given, and if so, what action, if any, did he take to have that order rescinded. When asked at the Public Safety Committee on May 1st to respond to the memo circulated within CBSA, the minister again failed to respond as to whether he was familiar with the memo, had in fact approved it, and if the contents of the memo with respect to ordering CBSA officers not to take proactive initiatives related to narcotic smuggling remains in effect. On that occasion, Mr. Speaker, the minister responded by pointing to the efforts of CBSA in intercepting contraband tobacco. The memo didn't say tobacco, Mr. Speaker. The memo talked about narcotics. Does this minister know what's going on in his department? He's had 3 opportunities to respond now. I would hope tonight that the parliamentary secretary on his behalf responds directly. The memo's out there, Mr. Speaker. That memo asking not to really look for narcotics in a serious manner unless there's almost an emergency. Does it remain in effect? Is CBSA doing its job? Thank you.
The Honourable Parliamentary Secretary to the Minister of Public Safety.
Thank you, Mr. Speaker. And first of all, contrary to the suggestions of the member from Malpeque, I can assure the House and all Canadians that CBSA did not make any cuts to frontline officers. In fact, Mr. Speaker, it's quite the contrary. In fact, we have increased frontline border officers by 26% since being elected in 2006. This government, our government, has been and continues to be steadfast in its protection of Canadians and ensuring that the laws are upheld. Let's look at some of these facts. The original directive did not instruct frontline officers to stop doing their job. What it did was outline the top priorities of the agency and introduced an intelligence-led approach. Mr. Speaker, criminals do not follow rules. Border-related criminality often starts inland and requires the CBSA to work with its domestic and international law enforcement and intelligence partners to identify and interdict illicit drugs and take the necessary actions against those who seek to break the laws. As a matter of fact, the CBSA plays a key role in the National Anti-Drug Strategies Enforcement Action Plan, in partnership with the RCMP, Health Canada, and the Public Prosecution Service of Canada. The action plan increases the capacity of law enforcement agencies to proactively target organized crime involved in illicit drug production and distribution operations. CBSA is doing great work to keep our borders safe and secure, Mr. Speaker, without impacting legitimate trade and travel. The numbers speak for themselves, and let's talk about some of these numbers. Canada Border Services Agency has a proven record of intercepting illicit drugs, having made over 9,000 seizures since April 1, 2013. This is valued at nearly $300 million. This is in fact, this is even a 4% increase over the previous year. Mr. Speaker, our government will take no lessons from the Liberal Party. In fact, this is the party, the Liberal Party, who had a previous member refer to our frontline border security officers as, and I quote, a bunch of wimps. Who said that, Mr. Speaker? Derek Lee in 2006. They also had a member who said the border officers are, and I quote again, glorified bank tellers. And that was by Minister Eleanor Kaplan. So, Mr. Speaker, again, we will take no lessons from the Liberal Party on this particular issue. Thank you.
The Honourable Member for Malpeque.
Well, Mr. Speaker, now that the Parliamentary Secretary had her little rant against the Liberals who haven't been here for about 6 years, let's get to the facts. The question wasn't about cuts to frontline officers. That wasn't the question. She said they introduced an intelligence-led approach. That's fine. Nobody's arguing with that. But we have a memo on the record that she has not refuted and hasn't said whether it remains in effect or not, and that memo says this, again, and I quote, "Other commodities, including outbound smuggling of narcotics, unless there is an intelligence lookout, should not be undertaken." End of quote. Is that still the policy of CBSA? Is the minister upholding and CBSA upholding the laws of Canada or not? Does that memo remain in effect?
Parliamentary Secretary.
Mr. Speaker, again, we will not apologize for taking an intelligence-based approach to border security. CBSA carries out its responsibilities with a workforce of approximately 13,000 employees, including over 7,200 uniformed officers. CBSA provides services at approximately 1,200 points across Canada and at 39 international locations. The magnitude of modern border management is vast. Border officers cannot open every suitcase or container, and nor should they, Mr. Speaker. Appropriate application of smart risk management is key. I will, however, like to point out to the member from Malpeque an article that was highlighted today and that I read about the good work of CBSA officers. With the help of a canine used to detect drugs, officers searched a truck and found 105 packages of cocaine in the side panels, roughly weighing 123 kilos. So when we talk about a mandate to continue doing this type of work, I hardly think that this story equates to a directive to stop doing their job. The member opposite from Malpeque should stop his smear of frontline officers, should support CBSA, and work with our Conservative government to keep our borders safe and effective. Thank you, Mr. Speaker.
The honourable member for Cape Breton-Canso.
Thank you very much, Mr. Speaker, and I'm pleased this evening to rise and pose the question to the minister, who I might note it's not often in adjournment proceedings that a minister's able to stay in the House and respond to a question. I think this is an important it's an important question on an important issue on the broader issue of temporary foreign workers. So his presence here this evening, I think, is awards or should be merited. The fact that the international exchange program is part of the issue surrounding the temporary foreign workers, and we've seen how this issue has really taken off, and we've been ringing alarm bells really for 4 years on the temporary foreign workers program. We've seen a lot of the checks and balances in that program really be cast aside, starting around about 2009, when the current Minister of Public Works had identified that she was accelerating the LMO process. She was allowing businesses to pay their employees 15% less to temporary foreign workers than Canadian workers. When they made those changes, and she was quite proud of the fact that she was speeding up the access to temporary foreign workers. And we've seen how that program has really ballooned. But, Mr. Speaker, this program, the International Exchange Canada program, and it was a program that was initiated by Liberal governments in 1967, and the whole purpose of it was to allow Canadians an opportunity to go offshore, to go to other countries and learn about the culture and all that could be learned about other countries and other peoples, and allow young people, youth from other countries, to come to Canada and learn a little bit about Canada and Canadian culture. So, the intent of it, I think, was positive. The intent of it was constructive, but the intent was to be reciprocal. There was supposed to be of mutual benefit in the program for those visiting the countries that are sending visiting students and Canadians going abroad. So it was supposed to be workplace neutral. It was supposed to be a program with balance. And as I said, it was clearly identified as a reciprocal program. But what's happened is that this government, in its rush to take in temporary foreign workers, took some of the checks and balances off this program and has really opened it up. And we don't know if, in fact, we're not sure what the impact is having. We know that there are 375,000 unemployed youth in this country.
The last job figures, 27,000 more unemployed young people in Canada. And this program, Mr. Speaker, when we see the disproportionate number of young people from other countries working in Canada as opposed to Canadians working offshore, I think that Canadians deserve the opportunity to understand what is going on with this program. So I asked my question to the minister. In light of this program and what's transpired recently, where is the reciprocal aspect of this exchange program when we see 60,000 visiting youth that are here in Canada now and less than 18,000 Canadians going offshore? Could he explain to me the reciprocal aspect of that?
The Honourable Minister of Citizenship and Immigration.
Thank you, Mr. Speaker. Thanks for the opportunity to be here. Thanks to the member for Cape Breton Council for his continuing interest in this topic. And I'd first like to pay tribute to my parliamentary secretary, who is usually here at this time, answering all manners of questions far better than I will be able to tonight. But because this conversation began between the member opposite and me in question period, I'm here to carry it on. It is an important one. To answer to give the short answer to the question, the reciprocity is there. We, in principle, have opportunities up to 60,000 places for Canadian students, for young Canadians to take in the countries, the 32 countries that are part of this International Experience Canada program. And there have been times when we have achieved reciprocity or virtually reciprocity across the entire program. Those were times, to be very blunt, the member well knows this, when the economic prospects, the economic reality in those countries, the job market, was as strong there as it is in Canada. Right now, it is not so strong in those countries as it is in Canada. And there is an attraction, a disproportionately larger attraction for foreign students to come here than perhaps for Canadian students to go to some places. But we are looking at this program in a long-term perspective. And I appeal to the member opposite to think of his own party's record, starting this program in 1951, expanding it in 2003, for reasons that we all recognize are important. And let's remind ourselves the objectives of the Immigration and Refugee Protection Act: to permit Canada to pursue maximum social, cultural, and economic benefits of immigration, not just economic, social and cultural as well, to enrich and strengthen the social and cultural fabric of Canada, to reinforce minority language communities, and to promote visitors, students, temporary workers for purposes of trade, commerce, tourism, and international understanding. These are among the goals of our Act, and I would submit, Mr. Speaker, these are among the International Experience Canada program is among those components of our overall immigration program that do the most to achieve those objectives. Because these are really not temporary foreign workers. These are students, young people with an interest in Canada, often with high skills. Of those who self-identify and tell us about the employment they receive, 87% have high skills. They come on exchange. They create opportunities for Canadians to go abroad. As other economies recover, we are convinced that Canadians will seize those opportunities. And they also do perform some very important additional purposes for immigration in Canada. Let's keep in mind that 44,000 of our new permanent residents in 2013 were people who are already here as temporary foreign workers, including as members of the International Experience Canada program. They were people who proved themselves here, studied here, worked here, and chose to stay here. Secondly, Mr. Speaker, we are looking to reinforce Francophone immigration outside of Quebec in this country. This is one of the objectives that we have as a government. It's no surprise that France is the biggest player in International Experience Canada, and France is also the biggest source of Francophone immigrants outside of Canada. Over 600 in 2013 stayed as immigrants in provinces and territories outside of Quebec. Finally, there is the question of goodwill, of building trade relationships. We're being told on all sides we need to do more to ensure companies, sectors, governments have people with international experience, with international connections, to help us seize the opportunities afforded by CETA in Europe, free trade with Korea, the continuing opportunities of NAFTA, and new opportunities in Latin America. That's why we have these agreements to bring young people from precisely those countries, for the most part, to Canada in large numbers, to keep them here as immigrants, to maintain connections with them over their lifetimes for the benefit of our country and the reciprocal benefit of those countries as well.
The honourable member for Cape Breton-Canso.
Mr. Speaker, I'm sure all the members in the House here tonight recall when the minister stood the other day and tried to dismiss the issue around this particular program, saying that it's only a couple of Aussies pouring beer in Whistler. And I'm sure the members would remember as well the minister's trip to Ireland, where he was really flagging, come on over, use this program, come to Canada, and they don't need a labour market opinion to come over on this program, Mr. Speaker. So what I'm saying, when we left government, there were 30,000 visitors to Canada. There were 22,000 Canadians visiting other countries. That's fairly close. Now it's about 60,000 to 18,000 Canadians that are working offshore. In the meantime, since the recession started, we've lost 250,000 jobs for young people in this country. So my question to the minister, with all due respect, is it not time to take some time, review this program, and try to build back in some semblance of reciprocity, some sense of marketplace neutrality?
The Honourable Minister of Citizenship and Immigration.
Thank you, Mr. Speaker. We will continue to review this program as we review all of our immigration programs. We will continue to encourage and in some cases oblige our partners to do more publicity here in Canada in front of the audience that is Canadian youth, to tell them about the opportunities that exist in Asia, in Europe, and Latin America for Canadians, because those opportunities are there, and sometimes they go unseized because of a lack of understanding and a lack of knowledge. But let's be very clear why so many foreign students are coming here under this program, and relatively fewer Canadians are going abroad for now. We think many more will go over the long term. It's because youth unemployment in this country, Mr. Speaker, is 1% lower than it was when the Liberals left office. Moreover, that is even after the worst global recession, global crisis in our lifetimes. Youth unemployment is much higher in many of our partner countries, certainly in Europe, certainly in the United States, than it is here. That's an advantage for Canada. We're not going to apologize for the relative success of the Canadian economy, but we are doing everything in our power through Canada Jobs Grant, through apprenticeships, through our planning for an immigration program that is on target to ensure young Canadians get first crack at today's opportunities and help us to build the sectors and the exciting regional opportunities of the future that are happening across this country.
The motion to adjourn the House is now deemed to have been adopted. Accordingly, this House stands adjourned until tomorrow at 2 p.m., pursuant to Standing Order 24-1.